Constitution Amendment Bill, d'après ce explanatory memorandum qui fait circuler dans le Parlement, l'objectif de ce projet de loi-là, c'est pour amender la Constitution pour accorder un pouvoir et une responsabilité additionnelle à la Electoral Commission, qui nous appelle Commission électorale, et au commissaire électoral dans une matière qui concerne le financement politique. Political Financing Bill, d'après ce explanatory memorandum qui fait circuler dans le Parlement, ce projet de loi-là pour garantir la transparence et la responsabilité dans le financement d'un parti politique afin qu'il empêche la corruption et qu'en même temps promouvoir une concurrence ou une compétition juste et équitable. Il interdit une donation politique à un parti qui n'est pas enregistré ou un individu qui n'est pas affilié à un parti qui est enregistré. C'est pourquoi Representation of People Act peut bien être modifié comme suit. Pour imposer une limite sur une dépense électorale, que ce soit pour un parti ou alliance, qui peut avoir une obligation légale pour déclarer une dépense. Pour avoir une augmentation dans les dépenses électorales qui un candidat gagne droit à faire dans l'élection à l'Assemblée nationale, élection régionale Rodrigue ou élection municipale et villageoise. Pour régulariser un quartier général politique temporaire qui met en place dans l'élection, qui nous appelle aussi base. Water Resources Bill. D'après ce explanatory memorandum qui fait circuler dans le Parlement, le principal objectif de ce projet de loi-là, c'est pour établir un cadre juridique complet pour l'utilisation, gestion, contrôle, protection, conservation et développement durable des ressources de l'eau dans Maurice. Sauvegarde l'intérêt public dans les médias et à long terme pour un accès équitable à de l'eau. Garantir sécurité et résilience de l'eau. Établir une Water Resources Commission. Encourage utilisation efficace de l'eau. Prend disposition pour et en relation avec les affaires connectées et par rapport à ce sujet-là.
announcements.
Honourable members, I have to inform the House that Mr. Niteshan Tailame has joined the clerk's table as clerk assistant. Mr. Tailame joined the civil service as management support officer in August 2014. He was subsequently appointed as court officer at the judiciary in October 2017 and court usher in January 2019. Prior to joining the National Assembly, he held the post of analyst at the Ministry of Finance, Economic Planning and Development. He holds a bachelor's degree in law and management from the University of Mauritius, a Master of Business Administration from the Open University of Mauritius, a Master of Laws in Financial and Commercial Law from the University of Central Lancashire. On behalf of the House and in my own name, I extend a warm welcome to Mr. Niteshan Tailame and wish him a successful professional career. I now invite Mr. Niteshan Tailame to join the table. Honourable members, I have another statement. I have taken cognizance of a press article entitled La sanction contre Rajesh Bhagwan considérée comme injustifiée, which appeared in the Express of today. In the said article, referring to the suspension of Honourable Bhagwan, the Honourable Shakil Mohammed is reported to have stated that I have given a wrong interpretation of standing orders. I wish to set records straight. Honourable members, the House will recall that at the sitting of 5th July 2024, I made an announcement in regard to the intervention of Honourable Bhagwan during a press conference whereby he uttered undignified words to my address. I accordingly requested the Honourable Bhagwan to present his unreserved apologies to the House, failing which I will be left with no other alternative than to ask him to withdraw from the chamber. The Honourable Bhagwan, instead of presenting his apologies, replied the following: I call a spade, and I won't withdraw. It is a fact, ou un agent politique, to un agent politique. In the light of the reaction of the Honourable Member, and considering that this amounted to a grossly disorderly conduct and to disregarding the authority of the Chair, I took the decision to name him under Standing Order 49-4, and there was no need to proceed under the National Assembly Privileges, Immunities and Powers Act, as grossly disorderly conduct occurred in the House itself. I further wish to inform the House that any member who is aggrieved by the decision of the Speaker may challenge same by way of a substantive motion. Therefore, the remarks made by the Honourable Shakil Mohammed in today's article in Express are not justified. Would the clerk continue with it?
Yes. Questions?
Mr. Speaker, I've given notice of the following private notice question to ask the Honourable Minister of Environment, Solid Waste Management and Climate Change whether in regard to the protection of the environment, he will state the measures he proposes to take following the judgment delivered by the Privy Council in the matter of EcoSud and two other respondents versus the Minister of Environment, Solid Waste and Climate Change and another appellants, Mauritius, on the 4th July 2024.
Mr. Speaker, sir, members will recall that during the summing up of the debate on the Environment Act 2024 at Parliament session of the 14th of May 2024, I informed the House that a judgment from the board of the Judicial Committee of the Privy Council was being awaited on this particular case with a view to provide clarification on interpretation of the law regarding the right of appeal by a person to challenge decisions on issuance of an EIE license. The Ministry has never objected to any NGO or aggrieved party to appeal against the decision of the Ministry before the Environment and Land Use Appeal Tribunal. For the benefit of the House, allow me to recall the chronology of events around this issue. On the 23rd of November 2017, my ministry received an application for an Environment Impact Assessment license from Point Destiny Landslide Company Limited for an integrated residential development under the Property Development Scheme on a freehold land of an extent of 709,648.26 meters square at Point Destiny, Beauvallon. The proposed development comprises the construction of the following principal components: 172 villas, 278 apartments and penthouses, 100 duplexes, and 105 service lots with educational, sport, leisure, and commercial facilities. On the 31st of January 2019, an EIE license was issued to the proponent, which was subject to a set of 48 conditions. Allow me here to emphasize that Section 24(3) of the EPA of 2002 provides, I quote, "Notwithstanding the approval of an EIA, the Minister may at any time revoke an EIA license or amend the conditions of an EIA license where he has reason to believe that circumstances reasonably justifying such revocation or amendment of the condition have arisen since the granting of the EIA. The proponent is contravening the conditions attached to his license. Proponent had failed to disclose any material information or had provided false or misleading information in the EIA report." On the 28th of February 2019, EcoSud appealed at the Environment and Land Use Appeal Tribunal against the decision to grant the EIA license to the proponent. The main ground of appeal was that, according to an expert's report issued by the Center for Wetland Research and Training, there were peatlands, that is, terrestrial wetlands, in the proximity of the development site, which have not been identified in the EIA report. Accordingly, the appellant moved that the EIA license be revoked. In August 2021, a preliminary objection was raised by the State Council representing the Minister of Environment, Solid Waste Management and Climate Change, and the same ministry that EcoSud lacked standing under Section 54(2) of the EPA 2002 to lodge the appeal. On the 6th of October 2021, the Environment and Land Use Appeal Tribunal upheld the preliminary objection raised and set aside the appeal by EcoSud on the grounds that the appellant failed to show that it was an aggrieved party and how it suffered undue prejudice from the proposed development. On the 26th of October 2021, EcoSud appealed against the ruling of the ELWAT at the Supreme Court. On the 18th of July 2023, the Supreme Court quashed the ruling of the ELWAT on the basis that the latter had given an unduly interpretation of Section 54(2) of the EPA of 2002 as to who can appeal against the decision of the Minister to grant an EIA license before the ELWAT. In fact, the Supreme Court adopted a more liberal interpretation based on jurisprudence of the British Supreme Court. Consequently, organizations such as NGOs, which allegedly had expertise and sufficient knowledge of the subject matter in which it seeks to protect, may appeal against the decision of the Minister to issue an EIA license. The case has been remitted back to the tribunal for it to decide whether EcoSud had sufficient standing under the Act in the light of the principles laid down in its judgment. On the 3rd of August 2023, further to advice of the Attorney General's Office, the Minister and the Ministry of Environment, Solid Waste Management and Climate Change appealed to the Judicial Committee of the Privy Council pursuant to Section 81 of the Constitution of the Republic of Mauritius, and a special leave was granted by the Judicial Committee of the Privy Council. Mr. Speaker, sir, after hearing the case on the 5th of May 2024, the Board of the Judicial Committee of the Privy Council delivered its judgment on the 4th of July 2024 In essence, the board dismissed the appeal of the minister and the Ministry of Environment, Solid Waste Management on inter alia a number of grounds. First, the Environment and Land Use Appeal Tribunal incorrectly required EcoSud to prove prejudice to its private interests in order to establish standing under Section 54(2)(b) of the Environment Protection Act of 2002. Second, a test of property rights or of economic interest is not appropriate in an environmental context when considering standing under Section 54(2)(b) of the EPA of 2002. The board held that in the environmental context, prejudice in the sense of harm can be applied to an interest in the environment, as well as prejudice to either an economic interest or to a private interest. Third, for that case in hand, the board recognized EcoSud as an aggrieved party possessing sufficient standing given it has shown genuine concern and interest in the environmental aspects that it seeks to protect, and EcoSud has showed it possessed sufficient knowledge of the subject matter at hand, albeit no individual property right or interest has been affected. The board observes that EcoSud has expertise and experience with regard to matters pertaining to wetlands and the region of Point Destiny, and this is backed by an expert's report. Fourth, if prejudice is confined to economic prejudice and prejudice to a private interest, such a narrow interpretation would defeat the larger purpose of the Environment Protection Act of 2002 of protecting the environment, particularly in situations where a proposed development would take place in a private, remote area, which is less likely to impact on an individual's personal interests. Fifth, in relation to the merits of the appeal, the substantive objections raised by EcoSud are not trivial, frivolous, or vexatious. Rather, the merits are backed by EcoSud's own considerable expertise and the expert's report. More so, ELWAT did not consider the merits of the claim, including the importance of the issue raised or its consequences. The standing requirement in Section 54(2)(a) should not therefore be used to filter out arguable environmental issues. Furthermore, ordinarily, a hearing on the question of standing should not descend into a protracted preliminary hearing. Last, the National Ramsar Committee's clearance to the development was subject to a condition that the Environment and Sustainable Development Division of the Ministry be requested to undertake an environmental impact assessment on the project. Accordingly, the National Ramsar Committee considered that EcoSud's objection had sufficient merit to require not only an EIA by the proponent, but also an EIA by the Ministry. I wish to point out that it is not for the Ministry to undertake an environment impact assessment of the project, but the proponent himself. This has been the position of the Ministry before the ELWAT. Moreover, given that the EIA assessment process is multidisciplinary by its nature, the different aspects relating to environment have been duly assessed during the EIA process by various concerned competent ministries. Mr. Speaker, sir, based on those arguments, the board of the Judicial Committee of the Privy Council held that the Supreme Court quash the ruling of the Environment and Land Use Appeal Tribunal and ordered that the matter be remitted back to the ELWAT for it to decide whether EcoSud had sufficient standing in the light of the principles laid down in its judgment. Mr. Speaker, sir, further to the judgment delivered, I wish to highlight the following. First, this judgment has brought further clarity on what defines an aggrieved party under Section 54(2) of the EPA of 2002, to the effect that an NGO which is able to demonstrate sufficient undue prejudice may challenge the decision to grant an EIA license, although no private or economic interest has been affected. Second, it is important to recall that amendments were brought to Section 54(2) of the EPA Act of 2002 through the Environment and Land Use Appeal Tribunal Act of 2012 to introduce standing requirements to prevent arguably busybodies, that is, persons unduly interfering and unconnected with the project, from abusing the appeal process, thereby causing considerable delay in projects. The judgment relates to the interpretation to be given as to who is an aggrieved person under Section 54.2 of the EPA of 2002 in respect of an NGO and would not have any impact on this policy of preventing such busybodies to make frivolous appeals against EI licenses granted to legitimate undertakings that have successfully gone through proper environmental impact assessments. What this verdict of the Judicial Committee of the Privy Council gives is clarity on how NGOs who have no private or economic interest which will be impacted by a project may be able to demonstrate sufficient prejudice to be able to challenge the project by proving that they have a genuine interest in aspects of the environment that they seek to protect, and sufficient knowledge of the subject will be able to show that a decision to approve the issue of an EI license is likely to cause them undue prejudice in relation to their interest in that aspect of the environment. Third, the judgment highlighted environmental stewardship as one of the strengths of the EPA 2002, which urges every citizen to use his best endeavors to preserve and enhance the quality of life by caring responsibly for the natural environment of Mauritius. I wish to point out to members of the House that environmental stewardship has been maintained in the new Environment Act of 2024 and is a vibrant proof of government's intent to pursue inclusive, good environmental governance. Fourth, as opposed to claims being relayed in the press, the judgment of the Judicial Committee of the Privy Council is in relation to the EPA of 2002, as amended. The Environment Act of 2024 is new, and its provisions have not yet been tested before a court of law. Accordingly, it would be presumptuous to state that the Environment Act of 2024 is undermined in any way. Rather, as previously mentioned, this judgment has brought clarity on interpretation of specific terms in a provision of the EPA 2002 as amended. Fifth, I wish to highlight that the Environment Act of 2024 has already provided for a host of other measures to even further improve environmental governance in the Republic of Mauritius, and which will come into force as from the 1st of August 2024. First, we have the reintroduction of a strategic environmental assessment, whereby government will lead by example by exposing several of its own key sectoral public policies and programs to evaluation of the environmental impacts is an illustration of this. A strategic environmental assessment aims at supporting proactive consideration of environmental and sustainable development objectives at the outset of plans and programs in various sectors such as agriculture, ESAs, fisheries, energy, industry, transport, waste management, town and country planning, developments above 20 hectares, port development, as well as multiple undertakings. A strategic environmental assessment will ensure that environmental considerations are integrated into plans and programs right from the planning stage, and will provide a wider perspective by ensuring that socio-economic issues are treated at par with environmental protection and sustainability. Furthermore, we are also expecting that SEA will be instrumental in the early consideration of potential impacts, precautionary and preventive action principles, including cumulative and synergistic impacts that are often difficult to identify at low tiers and project level. We have also the assessment. Proponents would now be required to apply for a completion certificate prior to operating any undertaking in line with Section 52 of the Environment Act 2024. Moreover, the new Act also provides for enforcing agencies to submit monitoring reports on a quarterly basis. This aims to ensure close monitoring by authorities and regular monitoring thereof. It is to be stressed that, as was the case in the EPA of 2002, the Environment Act of 2024 also provides for the Director of Environment to be able to extend the time limit to submit public comments to afford reasonable opportunity for any person to submit comments on a preliminary environment report, environment impact assessment, strategic environmental assessment as and when required. Mr. Speaker, sir, allow me to point out that funding has been appropriated in the last budgetary exercise for the ground-proofing and finalization of the environmentally sensitive areas, mapping of the following ESAs: coastal marshlands, upland marshlands, mangroves, as well as formulation of policy recommendations with regard to St. John's. Moreover, under the UNDP Global Environment Facility and Government Project on Sustainable Land Management, the draft Environmentally Sensitive Areas Bill of 2009 is being reviewed, and a legal expert has been hired to that end. A revised draft is expected to be formulated by December 2024. Last, it is to be also pointed out that the environment sector is one characterized by its dynamic nature. Hence, new issues or challenges may and will call for frequent reviews and possible legislative amendments. That approach will continue. Thank you.
Can I ask the Minister whether he'll inform us if the National Ramsar Committee is chaired by the Permanent Secretary of the Minister of Agro-Industry? Yes. Now, and he made the request for an EIA to be carried out, and that was set aside. Why is it then that the advice was not sought from the Ramsar Advisory Commission? Knowing perfectly well that there's encroachment upon the wetlands.
Mr. Speaker, sir, as I mentioned in my main reply, I pointed out that it is not for the ministry to undertake an environment impact assessment of the project, but the proponent himself. This has been the position of the ministry before the ELOAT. Moreover, given that the EIA assessment process is multidisciplinary by its nature, the different aspects relating to environment have been duly assessed during the EIA process by various concerned competent authorities.
Does the minister realize that in taking the lead in the appeal proceedings, he's in a way substituted himself for the promoter whose direct interests were involved?
Mr. Speaker, sir, as I said earlier, we welcome the decision of the Privy Council, as the Privy Council has given a wider interpretation of local standi in such matters. Had we not appealed on this matter, we would not have had the benefit of having such a broader interpretation of local standi.
Broader interpretation doesn't mean that government has to side with the promoter. Does the minister realize that in siding with the promoter during the appellate proceedings, both before the Supreme Court and the Privy Council, he was opting for the destruction of pristine environment by the promoter rather than preservation by Ecocide?
Monsieur le Président, je pense que j'ai été très clair dans ma réponse. Donc, je ne vais surtout pas répéter la réponse que j'ai donnée. Le EIA license il y a eu l'application du EIA license le 23 novembre 2017. Le 31 janvier 2019, le EIA license was issued to the proponent. 31 janvier 2019 was issued to the proponent, which was subject to a set of 48 conditions. Et j'ai mentionné aussi que le 23 février 2019, l'Ecosud a fait l'appel à the Environment and Land Use Appeal Tribunal. Ensuite, il y a eu le cas devant la Cour suprême, etc. Monsieur le Président, je pense que l'honorable leader de l'opposition doit quand même se rappeler. Il a été lui-même membre et aussi ministre dans le passé d'un gouvernement qui a tout, et dans le gouvernement mauricien, dans le principe démocratique à Maurice, il a toujours existé le principe de la permanence de l'État, et ce, quel que soit le gouvernement ou le ministre qui se succède. Et là, je l'ai mentionné dans ma réponse, que toute la procédure a été suivie. Ce n'est pas une question qui a délivré le PMI, qui est le ministre qui a délivré le PMI, etc. En tant que ministre de l'Environnement, j'assume pleinement ma responsabilité, bien, tout comme le ministère de l'Environnement fait partie du gouvernement, nous assumons pleinement notre responsabilité. Mais permettez-moi aussi de rappeler au leader de l'opposition. Hein. Je pense que le leader de l'opposition doit aussi se rappeler que... Laissez-moi terminer, Monsieur le Président. Laissez-moi rappeler au leader de l'opposition, c'était bien en 2012, lorsque lui-même faisait partie du gouvernement, il y a eu l'amendement de l'Environment and Land Use Appeal Tribunal, où, Monsieur le Président, dans le Environment Protection Act de 2002, où, à la section 54, c'est mentionné « Jurisdiction of the Tribunal. A tribunal shall hear and determine appeals against a decision of the minister », où c'est dit que, à la section 2, any person, je dis bien, any person may appeal within 30 days of the decision, etc., etc. Ensuite, il y a eu l'amendement de 2012. L'amendement de 2012, précisément, où c'est mentionné, noir sur blanc, that the minister had decided to issue an EIA license, any person who is aggrieved by the decision. Aggrieved by the decision and is able to show that the decision is likely to cause him undue prejudice may appeal against the decision of the tribunal. Donc, Monsieur le Président, ce n'est pas une question de venir dire que la faute impute à tel ou tel gouvernement, etc. Il y a eu des décisions successives qui ont été prises par le Parlement successivement, par plusieurs gouvernements. Nous nous retrouvons dans un cas de figure d'interprétation de la loi. Et moi, personnellement, en tant que ministre de l'Environnement, je suis très heureux que le Private Council a pu se prononcer sur cette question de local standby. Et moi, je suis très content que nous avons eu cet avis du Private Council, Monsieur le Président.
Yeah, but I can't understand why is that the minister has not allowed the promoter to fight its own case before the Privy Council. Why is it that the minister had to side with the promoter, and in doing so, his minister has been complicit in undermining the procedural safeguard of an appeal to the tribunal by allowing the promoter to proceed with the development as this amounts to a failure to care responsibly for the environment.
Monsieur le Président, il n'est pas normal de dire qu'on est en train de permettre à tel ou tel développement, etc. Mais je dois quand même dire que c'est vrai que le judgment Judicial Committee of the Private Council mention on works ongoing on the site, mais we take note of remarks need consideration. As far as we are aware, there has not been any formal request of a stay order by ECOSUD before the Supreme Court or before ELOAT. Et je dois dire aussi que le ministère de l'Environnement, the proponent submitted an EMP for approval on the 14th of December 2021. In view of the ongoing court case, the advice of the Attorney General's Office was sought on the 7th of July 2021, whether the EMP can be processed, and the Attorney General's Office informed the 27th of July 2021, provided that there has been no application for a stay of the implementation of the project made by an interested party before either the Environmental Land Use Tribunal or the Supreme Court, there would not be no legal impediment to proceed with the implementation of the proposed development. Donc, Monsieur le Président, nous ne sommes pas en train de travailler en isolation, mais bien sûr en conformité et aussi en consultation avec toutes les autorités concernées.
Because this is shocking in light of what the minister has said. The case has been heard before the Supreme Court, was pending before the Privy Council, and would eventually be sent back, as he said, to the Environment and Land Use Appeal Tribunal. How could the minister still allow the promoter to proceed with the development? Don't you have some respect, at least for the Supreme Court and the Privy Council, in the light of the judgment pronounced?
Monsieur le Président, je ne vais surtout pas répéter la même réponse que je viens de donner. Je pense que j'ai été très clair dans ma réponse, Monsieur le Président.
I've stated very clearly that action has to be taken, call it stay order. In the meantime, the promoter is carrying on with its work. Why is it that the promoter is allowed to carry on with the work? This goes against what the Privy Council and the Supreme Court has stated. There should be stay of action till the case is referred to the Environment Land Use Appeal Tribunal.
Monsieur le Président, je pense que dans le jugement du Judicial Committee of the Privy Council, cela est clair, que le Judicial Committee of the Privy Council a pris note du fait que le promoteur est en train de continuer son projet. Monsieur le Président, c'est clair dans le jugement que l'affaire sera référée au Environment and Land Use Appeal Tribunal, où l'ONG EcoSud aura l'occasion de venir prouver ses points, défendre ses points, etc. Ce n'est pas à mon niveau de venir préempter, de venir prédire quelle sera la décision du Environment and Land Use Appeal Tribunal. Je pense qu'il faut laisser les différentes instances du pays fonctionner et à la lumière de la décision de l'Environment and Land Use Appeal Tribunal, le ministère sera appelé à prendre toute décision qui s'impose.
Do we have a Minister of Environment, or the Ministry and the government the promoter? You have wasted more than 5 million rupees of taxpayers' money in an appeal, which, had you won, would have restricted the citizens' right to protect the environment. Can you inform the House who advised you to appeal against the decision of the Supreme Court, and what was the reasoning which convinced you to do so?
Monsieur le Président, je pense que je vais surtout pas répéter la question qui a été dite. Pour nous, c'était important pour nous d'avoir une bonne définition en ce qui concerne cette question de locus standi. On a eu la décision du Privy Council, bien sûr, nous serons toujours guided par la décision du Judicial Committee of the Privy Council. Et bien sûr, l'affaire sera référée au Environment and Land Use Appeal Tribunal. Moi, je pense qu'il va falloir qu'on puisse respecter toute décision qui va être prise par le Environment and Land Use Appeal Tribunal.
Order there.
Has the Minister made an assessment of the total costs implied? Total costs that have to be paid to all parties since our government has lost the case.
Non. Monsieur le Président, la question de cost n'a pas été soulevée jusqu'à présent. Donc, non, nous ne sommes pas en présence d'aucune indication de ce cas précis, Monsieur le Président.
And to reason that facts are damning, and the ministry has favored the promoter and has not respected the decision.
Honorable Boulel, put your questions directly without any observation, any remarks. Question.
Is the minister aware that in doing so, and by not implementing what the Privy Council has stated, that Mauritius may be considered as a rogue state by allowing those who have flouted the law to get away with murder?
Let the minister.
Monsieur le Président, cette question de faire appel au Privy Council, c'est une pratique courante dans le pays, Monsieur le Président. As I said earlier, we welcome the decision of the Privy Council, as the Privy Council has given a wider interpretation of locus standi. In such matters, had we not appealed on this matter, we would not have had the benefit of having such broader interpretation. Monsieur le Président, ce n'est pas la première fois que l'État fait appel au Privy Council. Il s'agit d'une pratique courante qui nous permet de faire appel à la plus haute instance juridique du pays, qui est le Privy Council. Dans ce cas précis, cela nous a permis d'avoir une conclusion constructive. Toutefois, il est bon de rafraîchir la mémoire du leader de l'opposition. Dans le passé, dans le cas Med Point, la Cour suprême avait donné gain de cause à Pravin Kumar Jagnat, l'honorable Pravin Kumar Jagnat, mais le DPP d'alors avait néanmoins fait appel contre le jugement de la Cour suprême aux frais de l'État, aux frais des contribuables, Monsieur le Président. Le Privy Council faut bien le rappeler, a confirmé le jugement de la Cour suprême et donné gain de cause à l'honorable Pravin Kumar Jagnat. Il faut aussi ne pas oublier que la pétition électorale de Suren Dayal, contestant les résultats des élections de la circonscription numéro 8, la Cour suprême avait confirmé qu'il n'y avait aucune maldonne dans le processus électoral. Mais M. Dayal a fait appel au Privy Council avec la bénédiction de son leader, mais nous savons tous que le Privy Council avait confirmé que ces élections se sont déroulées d'une façon free and fair. Ce que je veux souligner, Monsieur le Président, c'est que dans ce cas également, plusieurs instances gouvernementales, notamment l'Electoral Supervisory Commission, l'Electoral Commissioner, ont dû débourser des frais pour restaurer leur image que certains ont voulu tenir. Monsieur le Président, mais il faut bien que l'honorable puisse savoir cela, Monsieur le Président.
Order. Time over. Prime Minister's question time. The House is informed that PQB 552. Order. Both sides of the House. Order. Your time is finished. Your time is finished. Okay. No. Both sides of the House. I said. At all times I said. PQB 552 have been withdrawn, so I call Honorable David.
B553.
Mr. Speaker, sir, I wish to refer the honourable member to my reply to parliamentary questions B/989 and B1/1001 on 11th of July 2023 on the revamping of the Mauritius National Identity Card project, and parliamentary question B/1442 on 14th of November 2023 on the use of the new digital identity card in the next general elections. Since the parliamentary question regarding the use of the new digital identity card, which I am informed is the same as the new mobile identity card, has been put again, I will seize this opportunity to provide additional information regarding the mobile identity card and at the same time address the implications regarding the use of the mobile identity card during National Assembly elections. Mr. Speaker, sir, the Mauritius National Identity Card scheme was introduced and implemented in Mauritius in 2013 under a government-to-government agreement between the Republic of Singapore and the Republic of Mauritius. The honourable member would recall that in my reply, I also informed the House that following the private notice question of the then leader of the opposition, Honourable Paul Raymond Béranger, at the sitting of 30th of October 2012, the then Minister of Information and Communication Technology informed the House that in 2009, the State Informatics Limited launched a request for proposal for a new Mauritius National Identity Card project to 7 shortlisted suppliers in accordance with Section 3(1) of the Public Procurement Act, which provides that procurement is to be undertaken by the most competitive method of procurement available in all circumstances. In response to that tender exercise, 3 out of the 7 shortlisted bidders submitted proposals, and the Bid Evaluation Committee recommended that award be made to SAGEM for a value of 7.2 million euros, amounting to approximately 317 million rupees at that time. However, after the visits of the then Prime Minister to Singapore in September and subsequently in December 2010, he gave instruction to cancel the bidding exercise for unknown reasons and to enter into a G2G agreement with Singapore through the Singapore Corporation Enterprise in partnership with Crimson Logic Private Limited for the provision in the first instance of consultancy services for the sum of 10,916,204 rupees. Thereafter, on 17th of October 2012, an agreement for implementation of a new national identity card system was signed between the government of Mauritius and the Singapore Corporation Enterprise for a sum of 1,111,256,305 rupees as capital cost. So we come from 317 million rupees to 1,111,256,305 rupees. So it is worth noting that the contract signed between the parties contained a non-disclosure clause. Mr. Speaker, sir, following the advice received from the Ministry of Information Technology, Communication and Innovation, that the hardware and software of the former system had reached their end of support and end of life, my government decided in March 2020 to revamp the previous system. Hence, following a bidding exercise launched on 12th of April 2022, the contract for the supply, implementation, operations, and maintenance of a turnkey solution for the National Smart Card-based identity system and a smart app-based mobile ID solution was awarded to the consortium Thales Arel Malak Technologies. The contract was signed on 15th of February 2023 with an implementation period of 1 year for a capital cost of approximately 374 million rupees as compared to the more than 1.1 billion rupees which was incurred in 2013 as capital cost. As such, the new Mauritius National Identity Card System, which was launched on Friday, 23rd of February this year, is aligned with international trends and provides several new facilities. Mr. Speaker, sir, so far the physical version of the Mauritius National Identity Card 3.0 has been introduced. The mobile ID, which is part of the system, will be launched shortly after the final required technical verifications have been completed and the necessary process from Google Play Store and Apple App Store for the publishing of the mobile ID applications are completed. The National Identity Card Unit of my office is working in close collaboration with the Central Informatics Bureau of the Ministry of Information Technology, Communication and Innovation and the consortium Thales Arel Malak Technologies Limited to finalize the coming into operation of the mobile ID. I am informed that same will be stored securely in the digital wallet on a smart device. The digital wallet is a secured application which can be downloaded on a smart mobile device and is used to store digital documents. The introduction of the digital wallet and the mobile ID will complement the advancements in identity card technology, reflecting global trends in mobile-based identity solutions and digital transformation initiatives. Thus, with the implementation of the mobile ID, Mauritius will become the first country on the African continent to bring in a fully interoperable digital ID wallet based on international ISO standards. Similar digital wallets are already deployed in Australia and the United States of America and will soon be introduced in Europe. It is worth noting that our country will embrace this digital wallet app to hold an electronic version of their identity card, that is the mobile ID, even before the European Union, since these ISO-compliant electronic deployments will only start in the EU countries as from 2026 as part of new EU regulations. Thus, the mobile ID, which is the electronic version of the physical ID card, will soon be available on the citizens' mobile devices, enhancing accessibility, security, and usability, and will be one of the digital documents to be stored on the digital wallet. The mobile ID contains the same information found on a physical ID document, but with state-of-the-art security features available through digital technology. In view of the prevalence of smart devices in Mauritius, citizens will be able to use their mobile ID in lieu of their physical ID as a proof of identity. Furthermore, a mobile verifier app would be available free of charge to any citizen or organization to verify the genuineness of the mobile ID. The mobile ID will provide a convenient and secure technology for citizens within an infrastructure which will ensure security, privacy, and integrity of data from enrollment to the in-field verification process. It will also contain several facilities, such as the option of reporting change of address or loss of identity cards. Moreover, it will include digital signing of electronic documents, amongst others. In this context, the National Identity Card Act was amended through the Finance Miscellaneous Provisions Act 2023 to ensure that both the physical identity card and the mobile ID operate within a legal framework. The amended Act provides that the new identity card system shall have the necessary features to ensure the security and confidentiality of information contained therein, and to give the same legal standing to the physical identity card and the mobile ID as proof of identity. Provision was also made in the Act that any citizen registering for a mobile ID shall already be holder of a physical national identity card. Mr. Speaker, sir, moreover, the National Identity Card Regulations of 2024 have been promulgated to regulate the layout of the new ID card and new features such as the option to have digital certificates. In the same vein, the National Identity Card Mobile ID Regulations 2024 were introduced to, inter alia, regulate the use of the mobile ID. Also, a new set of regulations is being prepared by the Attorney General's Office in consultation with the National Identity Card Unit and the Ministry of Information Technology, Communication and Innovation pertaining to card reading. I am further informed that the digital wallet application, which will store the mobile ID in the first instance, will be able to accommodate other digital documents, such as the birth certificate and the marriage certificate. Discussions are ongoing between my office, the Ministry of Information Technology, Communication and Innovation, and other stakeholders to explore the possibility of storing other documents in the digital wallet. The digital wallet is protected by the existing security features on the smartphone of the citizen. Furthermore, the consent of the citizen is needed to access his or her mobile ID. Therefore, the digital wallet will be managed by the citizen himself or herself. Mr. Speaker, sir, as regards parts A and B of the question, I have already stated in my reply to Parliamentary question B/1442 on 14th of November 2023 regarding the use of the new digital identity card in the next general elections that the Electoral Commissioner has a well-established and regulated procedure already in place for the authentication of voters at the time of voting. Given that this question is coming again, let me remind the Honourable Member that pursuant to Section 41 of the Constitution, the constitutional powers to organize elections rest in the Electoral Supervisory Commission. Section 41(1) of the Constitution provides that, and I quote, "The Electoral Supervisory Commission shall have general responsibility for and shall supervise the registration of electors for the election of members of the Assembly and the conduct of elections of such members, and the Commission shall have such powers and other functions relating to such registration and such elections as may be prescribed," unquote. Moreover, Regulation 27 of the National Assembly Elections Regulations of 2014 provides that, and I quote, subsection 1, "Every elector desiring to record his vote shall present himself to the presiding officer in the appropriate voting room at the polling station at which he is entitled to vote, state his name, and produce his national identity card or any other acceptable proof of his identity." Subsection 2, "The presiding officer, after satisfying himself that the name of the elector appears on the copy of the part of the register containing the names of electors entitled to vote in that voting room, shall, subject to Regulation 29, deliver a ballot paper to the elector," unquote. Mr. Speaker, sir, as already stated earlier in my reply to Parliamentary question B/1442 on 14th of November 2023, there is a well-established process for authentication of the voter on the voting day, which is as follows. In order to cast his vote, a voter has to produce his national identity card or passport as acceptable proof of his identity to the presiding officer in the voting room at the polling station where he is entitled to vote. Before issuing a ballot paper to the voter, the presiding officer verifies the ID number and the name of the voter in the presiding officer's copy of Register of Electors. The presiding officer's copy of register contains the surname and other names, NID, address, gender of the elector, and as well the elector's number. And verification if the photo appearing on the national identity card or passport of the voter corresponds with the voter. This physical verification of the national identity card or passport is made to ensure the identity of the voter. I did also make reference to the fact that in both the 2014 and 2019 National Assembly elections, the following documents were used as acceptable proof of identity: national identity card, passport, driving license, and bus pass. Mr. Speaker, sir, Regulation 2 of the National Assembly Elections Regulations 2014 defines acceptable proof of identity as such document establishing the identity of a person as the Electoral Commissioner may, after consultation with the Electoral Supervisory Commission, determine. Thus, based on Regulation 2 of the National Assembly Elections Regulations 2014, the only acceptable proof of identity is, since the Village Council elections 2020, either a national identity card or passport. This measure was also adopted for the Rodrigues Regional Assembly elections of 2022. Mr. Speaker, sir, the House would recall that I also mentioned that Regulation 30, subsection 6 of the National Assembly Elections Regulations 2014 provides that, and I quote, subsection A, no person shall, by means of 1. A camera, 2. A mobile phone, 3. A photographic or an electronic device, or any other device through which a photograph may be taken or film may be made, take a photograph or make a film of a ballot paper, whether the ballot paper is marked or unmarked, unquote. However, I am informed by the Electoral Commissioner that an elector may be in possession of his mobile phone or any other devices mentioned in Regulation 30, subsection 6, in the voting room, but he is not allowed to use same in the voting or counting room. As I have already stated, the mobile identity card is being finalized. However, once it is launched, the possibility to use it for authentication of voters will require, in the first instance, the conduct of a feasibility study regarding, amongst others, manpower and training requirements, equipment including verification devices in the voting rooms of all polling stations, procedures regarding the authentication process, and financial implications thereof. I am informed by the Electoral Commissioner that in view of the wide-ranging implications for the introduction of mobile ID as proof of identity in the voting room, it will not be possible to make use of mobile ID for the coming elections. Thank you.
Merci, Monsieur le Président. J'ai écouté avec attention les 22 minutes de réponse du Premier ministre. Prime Minister stated in his answer, citizens will be able to use their mobile ID in lieu of their physical ID as a proof of identity. And in the meantime, we have now this new mobile ID regulations, February 2024, which states, Section 5E, the mobile ID can be used to authenticate the holder. I have listened very carefully, Honorable Prime Minister, to your last sentence. May I, therefore, ask the Honorable Prime Minister to take a commitment today in this House that no mobile ID shall be used to authenticate at any time any voter in any voting room for the next National Assembly elections.
Monsieur le Président, je pense que peut-être que j'aurai besoin de plus de 22 minutes. Parce que si en 22 minutes, ce que j'ai dit, c'est tellement clair, mais si l'honorable membre n'a pas compris et il me repose la même question, c'est que peut-être que je dois avoir une demi-journée pour expliquer. J'ai bien dit à la fin de ma réponse, let me repeat, et c'est surtout à la fin de ma réponse, I am informed. Ce n'est pas à moi de prendre la décision. I am informed. Je le dis en français, peut-être pour qu'on puisse mieux comprendre. So I am informed by the Electoral Commissioner, c'est le commissaire électoral, that in view of the wide-ranging implications for the introduction of mobile ID as proof of identity in the voting room, it will not be possible to make use of mobile ID. Ce ne sera pas possible d'utiliser le mobile ID pour aller voter. Qu'est-ce que je peux dire plus que ça? Ben, si vous me donnez la permission, je peux répéter ça en créole mauricien.
Thank you, Mr. Speaker, sir. I pick it from the last sentence that the Prime Minister just mentioned. The Prime Minister mentioned about the wide implications. Can the Prime Minister thus inform the House whether there are technical and legal implications with regards to the use of mobile ID for the purpose of voting? Thank you.
Mr. Speaker, sir, the Regulation 27(1) of the National Assembly Elections Regulations of 2014 provides that, and I quote, every elector desiring to record his vote shall present himself to the presiding officer in the appropriate voting room at the polling station at which he is entitled to vote, state his name, and produce his national identity card or other acceptable proof of his identity, unquote. So, if the mobile ID is to be used and is determined by the Electoral Supervisory Commission to be any other acceptable proof of a voter's identity, it would, of course, then be legally in order to use the mobile ID. However, there are major technical constraints for the use of the mobile ID for the purpose of voting. In order to verify, first of all, electronically the authenticity of voters using the digital identity card, all voting rooms at all the polling stations, and there are around 2,300, will have to be equipped with verification machines. And that entails also financial implications. That is why the Electoral Commissioner has said that for the coming elections, that would not be possible.
His reply, Honourable Prime Minister, mentioned about a mobile ID verifier app. May I know whether the MNIC unit, which falls under the purview of his office, has already procured this mobile ID verifier app?
Well, the honourable member should know according to standing orders. When he puts a specific question with regard to voting at the next general election, he should restrain and limit himself to the questions. Well, leader of the opposition, he's the last one to speak. He doesn't know, not even know how to put questions. So he's making comment.
Order. What is happening, Honorable Tim? Where you're concerned in this?
Yeah.
Can you show me your locus standi? So the table has been advised that PQB 555, 556, 557, 561, 562 have been withdrawn. Honourable members, time over. We now move to question to other ministers. I will call Honourable Juman.
B563.
Mr. Speaker, sir, I wish to inform the House that the National Pension Fund, NPF, is a pension scheme established in 1978 covering private sector employees in Mauritius. Contributions into the fund were being made by both employers and employees to the rate of 6% and 3% respectively. With the introduction of the contribution sociale généralisée, CSG, as from 1st September 2020, contributions are now made to the Mauritius Revenue Authority. The details of placement of NPF are being tabled. As far as the National Solidarity Fund is concerned, I wish to inform the House that this fund is not related to the National Pension Fund.
Thank you, Mr. Speaker. Mr. Speaker, can I know from the Honourable Minister the total amount invested by the NPF, whether as fixed deposit or corporate bonds, in hold attitude since 2016 and the return perceived to date?
Well, as far as I know, any surplus remaining in the National Pensions Fund may at any time be held on deposit with the government or invested in such manner as the NPF committee may determine. But one thing is certain: the investment is being made in a best and safe manner, with high returns.
Mr. Speaker, thank you. On parle de l'argent des travailleurs, on parle de plusieurs milliards de roupies. Mr. Speaker, can I know from the Honourable Minister the total amount, my question is clear, of interest due since March 2022 to date, despite 2 letters sent to the manager of hold attitude to settle the amount due, interest amount due, since 21st of March to December 2023. I'm tabling a copy of the letters sent, and also if the Minister is aware that the total amount... Yes, we are to... Yes.
Mr. Speaker, the supplementary question is very far from the original question. The original question is about placement. So
Yes, don't discuss.
But I have already...
I am ruling. You know, in a parliament there is a speaker. A parliament is not like a boutique. Don't make parliament become a boutique. You see what you're doing? You see. So I stop. Can you please, while I am giving my ruling, you're discussing with me, can you please walk out from this chamber? Walk out from this chamber. This is not the dignity of an honorable member. The dignity of this house. I am naming you. Sergeant at Arms, collect this man. He's becoming dangerous. Collect him. Withdraw him. Withdraw. All police officers, go and collect this man. He's becoming too rough for this parliament. Go out from here. Go out from here. Go out from here. You are too rough for parliament. You are a rough man in this parliament. Go out from here. Sergeant at Arms, collect him. Collect him. Collect him. You have the right, Sergeant at Arms. You have the right. He doesn't have the right. Collect him. Collect him. All police officers go there, collect the man. Collect the man, Sergeant at Arms. This is your work. Don't fail in your duty. You have police duties in this chamber. Honorable members, in view of the situation is becoming more and more difficult. I am suspending the sitting for a few minutes.
Questions?
Honourable members, I have to inform the House that Mr. Niteshan Tailame has joined the clerk's table as clerk assistant. Mr. Tailame joined the civil service as management support officer in August 2014. He was subsequently appointed as court officer at the judiciary in October 2017 and court usher in January 2019. Prior to joining the National Assembly, he held the post of analyst at the Ministry of Finance, Economic Planning and Development. He holds a bachelor's degree in law and management from the University of Mauritius, a Master of Business Administration from the Open University of Mauritius, a Master of Laws in Financial and Commercial Law from the University of Central Lancashire. On behalf of the House and in my own name, I extend a warm welcome to Mr. Niteshan Tailame and wish him a successful professional career. I now invite Mr. Niteshan Tailame to join the table. I have taken cognizance of a press article entitled La sanction contre Rajesh Bhagwan considérée comme injustifiée, which appeared in the Express of today. In the said article, referring to the suspension of Honorable Bhagwan, the Honorable Shakil Mohammed is reported to have stated that I have given a wrong interpretation of standing orders. I wish to set records straight. Honorable members, the House will recall that at the sitting of 5th July 2024, I made an announcement in regard to the intervention of Honorable Bhagwan during a press conference whereby he uttered undignified words to my address. I accordingly requested the Honorable Bhagwan to present his unreserved apologies to the House, failing which I would be left with no other alternative than to ask him to withdraw from the chamber. The Honorable Bhagwan, instead of presenting his apologies, replied the following: I call a spade, and I won't withdraw. It is a fact, ou un agent politique, to un agent politique. In the light of the reaction of the Honorable Member, and considering that this amounted to a grossly disorderly conduct and to disregarding the authority of the Chair, I took the decision to name him under Standing Order 49-4, and there was no need to proceed under the National Assembly Privileges, Immunities and Powers Act, as grossly disorderly conduct occurred in the House itself. I further wish to inform the House that any member who is aggrieved by the decision of the Speaker may challenge same by way of a substantive motion. Therefore, the remarks made by the Honorable Shakil Mohammed in today's article in Express are not justified.
The Constitution Amendment Bill. D'après ce explanatory memorandum qui fait circuler dans le Parlement, l'objectif de ce projet de loi-là, c'est pour amender la Constitution pour accorder un pouvoir et une responsabilité additionnelle à la Electoral Commission, qui nous appelle Commission électorale, et au commissaire électoral dans une matière qui concerne le financement politique. Political Financing Bill, d'après ce Explanatory Memorandum qui fait circuler dans le Parlement, sa projet de loi-là pour garantir la transparence et que la responsabilité dans le financement d'un parti politique afin qu'il empêche la corruption et qu'en même temps promouvoir une concurrence ou une compétition juste et équitable. Il interdit une donation politique à un parti qui pas enregistré ou un individu qui pas affilié à un parti qui est enregistré. C'est pourquoi Representation of People Act peut bien être modifié comme suit. Pour imposer une limite lors d'une dépense électorale, que ce soit pour un parti ou alliance, qui peut avoir une obligation légale pour déclarer une dépense. Pour avoir une augmentation dans dépenses électorales qui un candidat gagne droit à faire dans l'élection à l'Assemblée nationale, élection régionale Rodrigue ou élection municipale et villageoise. Pour régulariser un quartier général politique temporaire qui met en place dans l'élection, qui nous appelle aussi base.
Bill's second reading.
Mr. Speaker, sir, I move that the Constitution Amendment Bill number 5 of 2024 and the Political Financing Bill number 6 of 2024 be read together a second time as they relate to the same subject matter. Mr. Speaker, sir, it is with a deep sense of satisfaction that I'm presenting today these two historic bills, through which the government is fulfilling yet another of its major commitments, which it took vis-à-vis the nation in 2019. These two bills aim at introducing the much-needed and long-awaited transparency and accountability in political financing in our country. The presentation of these two bills today is also another unequivocal testimony of the government's willingness and commitment to safeguard and enhance public confidence in our democratic system and consolidate the health of our democracy. Mr. Speaker, sir, the House will recall that during our first mandate, we had made a pledge to the nation to regulate political financing. That pledge was duly reflected in the government program 2015-2019. And in fulfillment of that commitment, we did come up in 2019, after much efforts and wild consultations, with two bills, namely the Constitutional Amendment Bill number 13 of 2019 and the Political Financing Bill. The aim of those bills was precisely to plug the transparency and accountability gap in political financing in our country. It was, in fact, the first concrete attempt in our political history to regulate political financing in our country, although the issue had been on the political agenda for nearly 2 decades. However, as the House is also aware, the bills were regrettably not supported by the then opposition, much to the disappointment of the people of this country who had been impatiently awaiting appropriate political financing legislation to enhance public confidence in our political system. Instead of supporting the laudable initiative of the government to promote a culture of transparency and integrity in the political arena, the then opposition chose to play petty politics and came up with all sorts of lame excuses to justify their untenable stand on those bills. In fact, they did not have single valid argument not to vote for the bills. Most of their interventions were only empty rhetoric. Mr. Speaker, sir, had those bills been voted at that time, we would have by now gone a long way in addressing the lingering suspicion and public concerns about unregulated political finance in our country, which I must say was reinforced in the aftermath of the infamous coffers saga. Mr. Speaker, sir, the need to regulate political financing is long overdue. And as far as we, on this side of the House, are concerned, we reckon that the absence of an appropriate regulatory regime for political financing remains an important gap in our anti-corruption framework. This is the reason why, in our electoral manifesto of 2019, we maintained our pledge to introduce a new bill on the financing of political parties, and that pledge was faithfully reflected in the government program 2020-2024. In order to fulfill that commitment, the government set up a ministerial committee in November 2022 under my chair, with a view to making recommendations on, inter alia, the regulation of the financing of political parties. The committee examined the different aspects and issues surrounding political finance regulations, including its essential building blocks and core principles, namely the oversight and enforcement mechanism, prohibited donations, spending limits, accounting and record keeping, reporting and disclosure, registration of political parties and sanctions, amongst others. The committee also examined the views expressed and counter-proposals made by members of the National Assembly during the debates on the Political Financing Bill in 2019, including those from the opposition side. A first draft of the Political Financing Bill and the Constitution Amendment Bill was prepared by the Attorney General's Office based on the recommendations of the Ministerial Committee. After further discussions and fine-tuning, the draft bills were widely circulated on 29th April 2024 for consultation purposes. In fact, copies of the bills were sent to each and every member of the National Assembly, the Electoral Supervisory Commission, the Electoral Commissioner, the Financial Services Commission, Business Mauritius, and the International Institute for Democracy and Electoral Assistance, International IDEA. A copy each of the two bills was also posted on the website of the Prime Minister's office, and members of the public were also invited to submit their views, comments, and/or counter-proposals. Mr. Speaker, sir, following the consultation exercise, my office received comments and counter-proposals from the following institutions and persons: the Electoral Supervisory Commission, the Electoral Commissioner, the Financial Crimes Commission, Business Mauritius, Transparency Mauritius, International IDEA, and two parliamentary private secretaries namely Honorable Francois and Honorable Nakchedi. Mr. Speaker, sir, all the observations made and counter proposals received following the consultation exercise have been duly considered by the Ministerial Committee. And the draft political financing bill has been reviewed to accommodate certain observations and counter proposals made. I must say that the proposals contained in the two bills have been welcomed by the Electoral Supervisory Commission, the Electoral Commissioner, the International IDEA, and Transparency Mauritius. In fact, the Electoral Supervisory Commission considers that the political financing bill is in the national interest, ensures fairness, and aims at reducing improper influence and corruption by making provision for accountability and transparency with regard to the electoral process. The Electoral Commissioner, on his part, sees the proposals for regulating political financing embodied in the bill as being robust, well-structured, and comprehensive, and containing clearly defined provisions aimed at promoting transparency, accountability, and integrity in political financing. International IDEA, on its part, considers that overall, the draft bill quite sufficiently covers a wide range of political finance issues and is mostly in line with global regulatory trends. It has also drawn attention to some emerging issues that may be worth considering in the future. Transparency Mauritius has, on its part, expressed its gratitude for the government's efforts and commended the initiatives taken, and it also made certain suggestions. Mr. Speaker, sir, before delving into the content of the two bills, I would like to briefly explain the stand of the government on the issue of public funding of political parties. This issue was carefully examined by the Ministerial Committee, which took note of, inter alia, the recommendations made in previous reports on this particular issue, namely the report of the Sachs Commission of 2001 and the Yangxing report of 2004, and also international practice in this regard. Admittedly, public funding of political parties is a common feature in many foreign jurisdictions. However, its forms and objectives vary considerably from one country to another. The main argument in favor of public funding is that it can contribute to ensure, to a certain extent, a level playing field in a political contest. However, it remains questionable whether public funding can actually help create a level playing field among political parties. It is arguable that, on the contrary, public funding could well accentuate the disparity between major parties and emerging ones, given that a threshold would inevitably have to be imposed for a party to qualify for public funding. Even with fair eligibility and allocation criteria, we may end up with a polarization of the political arena, given that only major political parties would ultimately benefit from public funding, and smaller parties would run the risk of being driven out. It can also be argued that public funding may lead to an over-reliance of political parties on such funding and gradually disconnect the party from its grassroots. The Ministerial Committee felt that, although public funding may have certain advantages, public opinion in Mauritius is still, in general, not in favor of the idea of financing political parties from taxpayers' money. The Ministerial Committee also considers that the objectives of the Political Financing Bill, as enunciated in its explanatory memorandum, can be achieved without necessarily introducing the element of public funding. Mr. Speaker, sir, I must underline the fact that through these bills, we are also fulfilling one of our important international and regional obligations in relation to political financing, namely, under the United Nations Convention Against Corruption, UNCAC, and the African Union Convention on Preventing and Combating Corruption. As a matter of fact, the UNCAC, which Mauritius signed in 2003 and ratified in 2004, provides as follows in Article 7.3 of the Convention, and I quote, each state party, shall also consider taking appropriate legislative and administrative measures consistent with the objectives of this convention and in accordance with the fundamental principles of its domestic law to enhance transparency in the funding of candidatures for elected public office and, where applicable, the funding of political parties, unquote. Moreover, Article 10 of the African Union Convention on Preventing and Combating Corruption, which Mauritius signed in 2003, but ratified only in 2018, enjoins state parties to inter alia, and I quote, adopt legislative and other measures to A, prescribe the use of funds acquired through illegal and corrupt practices to finance political parties, and B, incorporate the principle of transparency into funding of political parties, unquote. Mr. Speaker, sir, the framework for the regulation of political finance, which we are proposing in the new political financing bill, is very much in line with the philosophy enunciated in Articles 7 and 10 of the UNCAC and the AU Convention, respectively. It should also be highlighted that neither of these conventions imposes any obligation on state parties to introduce public funding of political parties or candidates. Mr. Speaker, sir, the preparation of these two bills has been a complex task involving evaluation of different options and prioritizing competing objectives. Although we have drawn inspirations from best practices in foreign jurisdictions, the proposed framework for regulating political finance is largely homegrown and is crafted in a manner that takes into account the specificity of our electoral system and our social and political context and realities. We have also taken particular care not to impose unnecessary burden on political parties, candidates, campaigners, and citizens, whilst ensuring that the legislative objectives are met. We have therefore opted for a political finance regulation framework that is simple, effective, and enforceable. Mr. Speaker, sir, let me now highlight the salient features of the two bills. I shall first take the Constitution Amendment Bill, which seeks to amend the Constitution in order to extend the powers and functions of the Electoral Supervisory Commission and the Electoral Commissioner. to cover matters relating to political funding. Section 41(1) of the Constitution presently empowers the Electoral Supervisory Commission to have general responsibility for and to supervise the registration of electors for the election of members of the National Assembly. The powers and functions of the Electoral Commissioner are, pursuant to Section 41(2) of the Constitution, also presently limited to registration of electors and conduct of elections. Clause 2 of the Constitution Amendment Bill is accordingly amending subsections 1, 2, and 3 of Section 41 of the Constitution with a view to vesting additional powers and functions upon the Electoral Supervisory Commission and the Electoral Commissioner in matters relating to political financing. Mr. Speaker, sir, I now come to the Political Financing Bill. As mentioned in the explanatory memorandum, the object of this bill is to provide for accountability and transparency in political financing with a view to promoting a level playing field, ensuring fair competition, and preventing improper influence and corruption. Clause 2 of the bill provides, inter alia, for a clear definition of the terms political donation, monetary donation, and donation in kind, as follows. Political donation means a monetary donation and a donation in kind. Monetary donation means donation in cash and with respect to a registered political party. Includes any money lent to that party which has been written off by the lender, but does not include a membership fee paid to that party. Donation in kind means any of the following sponsorship or services provided to a recipient: publicity in the media and on billboards, elections, paraphernalia, including banners, flags, buntings, or posters, campaign promotion shirts, t-shirts, polo shirts, and caps, advertising materials such as sample ballot papers, pamphlets, or stationery, transport facilities, public address system, equipment, goods, or facilities, including marquees and halls, but does not include sponsorship or services, excluding those referred to in paragraph A, rendered personally by a volunteer, or free airtime for political broadcast. Mr. Speaker, sir, we have opted for a definition of donation in kind that is wide enough to capture most of the costly items which a party may receive as donation in kind, especially during an election period, and which should be accounted for. I wish to point out that the proposed definition of donation in kind now includes items such as transport, marquees, and public address system, as these constitute high-cost components in an election campaign. However, for the sake of enforceability, petty items and services provided by volunteers and free airtime for political broadcast have been excluded from the definition. Moreover, monetary donation will include any loan granted to a party which has been written off by the lender. Clause 3 of the bill provides that the Act will apply to any political party, a member of the National Assembly, a candidate, an election agent that receives political donations. Part 2 of the bill, which includes clauses 4 to 10, lays down the rules on political donations and covers, inter alia, issues such as who can accept political donations, what are the permissible sources of political donations, and the rules governing such donations by private entities. Mr. Speaker, sir, the House will recall that the Political Financing Bill of 2019 required all political donations to be channeled through the Treasurer. It was argued that that requirement would lead to bottlenecks and impose undue burden on the Treasurer. This issue has been addressed in Clause 4 of the present bill, which accordingly provides that a political party registered with the Electoral Supervisory Commission, a member of the National Assembly, and a candidate and his election agent can accept a political donation. Clause 5 of the bill imposes an obligation on any person receiving a cash donation on behalf of a political party to remit such donation to the party leader or the treasurer of the party within 7 days of receipt, with all necessary information for proper recording and reporting. Similarly, information on any donation in kind received by a person on behalf of a party should be communicated to the party leader or treasurer of the party within 7 days of receipt for recording and reporting. Clause 6 of the bill pertains to political donations received on behalf of a candidate by his election agent. This clause imposes an obligation on the election agent receiving cash donations on behalf of the candidate to remit same to the candidate within 7 days with all required information for proper recording and reporting. There is a similar obligation on the election agent to communicate to the candidate information pertaining to donation in kind received by him on behalf of the candidate. Clause 7 of the bill lays down the rules governing political donations by private entities. Clause 7 provides that a private entity cannot make a political donation until and unless there is a written resolution of its governing body authorizing it to do so. Such political donations should be disclosed in its financial statements, indicating the amount of cash donations and monetary value of donation in kind made, and a political donation by a private entity must be made only by checks or electronic means. I should point out that the definition of private entity now includes an association, a foundation, a limited liability partnership, a trust, or such other private entity as may be prescribed. Mr. Speaker, sir, Clause 8 of the bill imposes a duty on the leader or treasurer of a political party to deposit any unutilized cash donations received on behalf of the party into the bank account of the party. Moreover, any unreturned party candidate must, after the election, remit any unutilized cash donation to the leader or to the treasurer of his party. A member of the National Assembly will be required to deposit any unutilized cash donation in a separate bank account to be opened by him, and no other money should be deposited into that same account. Clause 8 further provides that in case a party member passes away, any available balance of donation deposited into the bank account shall be deemed to belong to his party. Mr. Speaker, sir, Clause 9 of the bill prescribes the acceptance of political donations from the following sources: an anonymous person, a state-owned enterprise, a statutory corporation, a religious body, a non-governmental organization which is in receipt of subsidy or grant from the government, a CSR fund set up under Section 50L of the Income Tax Act, a non-resident citizen, a non-citizen, a foreign government or foreign entity, or such other bodies as may be prescribed. Mr. Speaker, sir, these prohibited sources of political donations are generally in line with international practice. In regard to donations from foreign sources, I would like to point out that according to the database of the International IDEA, out of 180 countries, 126 have placed some form of ban on donations from foreign governments or foreign individuals. Such countries include the United Kingdom, the United States of America, Japan, Norway, Canada, Brazil, and France. I would like to highlight the fact that the 2019 Political Financing Bill did not include non-resident citizens as a prohibited source of political donation. However, this time, the Ministerial Committee considered that allowing non-resident citizens to make political donations would constitute a loophole in the legislation, as it could be used to circumvent the law and allow the channeling of donations from other prohibited sources. It is also to be noted that a non-resident citizen has been defined in the bill as being a citizen whose permanent residence is outside Mauritius and who is not registered as an elector for the purpose of a general election. Mr. Speaker, sir, Clause 10 of the bill prohibits a recipient from accepting a donation which he suspects to originate from the proceeds of a crime and imposes a duty on him to report such cases to the Financial Crimes Commission. A similar duty has been imposed on the Electoral Commissioner to report any suspicious transaction to the Financial Crimes Commission. Mr. Speaker, sir, Part 3 of the bill, which comprises clauses 11 to 16, provides for another important pillar of an effective political finance regulation, and that is the recording and accounting of political donations. In fact, Clause 11 of the bill requires all recipients of political donations to keep a register to be known as a register of political donations. The register shall contain the following information: the amount of monetary donations received, whether in cash, by check, or by electronic means, the nature and the monetary value of donations in kind received, the date the political donations were received, the names and addresses of the donors, and such other particulars as may be prescribed. Moreover, a member of the National Assembly, an unreturned candidate, and an election agent will be required to keep his respective register of donation for a period of 5 years. Clause 12 of the bill requires all unreturned party candidates to submit within 7 days of the proclamation of the election results a report to his treasurer or to his party leader. Such reports must contain the following information: the amount of monetary donations received, whether in cash, by check, or by electronic means, the amount of any unutilized monetary donation, the nature and monetary value of donations in kind received, the date on which the political donations were received, and the names and addresses of the donors, including their contact details. On the other hand, a returned candidate will be required to submit a similar report within 7 days after the elections, and thereafter he will have to submit such report to his leader or treasurer on a quarterly basis. This obligation on a candidate to submit reports on political donations to his party leader will give the latter a droit de regard and will act as an additional safeguard against any risk of illicit money polluting the political process. Clause 13 of the bill imposes a duty on the treasurer of the party to keep all accounting records of the party's transactions in terms of donations received and payments made, so as to enable him to prepare the statement of accounts required to be submitted under this law and to keep same for a period of at least 5 years. Mr. Speaker, sir, the House will recall that the 2019 Political Financing Bill required a political party whose gross income or total expenditure in any financial year exceeded 1 million rupees to get its accounts audited by a qualified auditor before submission to the Electoral Supervisory Commission. In order to reduce the burden on political parties, Clause 14 of the present bill enjoins the treasurer of every political party only to prepare and submit the party's audited statement of accounts to the Electoral Commissioner, not later than 60 days after the end of every financial year. There would be no need to have the accounts audited by a qualified auditor. However, Clause 14 also empowers the Electoral Commissioner to appoint a qualified auditor to audit any unaudited statement of accounts. Mr. Speaker, sir, I should also highlight the fact that all such statement of accounts submitted to the Electoral Commissioner shall be open for consultations by the public. It is of note that there will be no legal obligation on a member of the National Assembly to submit an annual statement of accounts. However, a party candidate and an independent candidate will be required to submit their usual election returns under the Representation of the People Act. A similar obligation to submit election returns is being imposed on a political party through a consequential amendment to the Representation of the People Act, which is being brought by Clause 28D of the bill. Clause 16 of the bill requires the Electoral Commissioner to prepare and submit a report based on the statement of accounts of all registered parties to the National Assembly not later than 120 days after the end of every financial year. In the 2019 bill, there was no mention of the information that such report should contain. The present bill provides that this report to the National Assembly should contain the following information: any amount received by each party in respect of subscription and membership fees from its members, interests, monetary donations, and any other activity. The monetary value of donations in kind received, any expenditure incurred and the reason for such expenditure, any asset including any amount of cash in hand and cash at bank, together with the name of the bank where the money is deposited, and any liability. It goes without saying that any donations in kind received should be valued at its market rate. Mr. Speaker, sir, Part 4 of the bill lays down the role and powers of the Electoral Supervisory Commission and the Electoral Commissioner with regard to supervision and monitoring of political financing. The Electoral Supervisory Commission and the Office of the Electoral Commissioner have been chosen as the oversight body for the monitoring of political financing, as they are two independent constitutional bodies of high repute, both regionally and internationally, and are best suited for such role. Besides, globally as well, the most common approach is to entrust the oversight role for political financing to election management bodies. Clause 17 of the bill accordingly vests the Electoral Supervisory Commission with general responsibility for the supervision of all matters relating to political financing. Clauses 18 to 20 of the bill vest the Electoral Commissioner with powers of investigation as well as wide powers of entry and search in order to enable him to discharge his new functions in an effective manner under the supervision of the Electoral Supervisory Commission. Clause 19 of the bill empowers the Electoral Commissioner to order any person to appear before him and to produce any book, document, record, or information which he may require in the course of his investigation. He may also order a person to furnish a statement in writing under oath. Failure to comply with an order issued by the Electoral Commissioner shall constitute an offence under this Act. Clause 20 of the bill provides that a magistrate may, on sworn information, issue a warrant to an officer designated by the Electoral Commissioner authorizing him to enter and search any premises at all reasonable times where there is reasonable ground to believe that there is, on such premises, evidence which may assist the Electoral Commissioner in an investigation. However, such searches should be carried out in presence of the owner of the premises or his duly authorized agent, who should, prior to the search, be provided with a copy of the warrant. Clause 25 of the bill further provides that any information obtained by the Electoral Commissioner in the course of his investigation from any book, document, record, and so on, shall be admissible in court. Mr. Speaker, sir, it is also noteworthy that the Electoral Commissioner is being empowered under Clause 21 of the bill to issue directives to a person to take remedial actions for having breached any provision of the Act or to take measures to prevent any contravention of the Act within a specified time period. Where such a directive is issued to a political party, it will be incumbent upon the treasurer of that party or the leader of that party or any other person concerned with the management of the party to comply with such directives. I should point out that non-compliance with such directives shall constitute a separate offence for each day of non-compliance, punishable by a fine of 5,000 rupees per day up to a maximum of 5 million rupees. Provision has nevertheless been made under Clause 21(3) of the bill for a person to whom such a directive has been issued to have the opportunity to make representations to the Electoral Commissioner within such time frame as may be prescribed. Mr. Speaker, sir, Part 5 of the bill deals with the procedures and requirements for the registration of political parties for the purpose of accepting political donations. Clause 22 of the bill enjoins any political party wishing to accept political donations to be registered with the Electoral Supervisory Commission. An application for such registration may be made at any time to the Commission, and the applicant should provide the following information to the Commission: the names, address, and symbol of identification of the political party, the names, signature, and residential address of the leader, president, secretary, treasurer, and other office bearers of the political party, whether the political party is represented by any member in the National Assembly, evidence that the political party holds a bank account, and such other information or document as the Commission may determine. A political party that does not hold a bank account at the time of application may be registered by the Commission, provided that the party shall, within 1 month of its registration, open a bank account, failing which its registration will lapse. Clause 22(3) of the bill further provides that no application for registration will be entertained by the Commission during the period starting 5 days after the day on which writs for a general election have been issued and ending on the day the election results are proclaimed. Moreover, where the Commission decides to register a party, it shall give notice of such registration in the Government Gazette. Where the Commission decides to reject an application, it will have to give the reasons therefor. Mr. Speaker, sir, during the debate on the 2019 Political Financing Bill, few members had suggested that the bill should have provided for a right of appeal in case the ESC decided to reject an application for registration. Clause 22(7) of the present bill accordingly provides that any party aggrieved by the decision of the Commission not to register it may appeal to the Supreme Court, and such appeal shall be determined by a judge within 14 days. In case the Commission decides to reject an application made not later than 5 days after the day on which writs for general elections have been issued, an appeal against the decision should be made within 24 hours of the decision, and the appeal should be heard and determined not later than 2 days before the nomination day. Moreover, the determination of the judge shall not be subject to appeal. Mr. Speaker, sir, proportionate and dissuasive sanction is an essential element in ensuring the effectiveness of any political financing legislation. Honorable members will have noted that in different clauses of the bill, provisions have been made for sanctions in the form of financial penalties only. A general provision is made in clause 25 of the bill to the effect that any person who otherwise contravenes the act shall commit an offense and on conviction be liable to a fine not exceeding 5 million rupees. The proposed fine up to 5 million rupees, coupled with the power vested in the Electoral Commissioner to issue enforceable directives, which I mentioned earlier, is considered to be dissuasive enough to ensure compliance with the law. Government has opted for financial penalties instead of other forms of sanctions like imprisonment, disqualification, or loss of office, deregistrations, amongst others, as we consider that a fine is simple and relatively easy to enforce and is more in line with our democratic tradition. It is also the most common form of sanction internationally. Mr. Speaker, sir, clause 26 of the bill grants jurisdiction to a magistrate to try any offense under this act and to impose any penalty provided therefor. Clause 27 of the bill empowers the President of the Republic to make regulations for the purposes of the act, after consultation with the Electoral Supervisory Commission and the Electoral Commissioner. It is to be noted that this is similar to the provisions of Section 85 of the Representation of the People Act, which also empowers the President to make regulations for the purposes of the Act. Clause 28 of the bill deals with the consequential amendments to the Representation of the People Act. Section 51 of the RPA is being amended to provide for an upward review of the ceilings of election expenses so as to bring it to a more realistic level. As the House is aware, the present ceilings were set in 1989 and have not been revised since then. The House will recall that the Sachs Commission identified the violation of the unrealistic expenditure ceilings as being a big loophole in our law, which makes a mockery of the whole issue of placing ceiling on expenses. The Commission therefore forcefully recommended an increase of the expenditure ceilings to a reasonable and realistic level so as to match the costs of elections. Accordingly, the expenditure ceilings are being revised through this bill as follows. For a National Assembly election, in respect of a party, a ceiling of 1.5 million rupees per constituency is being prescribed, provided that the party has fielded at least one candidate in that constituency. It is to be noted that so far, there was no ceiling prescribed on the expenditure of political parties. In respect of a candidate who is not the only candidate belonging to a party at the election in the constituency, the ceiling is being increased from 150,000 rupees to 1.5 million rupees. In respect of a candidate who is the only candidate belonging to a party at the election in the constituency, the ceiling will be 2 million rupees. And in respect of a candidate who does not belong to any party at an election in a constituency, the ceiling will be 2 million rupees. For the municipal city council or municipal town council election, the ceiling is being increased from 50,000 rupees to 300,000 rupees per candidate. For village council elections, the ceiling is being increased from 50,000 rupees to 200,000 rupees per candidate. For a local region election or an island region election in Rodrigues, the ceiling is being increased from 100,000 rupees to 300,000 rupees. I wish to point out that these expenditure ceilings include the monetary value of the donations in kind that a party or a candidate may receive. Mr. Speaker, sir, the other amendments proposed in the Representation of the People Act are as follows. 1. The limit of expenses to be incurred by a candidate, as provided in Section 53 of the Representation of People Act, is being increased as follows. Expenditure for the candidate's personal living expenses is being increased from 25,000 rupees to 150,000 rupees. Petty expenditure is being increased from 2,500 rupees to 25,000 rupees. 2. In Section 56, the minimum expenditure to be supported by vouchers is being increased from 30 rupees to 5,000 rupees. 3. A new Section 56A is being introduced to impose an obligation on the treasurer of every political party which has fielded at least one candidate at a general election to make an election return to the Electoral Commissioner within 90 days of the proclamation of the results. As the House is aware, at present only candidates are required to submit such election returns, given that expenditure limits are applicable only to candidates. I wish to point out that such election return in case of a party alliance should be made jointly by the respective treasurer of the political parties constituting the alliance. Insofar as candidates are concerned, they are required to submit their election returns within 6 weeks of the proclamation of results as provided in the Representation of the People Act. 4. The fines prescribed in Part 5 for various election offences like illegal payment, or hiring, bribery and treating, undue influence, and offences in respect of ballot boxes are being increased from 1,000 or 2,000 rupees to 50,000 rupees. 5. A new section 72B is being inserted to provide for temporary political headquarters and campaign quarters, commonly known as BAS. There shall be not more than one political headquarters per constituency, municipal city council, municipal town council, district council, or local region, as the case may be, and not more than one temporary political campaign quarter, that is the BAS per polling station. Moreover, no political headquarters or BAS shall be set up before the issue of writs of election. 6. A new section 72C is being inserted to empower the Electoral Supervisory Commission to issue directives to ensure compliance with the provisions regarding temporary political headquarters and campaign headquarters. A person on whom a directive will be served will have the possibility of making representations to the Electoral Supervisory Commission as he deems necessary. The functions and powers of the Commission under this new section shall be discharged and exercised by the Electoral Commissioner. And 7, Section 74(1) presently provides, inter alia, that a person who is found guilty of an illegal practice shall be liable to a fine not exceeding 1,000 rupees. This fine of 1,000 rupees is also being increased to 50,000 rupees. Mr. Speaker, sir, while framing the proposals embodied in the Political Financing Bill, we have drawn inspirations from best practices in both established and transitional democracies, taking into account our own local context and realities. The House may be aware that in recent years, a significant number of countries have introduced legislation to reduce the negative impact of money in politics. As far as Mauritius is concerned, we do not have, as yet, any specific legislation on political financing, despite our international commitment vis-à-vis the UNCAC more than 20 years ago. The absence of such a legislation indeed constitutes a big gap in our governance and democratic framework. As I have said previously in this House, there is no universally agreed system of regulating political finance. Each country has to craft its own model that suits its local context. We consider that the proposals embodied in these two bills are appropriate and workable in our local context. Mr. Speaker, sir, I would invite the opposition this time to look at the proposals in a dispassionate and rational manner and to put national interest above party political considerations. As I stated earlier, in 2019, the opposition chose to be on the wrong side of history when they decided to thwart the government's initiative and frustrate the will of the people by not supporting the political finance bill. Today, they are being given an opportunity to make amends and redeem themselves. The House and the population will recall that for the 2014 general election, the Labour Party MMM coalition promised in their electoral manifesto to introduce legislation to regulate political financing, although that was not sufficient enough to convince the electorate. For the 2019 general election, the MMM, in its electoral manifesto, promised to, and I quote, introduire un financing of political parties bill efficace pour permettre aux partis politiques d'assumer démocratiquement leur rôle sans les ficelles des financements occultes, unquote. In regard to the Labour Party, surprisingly, or should I say unsurprisingly, we do not see any such commitment in their 2019 electoral manifesto. But be that as it may, such pledges to promote integrity and clamp down on corruption must be more than campaign promises and words on paper. Therefore, I make an appeal to the opposition, who often present themselves as anti-corruption and integrity champions, to come forward and fulfill their commitment, not only towards the people of this country, but also towards the international community. Parliamentarians should be the first to take a moral stand and support a culture of integrity. It all begins with setting the right example. By helping to tackle corruption, parliamentarians can show they mean business. Mr. Speaker, sir, as I said earlier, the proposed bills constitute a much-needed legislative framework with the very lofty objective of strengthening our democracy. The people of this country are watching. The opposition will be well advised not to miss the opportunity this time, else the people will not forgive them. The government has done its part. It is time for the opposition to walk the talk and demonstrate what they stand for. This may not be a perfect bill. After all, there is no such thing as a perfect political financing legislation. But we need to start somewhere, and we can build on that in the light of experience that we gather as we go along. Mr. Speaker, sir, the 10th session of the Conference of State Parties to the UNCAC was held in December last in Atlanta, USA. One of the key issues which was on the agenda was precisely the question of how to stop opaque money from corrupting democracy. In that context, a broad coalition of more than 100 international institutions and civil society, including the International IDEA, the US-based International Foundation for Electoral Systems, and the UK-based Westminster Foundation for Democracy, made a joint appeal to the delegates attending the UNCAC Conference of Parties to further prioritize and enhance political finance transparency by, inter alia, closing loopholes for illicit funds in politics, improving oversight and accountability, and strengthening international cooperation. Mr. Speaker, sir, to conclude my speech, I would like to quote the following from their submissions, which underscore the need for countries like Mauritius to regulate the role of money in politics, and I quote, "Political finance is a pivotal issue in the fight against corruption. The integrity of democratic processes is contingent on financial transparency and accountability in politics. The lack of transparency in political finance leads to waste or misuse of often limited public resources, posing a threat to the entire sustainable development agenda. When financial contributions to political parties, electoral campaigns, or candidates are opaque and unaccountable. This enables clientelism, fuels corruption, increases the cost of political participation, and destroys trusts in governments. These outcomes adversely affect public services, drive conflict, and make politics an exclusive club. These negative impacts are felt most keenly by women, young people, people with disabilities, and other marginalized groups, unquote. Mr. Speaker, sir, with this pertinent and insightful code, I commend the bill to the House.
Amended.
The Water Resources Bill. D'après ce explanatory memorandum qui fait circuler dans le Parlement, le principal objectif de ce projet de loi-là, c'est pour établir un cadre juridique complet pour l'utilisation, gestion, contrôle, protection, conservation et développement durable des ressources de l'eau dans Maurice. Sauvegarde l'intérêt public dans les médias et à long terme pour un accès équitable à de l'eau. Garantir sécurité et résilience de l'eau. Établir une Water Resources Commission. Encourage utilisation efficace de l'eau. Prend disposition pour et en relation avec les affaires connectées et par rapport à ce sujet-là.
Please be seated. Honorable members, earlier today, I ordered Honorable Juman to withdraw from the chamber for arguing with the chair. Thereafter, Honorable Juman stated, "You're cheap, you're shame." Thereupon, I named Honorable Juman. Honorable Juman continued to argue with the chair in a grossly disorderly manner and challenged the authority of the chair in a most undignified manner by uttering the following words. "Do whatever you want." Couvert. Combien te pou capable couvert? Bientôt te pou dehors. To the address of the speaker. I ordered Honorable Juman to leave the chamber several times, and the honorable member refused to leave, and the sitting became unruly. I therefore suspended the sitting.
Mr. Speaker, sir, in view of your decision to name Honourable Juman, I beg, under Standing Order 17.3, to take the time of the Assembly for urgent business.
Seconded.
Seconded. The question is that the Honourable Deputy Prime Minister be allowed under Standing Order 17.3 to take the time of the House for urgent business. Those in favour say aye, those against say no. The ayes have it.
Mr. Speaker, sir, having obtained your permission, I now beg to move under Standing Order 29.1 to present a motion without notice.
Seconded.
Seconded. The question is that the Honourable Deputy Prime Minister be allowed under Standing Order 29.1 to move a motion without notice. Those in favour say aye, those against say no. Aye. The ayes have it.
Mr. Speaker, sir, in view of your decision to name Honourable Juman, I beg to move that the Honourable Juman be suspended from the service of the Assembly for today's sitting and the next 6 sittings, unless unreserved apologies are tendered to the House.
Seconded.
Seconded. The question is that the Honourable Juman be suspended from the service of the Assembly for today's sitting and the next 6 sittings, unless unreserved apologies are tendered to the House. Those in favour say aye, those against say no. Aye. The ayes have it. Questions? We move to the next question. Honourable Leopold.
Thank you, Mr. Speaker, sir. B564.
Monsieur le Président, le Home Loan Payment Scheme est l'une des mesures phares introduites dans le budget 2021-2022. Mise en place pour soutenir la vision du gouvernement d'une société plus inclusive, elle a permis de faciliter l'accession à la propriété abordable pour des citoyens de la République de Maurice. Dans le cadre de ce programme, une personne éligible qui contracte un prêt immobilier garanti pour construire sa résidence bénéficie d'un remboursement de 5% du prêt jusqu'à un maximum de 500 000 roupies. Le programme est administré par le Registrar général et a été prolongé dans le dernier budget. Cette mesure a eu un impact significatif sur le taux d'investissement, c'est-à-dire le ratio investissement sur le PIB. Pour rappel, le taux d'investissement est passé de 18,5% en 2014 à 23,5% en 2023 et devrait atteindre les 25% en 2024. Monsieur le Président, je souhaite rappeler à l'Assemblée que ce programme a toujours été applicable à Rodrigue. Je suis informé par le Registrar général que depuis le début du plan, 6 demandes sous le Home Loan Payment Scheme ont été reçues de citoyens qui ont contracté un prêt immobilier garanti à Rodrigue. Afin de traiter les demandes, une copie de l'acte de prêt est demandée à l'institution prêteuse respective. Après le processus de vérification, les 6 demandes ont été approuvées et les paiements effectués. Merci.
Next question. Honourable Ochit.
B565. Mr. Speaker, sir, the Central Water Authority supplies water in 6 water supply zones across the island and the regions of Triolet, Trobiche, Pointe-au-Piment, and Morcellement-Saint-André fall under the Water Supply Zone North, which has a total of 15,031 subscribers. These regions are serviced from Boismont Reservoir, New Plaine des Papayes Reservoir, Solitude Borehole, and a containerized filtration plant at Bassin Solitude. The daily hours of supply are 10 hours. I am informed by the Central Water Authority that the intermittency in water supply in these regions is primarily due to the following reasons. A, presence of old and defective asbestos cement or galvanized iron pipes that frequently burst, causing low water pressure or no supply, especially in elevated areas. B, inadequate water resources. C, periodic interruptions for repairs on damaged main service pipes or to facilitate new connections carried out by the CWA. D, disruptions from low service reservoir levels due to pump breakdowns, extended power outages, or decreased production from the irrigation authorities' pipeline. And E, water supply disruptions during the dry season as surface and groundwater levels drop. Mr. Speaker, sir, in my reply to PQB 1184 at our sitting of 17th October 2023, I had informed of measures being taken by the CWA to address these issues. The commissioning of one containerized pressure filter with a capacity of 2,500 meter cube per day at Bassin Solitude in December 2022, along with the installation of HDPE pipeline from Bassin Solitude to Triolet, has contributed to an improvement in water supply. Another containerized pressure filter with a capacity of 2,000 meter cube per day is being installed at Bassin Solitude to enhance the water supply in Triolet and Pointe-au-Piment. A third containerized pressure filter is planned to be commissioned at New Plaine des Papayes Reservoir to channel additional water towards Triolet, Troubiche, and Pointe-au-Piment. Moreover, old and defective pipelines have been replaced and new dedicated pipelines have been laid to improve water supply and pressure. The laying of a dedicated HDPE 200 millimeter pipeline, approximately 3 kilometers long, from New Plaine des Papayes Reservoir to Triolet upper parts, that is Comoti and Tago Road, is near to completion. Additionally, the replacement of old and defective pipelines is ongoing in the affected regions. Specific projects include the replacement of some 1,450 meters of old pipelines in Dodo Lane and Tago Lane, Pointe-au-Piment, and some 5,220 meters in Morcellement, Saint-André. Replacement of some 2,220 meters have already been completed in areas such as Calimai Road, Flamboyant Street, and Filao Street. Mr. Speaker, sir, the CWA is also contemplating to come up with additional boreholes at Solitude and New Plaine des Papayes Reservoir to further improve the water supply. I thank you, Mr. Speaker, sir.
Is the Honourable Minister aware that the issue of water cuts in these regions was reported in l'Express newspaper on Sunday, highlighting the dissatisfaction with the service provided by CWA? And if so, has the Ministry conducted any assessment to address these concerns?
Yes, Mr. Speaker, sir, I'm aware of the situation just mentioned by the Honourable Member. I've queried the CWA and I was told that this was due to a problem that occurred on the Irrigation Authority network, and that had caused several water cuts in that region over a period of a number of days, Mr. Speaker, sir, but this is behind us. Supply has been restored, and I understand the situation is back to normal.
Next question.
B566.
Mr. Speaker, sir, the National Skills Development Programme, NSDP, which was announced in Budget Speech 2016-2017, is implemented by the Human Resource Development Council. The main aim of this program is to train unemployed individuals to better match skills with demand of enterprises. Mr. Speaker, sir, I am informed by the HRDC that the NSDP is implemented following applications for training programs from industry associations and an enterprise or cluster of enterprises. Training programs have to be approved by either the Mauritius Qualification Authority or Higher Education Commission and delivered by training institutions duly registered with the Mauritius Qualification Authority or HEC. All training programs should also comprise a placement component during or at the end of training. Generally, training programs span between 3 and 12 months. The NSDP targets unemployed individuals having studied from primary school achievement certificate, PESAC, to a diploma level and aged between 16 and 59 years. Mr. Speaker, sir, the HRDC under this program covers the eligible training cost and monthly stipend of 8,000 rupees is paid per trainee. Mr. Speaker, sir, I am informed that from 1st of October 2022 to 30th June 2024, there were 634 trainees under the NSDP, and since October 2022 to 30 June 2024, the HRDC has disbursed an amount of 40.5 million rupees under the NSDP, out of which 22.8 million representing stipend paid to trainees and 17.7 million representing training costs paid to training centers, which include, among others, fees for trainers, cost of training venue and training facilities, training material costs, development costs, administration, overhead, and other training-related costs.
Next question.
B567.
Mr. Speaker, sir, I am informed by the Central Electricity Board that there are 5 engines of a capacity of 30 megawatt each at the Fort George Power Station, namely 2 from manufacturer Sulzer and the other 3 from MAN. I am further informed by the Central Electricity Board that following a procurement exercise for the provision of services for 10 years periodical maintenance of alpha lubricating system on the 3 MAN engines, a contract was awarded to Hyundai Global Service Europe, BV, for an amount of USD 261,301.53 on 2nd February 2023. The scope of works comprised A, the maintenance of the alpha lubricator system for the 3 engines, B, supply of spare parts required such as angle encoder, filters, coupling, non-return valves, solenoid valves, accumulator, and feedback sensor. C, programming of the 3 sets of electronic cards as spare for the units, and D, handing over of all programming devices, associated documentations, programming softwares, communication cables, list of plant set values, license certificate, and other accessories used to commission the equipment for their subsequent use. Execution of the maintenance on all 3 engines was scheduled to take place over the period 9th August to 15 September 2023. Mr. Speaker, sir, I have been informed that spare parts, except for the 3 sets of control cards which were intended for subsequent use, were delivered in several batches by Hyundai Global Service Europe BV to Fort George Power Station between 4th to 9th August 2023. As for the 3 sets of control cards, Hyundai Global Service Europe B.V had informed CB that it would in the first instance configure those that CB had procured in 2021. Subsequently, the maintenance works on the 3 engines were successfully completed on 15th September 2023 by 2 technical teams from Hyundai Global Service Europe B.V. Mr. Speaker, sir, with respect to the payment schedule, I am informed by the CB that the agreement provides for claims to be settled within 30 days after completion of service and upon submission of appropriate invoice. CB has informed that in October 2023, 2 invoices amounting to 193,801.53 USD and 67,500 USD respectively were received. Mr. Speaker, sir, I am informed that on 7th December 2023, CB settled the 2 invoices through a bank transfer of 258,944.99 USD to the supplier's bank account according to the details provided by the supplier. Mr. Speaker, sir, with a view to confirming the payment, CB transmitted copies of the outward remittance advice and SWIFT copy to the supplier on 14th December 2023. However, in April 2024, the supplier informed the CB that since March 2024, Hyundai Global Service Europe BV had been renamed as HD Hyundai Marine Solution Europe B.V, and that payment for the 2 invoices amounting to 261,301.53 USD had not been received at their end. Following exchange of correspondences regarding payment documents between 2nd of May to 21st of May 2024, HD Hyundai Marine Solution Europe B.V informed CB on 21st of May 2024 that the previous emails sent to CB were erroneous and did not belong to the email domain of the company. The Internal Audit Department of the CB was requested to carry out an investigation into the above matter on the 22nd of May 2024. Due to the seriousness and technicality of the issue, the Internal Audit Department submitted a preliminary report on 23rd June 2024. It concluded, among others, that the internal audit did not come across any element which could indicate a direct implication of CB personnel in the phishing scam, and the most probable cause is a hacking of Hyundai computer system. The Internal Audit Department is currently carrying out an in-depth and thorough investigation in the payment process. The matter has also been reported to the police. I thank you, Mr. Speaker.
Monsieur le ministre vient de confirmer à la Chambre, Monsieur le Président, que 12 millions de roupies, près de 13 millions de roupies, a été payé à une compagnie fantôme, fictif, scam. Est-ce que le ministre peut dire à la Chambre quand est-ce que le CEB a rapporté le cas à la police ou à la Financial Crime Commission?
No. In my reply, I said that they have reported the case to the police, and I understand that same was done last Friday.
Puisque ce paiement, on ne sait pas combien de paiements il y a, aujourd'hui on sait qu'il y a un paiement de 12 millions de roupies, puisque ce paiement a été approuvé par le Head of Finance du CEB, qui gère des milliards de roupies, et par le General Manager, est-ce que, Monsieur le ministre, compte prendre des sanctions concernant ce paiement de 13 millions de roupies qui s'est évanoui dans la nature contre le Head of Finance et le General Manager, qui les deux ont approuvé ce paiement à la hauteur de 13 millions de roupies?
Mr. Speaker, sir, I cannot take this decision. It is for the board of the CEB to take that decision. And I've said there is an ongoing inquiry. Let us have the conclusion of that inquiry. Then whatever decision has to be taken will be taken, Mr. Speaker, sir.
Next question.
B 568.
Mr. Speaker, sir, with regard to Part A of the question, I'm informed by the National Development Unit that a contract for the construction and upgrading of a network of drains in constituency number 20, comprising the construction of drain at Verger Bissamba Lane at Montroche, construction of drain along Charles Jolivet and Chanoin Rivalan Street, construction of drain along Lady Twinning Street, Beaubassin, and reconstruction of drain at Colonel Mengo Street, Beaubassin, was awarded to J. Ducan and Son Limited on 14th April 2018 for a total amount of 5.3 million inclusive of VAT. The cost of the works at Verger Bissamba Lane was estimated at 272,000 inclusive of VAT. The three projects along Charles Jolivet and Chanoin Street, Lady Twinning Street along Colonel Mengo Beaubassin were completed by the contractor. As regards the project at Verger Bissamba, the contractor had mobilized on site in May 2018, and the work was scheduled to be completed 7 June 2018. However, following representations made by the inhabitants, consultation was held with the then Honorable Parliamentary Private Secretary of Constituency 20 and representative of the Municipal Council of Beaubassin-Rosil, whereby it was decided that the drainage system in the locality would be reconsidered in a holistic way. The contract for works pertaining to Verger Bissamba was consequently cancelled. Mr. Speaker, sir, the services of Lux Consult as consultant under the framework contractor agreement for consultancy services was enlisted on the 7th September 2018 to study the region of Verger Bissamba, taking into consideration the complaints from the inhabitants and the problems reported, namely infiltration of water from the irrigation canal into the private properties, overflowing of irrigation canal during heavy rainfall, resulting in flooding of lateral roads and private properties, accumulation of water in regions along Verger Bissamba Road, and overflowing of existing absorption drain at Supramania Barrety Road at its junction with Verger Bissamba. Lux Consult submitted the feasibility study report on the 10th January 2019, and same could not be finalized for implementation of work as another study was being carried out upstream of Saint-Martin Road by another consultant, namely Servan Singh Yadav and Partners Consulting Engineers Limited, under the mega project flood mitigation measures in the region of Plaisance, Rochebrune, Montroche, and La Chaumière. This project had a direct incidence on the drain work project at Verger Bissamba. The design for the project at Verger Bissamba had to be consequently kept on hold since Servan Singh Yadav and Partners had recommended that the proposed solution for the mega project would entail channeling part of the flow from the upper region of Montroche through Supramania Barrety Road and downstream, hence impacting on the overflow and surface runoff of stormwater at Verger Bissamba. Mr. Speaker, sir, I wish to inform the House that the region of Plaisance, Rochebrune, Montroche and La Chaumière are fully built-up areas with extensive underground services and low-lying in topography with no natural water course to be used as outlet. Therefore, addressing the flooding issues in this region is very complex, challenging, and time-consuming in order to find a sustainable solution. Mr. Speaker, sir, I wish to highlight that initially, the proposed design catered for discharge of stormwater into La Ferme Reservoir through Trianon Grosse Roche Feeder Canal. However, the Water Resources Unit has, on the 9th September 2021, objected to the use of the reservoir as a final discharge point. Due to its precarious state, the Water Resources Unit instead proposed that the River Belle-Île be used as a discharge point on 28 September 2023. However, on 14 February 2024, the Water Resources Unit has informed that the project for upgrading of La Ferme Reservoir has been finalized and has requested that NDU to reconsider a new alignment to cross nearer to La Ferme Reservoir to cater for the overflow from the reservoir into our drain until the discharge point at River Belle-Île. This has considerably delayed the finalization of the design for this mega project. It is only after finalization of the design of this project that consideration for the drain project at Verger-Bissamba could be reconsidered. Mr. Speaker, sir, regarding part B of the question, it is premature at this stage to confirm the completion date of the project. However, at this juncture, I'm informed that the project has a lifespan of 12 months upon appointment of a contractor. Thank you.
Comme mentionné par l'honorable ministre, en 2018, le consultant Lux Consult Limited avait mené une étude et avait soumis son rapport préliminaire afin de trouver des solutions aux problèmes d'inondation dans la région basse de Montroche. Mais par la suite, durant ces 6 années, il n'y a eu aucun développement, quoi que ce soit, et entre-temps, les habitants de Verger ont beaucoup souffert des inondations. L'honorable ministre peut-il donc déposer une copie du rapport final du consultant, et l'honorable ministre peut aussi donner l'assurance que les travaux vont débuter et que les habitants vont bientôt être soulagés des inondations.
Mr. Speaker, sir, I think it's too easy to come and say nothing has been done for 6 years. I've said, well, that we are here in a built-up area. We have challenges. Dealing with flooding issues is not dealing in an aquarium where you take the water to point A, you put it to point B. In fact, here we're trying to find a sustainable, long-term solution. In fact, as I've mentioned, there is no outlet in that part of the country. So the consultants are working, and I don't think it's also correct to come and ask for a copy of the report. We should know that this report will finally go on a tender document where we will have to have contractors to come and tender for that project. How can we make those reports public at this stage?
Next question.
Je vous remercie, Monsieur le Président. B569. Merci.
Mr. Speaker, sir, the Bejutombo Child Daycare Center, which is run by the National Children Council, was set up with a view to offering quality early child daycare to babies and toddlers in a deprived area, so that we can enable the mothers of these children the possibility to undertake gainful employment. With regard to cleaning logistics of the CDCC, I am informed that for upkeeping and regular maintenance of the yard, the following arrangements are in place. There is a nursery attendant who is responsible for the daily general cleaning of the center. There's also a handyman on the establishment of the National Children Council who is posted there twice weekly for the cleaning of the yard, and a general worker is also posted twice weekly to assist in the general cleaning of the child daycare center. Grass cutting is effected by an attendant from the National Children Council twice monthly, or as and when required, depending on the season. And acquisition has also been made for power tools and equipment such as a water pressure cleaner of high capacity, a bush cutter, and gardening tools, amongst others. Mr. Speaker, sir, furthermore, whenever the need arises, the Forestry Service is contacted for the trimming or the felling down of trees around or nearby the CDCC. I am informed that on the 5th of June this year, upon the request of the National Children Council, officers of the Special Mobile Force brought down a tree found in the premises of a pre-primary school, which is located at the rear of the child daycare center, because the roots of that tree were causing cracks in the concrete block wall which separates the pre-primary school and the CDCC. Arrangements, Mr. Speaker, sir, is also being made for trimming of another tree found in the yard of a grotto adjacent to the child daycare center. Mr. Speaker, sir, I wish to inform the House that the child daycare center is found in a building which also houses a women's center on the first floor. With a view to ensuring a clean and conducive environment at the center, regular monitoring visits are effected by the staff of the National Children Council and the licensing section of my ministry, and to date, no complaint whatsoever has been received regarding the condition of the yard, which is kept clean and tidy. The last visit effected by senior staff of my ministry was on the 4th of July this year, confirmed that the state of the yard is in good condition. Thank you, Mr. Speaker, sir.
Monsieur le Président, une supplémentaire, s'il vous plaît. Deux supplémentaires, pardon. Monsieur...
Who can decide? You decide 2, 3, 4, 5 supplementary
Oui,
questions?
OK, très bien. I'm just asking, Mr. Speaker, sir.
You should not ask me.
OK. Alors, Monsieur le Président, je suis juste un peu choquée par rapport à la réponse de la ministre qui dit que la Cour est en très bon état et ce n'est pas les informations que j'ai. Par contre, je suis d'accord avec la ministre quand elle dit que c'est suite à ma question que le management est descendu le lendemain et en urgence, les travaux ont été entrepris. La ministre peut-elle indiquer à la Chambre pourquoi le poste de General Worker est resté vacant depuis 10 ans et trouve-t-elle acceptable que la NCC fasse appel à un attendant de manière sporadique, soit du shelter L'Oiseau du Paradis ou du Maibo Child Creativity Center pour assurer l'entretien de la cour?
Mr. Speaker, sir, in my original reply to the PQ, I have made it very clear on what basis, twice weekly it is, that there is a general worker and an attendant who assist in the general cleaning of the said child daycare center. Thank you.
Yes, please. You can't just, Monsieur le Président, start talking. I should give you the floor. Don't make an abuse of your right to put questions. Now, the next question to Abbas Mahmoud, Honorable Abbas Mahmoud.
B570.
Mr. Speaker, sir, since this parliamentary question and PQ B574 refer to the same subject matter, I shall, with your permission, reply to both of them together. Mr. Speaker, sir, I am informed that as at date, there are 1,592 registered cooperative societies, out of which 1,390 are active. 6 schemes are available to support these cooperative societies. As regards the incentives associated with these schemes, I presume that the Honourable Second Member for Port Louis Maritime and Port Louis East would wish to know what are the financial incentives under the different schemes which the cooperative societies can benefit therefrom. Mr. Speaker, sir, these schemes, with their corresponding financial incentives, which I must point out are grants and are as follows. First, the Boost to Local Production Scheme. This scheme offers a grant of up to 300,000 rupees per cooperative society for the acquisition of new agricultural, agro-processing and value addition equipment and machinery, and or the purchase of livestock, excluding goat and sheep, to enhance local production. Second, the Livestock Farming Project Scheme, which provides cooperative societies engaged in goat sheep rearing with necessary support for the construction, upgrading, or extension of sheds, and the purchase of goats, sheep for breeding and fattening. Each cooperative society in this activity can benefit from a grant of 200,000 rupees. Third, the Zero Budget Natural Farming Scheme, which aims at promoting green and sustainable agriculture. It encourages cooperative societies to adopt new farming techniques and produce natural fertilizers at a reduced cost. Each cooperative society can be allocated 200,000 rupees as grant for the purchase of cows and the construction of cow sheds. Fourth, the waste recycling schemes. This scheme motivates cooperative societies to diversify their activities and adopt sustainable practices by participating in circular economy. A 50% grant up to a maximum of 500,000 rupees per cooperative society can be provided for the purchase of recycling equipment and transportation vehicles from local suppliers. Fifth, the seedling production scheme, which supports cooperative societies in establishing or upgrading a seedling production unit for vegetables and fruits. Each cooperative society can avail itself of a grant for an amount of 200,000 rupees for the purpose. And the sixth, the digitalization scheme, which offers a 50% grant up to a maximum of 100,000 per cooperative society to facilitate the adoption of digital tools, application, and technologies. Mr. Speaker, sir, for a cooperative society to be eligible to benefit from the grant schemes, which I have just enumerated, it would need to satisfy the following common criteria. First, it should be an active and operational society and not a dormant one. It should not be in arrears with regard to payment of annual fees. It should not be under liquidation, and it should submit a detailed project write-up, including the project's objectives, expected outcomes, budget, and implementation plan. Mr. Speaker, sir, as regards Part A of PQB 574, that is quantum disbursed for the financial year 2023-2024, I have been informed that letters of awards have already been issued to 146 beneficiaries for a total amount of 33.8 million rupees. Disbursement is effected as and when valid invoices are being submitted by the respective beneficiary cooperative societies to my ministry. Mr. Speaker, sir, insofar as the last part of PQB 574 is concerned, that is the processing time for the allocation of funds, I wish to inform the House that applications received are processed in a timely manner and is contingent upon their completeness and accuracy. The processing of an application involves the following step. A review of the application and project write-up with a view to ensuring that besides complying with the established eligibility criteria, it has submitted all the required documents and information, the evaluation of the project by a technical committee set up, the approval and issuance of a letter of award once the evaluation is complete, and the disbursement of funds upon submission of valid invoices and confirmation of project milestones.
Thank you, Mr. Speaker, sir. Can the Honourable Minister provide a breakdown of the number of beneficiaries under each grant scheme and the corresponding amount approved for disbursement for the financial year 2023-2024?
As I told in my reply, 146 cooperative societies beneficiated for an amount of 33.8. For each of them, Boost to Local Production Scheme, a total amount approved was 20.5 million for 78 cooperatives. For Livestock Farming Project, 3.5 million was approved for 18 cooperative societies. For the zero budget natural farming scheme, 1.5 million was approved for 8 cooperative societies. For waste recycling scheme, 205,000 rupees for 1 cooperative society. And for seedling production scheme, 7.8 million for 41 cooperative society. As for the digitalization scheme, this is a new scheme announced in the budget speech, and the criteria allocation for grant of these schemes is being worked out.
Thank you, Mr. Speaker. Sir, can the Honourable Minister state if there is any training component associated with the grant schemes to ensure that cooperative societies are well prepared to implement their projects effectively?
Yes, at the Ministry of Cooperatives, at the Division of Cooperatives, there is a comprehensive training program associated with each grant scheme, and the societies have to undergo a training program at the National Cooperative Society, which is the training arm of my ministry.
Next question.
B571.
Mr. Speaker, sir, Government of Mauritius is actively following at least 2 cases at the level of the International Court of Justice concerning the cause of Palestinian people. First case is the case of the advisory opinion, and the second case is the case concerning on the genocide treaty. Mr. Speaker, sir, on the first case of the advisory opinion, it is to be recalled that on 22nd of February of this year, Mauritius participated in the oral hearings at the International Court of Justice on the request for an advisory opinion pursuant to the United Nations General Assembly Resolution 77/247 pertaining to the question of Palestine. On the second case, namely under the genocide treaty, it is to be recalled that on 29 December 2023, South Africa filed an application instituting proceedings against Israel concerning alleged violations by Israel of its obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, commonly referred to as the Genocide Convention, in relation to Palestinians in the Gaza Strip. In its application, South Africa also requested the court to indicate provisional measures in order to protect against further severe and irreparable harm to the rights of the Palestinian people under the Genocide Convention, and to ensure Israel's compliance with its obligations under the Genocide Convention, not to engage in genocide and to prevent and to punish genocide. In that case, Mr. Speaker, sir, public hearings on South Africa's request for provisional measures were held on 11 and 12 January 2024. The ICJ delivered 2 orders on provisional measures, Mr. Speaker, sir. The first one on 26 January 2024, and the second one on 24th May 2024. Mr. Speaker, sir, in line with its principled stance for the upholding of international law, Government of Mauritius supports all initiatives with the aim of upholding the respect for international law, including on the question of Palestine. Thank you, Mr. Speaker, sir.
Yes, thank you. Okay, since the Honourable Minister has mentioned about support, can I ask him whether government will support and sign a petition that was coordinated by Mrs. Rajni Lala of Mouvement Libération Femmes, dated 12th of June 2024 and submitted to the Honourable Prime Minister through his office, seeking support across the political spectrum to support the South African ICJ case, just like leaders of other political parties in Mauritius have. Mauritius Labour Party, MMM, PMSD, l'Union Maurice, and Lalit, and even Nouveau Démocrate.
Mr. Speaker, sir, I will need a specific question to that, because I have not seen that petition. I understand from the question that it was addressed to the Honorable Prime Minister. I can surely look into that. The House and the population at large will appreciate the stand taken by Mauritius as a country which has been consistent over the years. It has not evolved with this government or that government. The state of Mauritius has consistently supported the Palestinian people in all forums. If I have to name all the resolutions and in different forums, whether in Geneva or New York, I will have to take hours of the House. But there has been consistency. In fact, let me recall also that formal diplomatic relations were established between Mauritius and the state of Palestine ever since 1988, Mr. Speaker. And we have been consistently supporting the Palestinian cause.
Question sufficiently canvassed. Honorable Bodan, next question.
Thank you, Mr. Speaker, sir. B/572.
Mr. Speaker, sir, ensuring availability of quality and nutritious food and access thereto have always been a priority of this government. In this respect, we have been and are still making every possible effort to at least sustain the local production in sectors where we are already self-sufficient and to increase production in other sectors to meet our requirements. Mr. Speaker, sir, currently some 40 different types of vegetables, root crops, and spices are cultivated by both small planters and corporate growers across the island, so much so that with a production of over 150,000 tons per year, we are today self-sufficient in fresh food crops. Indeed, Mr. Speaker, sir, since 2019 onwards, our local production has increased from 96,900 tons to reach approximately 154,000 tons in 2023, representing an increase of 58.8%. This has been possible, amongst others, due to an increase in the area under cultivation from around 7,400 hectares to 9,000 hectares over the period 2019 to 2023. Increased production under sheltered farming, such as hydroponics and net houses, which in general produce more and better yields and have a higher productivity under the same area, and also numerous facilities, support and assistance given to planters through a panoply of schemes being operated by my ministry. For the period January to April 2024, Mr. Speaker, sir, I'm informed that only 31,199 tons of fresh food crops have been produced. This is mainly due to the extreme weather conditions that have prevailed since the beginning of this year. Mr. Speaker, sir, Mauritius, like many small island developing states, is dependent on the importation of food. In fact, we import almost 75% of our food requirements. Although most of our fresh vegetables needs are locally produced, items such as rice, wheat flour, and cereals, which constitute our staple food, cannot be cultivated locally due to our limited size and because these specific crops are not adapted to the local climate and thus have to be imported. Some vegetables are also imported for niche markets and after calamities, such as cyclones, when our local production is affected. According to figures from the Mauritius Revenue Authority, the quantity of imported vegetables, excluding potato, onion, and garlic, decreased from around 24,204 tons in 2019, with a cost, insurance, and freight value of approximately 1.1 billion rupees to around 22,987 tons in 2023, with a CIF value of approximately 1.8 million rupees. It is to be noted that the increase in CIF value is largely due to an increase in freight cost. I'm informed that from January to the 3rd of July of this year, around 14,779 tons of vegetables have been imported for a CIF value of approximately 1.2 million rupees. In fact, a larger quantity of vegetables such as carrots, cabbages, sweet peppers, beans, and beetroots, amongst others, had to be imported following the passage of Cyclone Belal and the adverse weather conditions I mentioned earlier. I should also mention, Mr. Speaker, sir, that to boost our local production, a range of measures, schemes, and support are being extended to farmers. However, our scope for action is severely constrained by the vagaries of climatic conditions and its related consequences. For instance, water scarcity, droughts, soaring temperatures, precipitations, floods, cyclones, and increasing incidence of pests, all of which affect our local production. This is the reason why my ministry is encouraging planters to adopt climate-resilient practices. Mr. Speaker, sir, with regard to strategic crops, which consist essentially of potato and onion, and the local production of which represents a significant component of our agricultural industry, I'm informed that the local production of potato increased by 11.4% from 14,822 tons in 2019 to 16,518 tons in 2022. A slight decrease to 13,719 tons was recorded for the year 2023 in view of unfavorable climatic conditions, which brought about an increase in the incidence of pests and diseases and bacterial wilt, for which there is no remedy so far. As for onions, the local production increased from 3,219 tons to 5,402 tons from 2019 to 2023, representing an increase of 67.8%. Furthermore, potatoes and onions being seasonal crops, we are compelled to import these off-season to supply our local market. In 2019, we imported 6,960 tons of potatoes, while 8,004 tons were imported in 2023 for an amount of 233.9 million rupees. And for the period January to June this year, around 12,669 tons of potatoes were imported, as local production had been destroyed again following the passage of Cyclone Belal and adverse weather conditions. For onions, Mr. Speaker, sir, imports decreased by 20.7% from 14,727 tons in 2019 to 11,676 tons in 2023, costing us 312.8 million rupees. Concerning the local production of fresh fruits, Mr. Speaker, sir, such as bananas, pineapples, melon, pawpaw, watermelon, strawberry, lychee, longan, mango, and avocado, same was 20,791 tons for the year 2019, and the production increased by 10.6% to reach 22,992 tons in 2023. Since most of our fruits are seasonal and are not available all year round, we have to import fruits as well. In 2019, we imported 27,632 tons of fresh fruits. This decreased to 26,945 tons in 2023. The importation figure for the period January to 3rd July 2024 stood at 15,391 tons for a CIF value of 1.1 million rupees. Mr. Speaker, sir, it is not a secret to anyone that the livestock sector faces many challenges, such as a decline in traditional backyard production, which operates singly on a low input, low output system of production, the lack of breeders due to an aging population of breeders, decline of interest in this field, scarcity of land for grazing and pasture, and the environmental threats that livestock breeding pose to our groundwater. Nonetheless, Mr. Speaker, sir, we are since some years now self-sufficient in poultry. In fact, the production of poultry increased from 51,000 tons in 2019 to 59,200 tons in 2023. As regards to beef, goat, mutton, and pork meat, the local production has remained quasi-constant over the past 5 years, with a production of 2,667 tons in 2023. On the other hand, our milk production has increased by around 11.5% from 2.5 million liters in 2019 to 2.8 million liters in 2023. As regards local honey production, Mr. Speaker, sir, which also forms part of the livestock sector, an increase of 32% has been recorded from 25 tons in 2019 to 33 tons in 2023. The importation figures in the livestock sector has also been on the decreasing trend. Around 17,115 tons of items such as frozen meat, frozen poultry products, chilled, processed, and pre-cooked meat, canned beef, mutton, and poultry products, and natural honey, amongst others, were imported in 2020. This figure decreased to 16,454 tons in 2023. Thank you, Mr. Speaker.
Minister, for his extensive reply. May I ask the Honourable Minister, he said that the crop acreage has increased. So I wanted to know whether it has increased among the small planters or whether it has increased among the big producers.
Well, for me, it's both the small planters and also the corporate growers as well. As you're already aware that some have moved out of sugarcane and went into other crops. So we've seen that trend both among the corporate growers and also among the small farmers as well.
Please.
One more. Yeah. Can the minister consider the possibility of having price support to boost production in certain specific areas, in certain specific crops?
I mean, we are already subsidizing a number of crops. Those are what we call strategic crops. I mean, if we look at potatoes and onions, the prices are, in a way, controlled, if I may say so. And you will recall that during the post-Belal time, we had to intervene through the Ministry of Finance to provide that a number of crops, other than potatoes and onions, like carrots, beans, cabbages, and even chilies, were being imported and were being put on the market at the subsidized price. So the government do intervene as and when the need is felt.
Next question.
B573.
Mr. Speaker, sir, antimicrobial resistance, AMR, occurs when bacteria, viruses, fungi, and parasites mutate over time and no longer respond to conventional medications documented for the therapeutic use. At the G20 meeting held in 2022-2023, it was unanimously agreed that antibiotic resistance is among the top 10 global public health threats and represents an urgent health challenge for the next decade. The committee, inter alia, recommended that to better address the antimicrobial resistance threat, robust surveillance and monitoring are required globally. In addition, scaling up collaborative, coordinated, One Health AMR surveillance, risk assessment, and interventions have to be reinforced by all member countries. In this context, a One Health Steering Committee on AMR and zoonosis was set up in 2023 to oversee the implementation of action plans related to AMR and to ensure that the prevalence of AMR decreases in the country. Thereafter, a new action plan, national action plan on AMR, has been developed in collaboration with the World Health Organization, and same was approved by my ministry in 2024. The action plan focuses on the One Health approach, which comprises multiple strategies that the country will employ to combat AMR. As such, it ensures the continuity of successful evidence-based treatment and prevention of infectious diseases with effective, safe, and rational use of medicine. Mr. Speaker, sir, firstly, it has been observed antibiotics are misused without unnecessary prescriptions from doctors who prescribe them to treat flu, bronchitis, and other illnesses not caused by bacteria, or without properly testing and diagnosing the patient first. Secondly, self-medication by patients who take leftover antibiotics from other people is very well known in the country, while some patients do not complete their course of antibiotics as prescribed by their doctor. Thirdly, some pharmacists dispense antibiotics to the public without a doctor's prescription as established in the Pharmacy Act, while some doctors prescribe underdosed antibiotics or antibiotics for an exceedingly long duration. And fourthly, prophylactic use, that is, utilization as a preventive measure in the agricultural or veterinary sectors, can lead to antimicrobial resistance. Mr. Speaker, sir, in order to better evaluate progress, national indicators on AMR were created in 2023. Outbreaks of AMR occurring in all regional hospitals are notified every month, and investigations are carried out by infection prevention control teams. Furthermore, isolation rooms are under construction in several hospitals, while the one at SSR Hospital is already operational. In addition, isolation bays were also added to the NICU of SSR and Hospital in 2023, so as to isolate infants infected with multi-drug resistant organisms. Mr. Speaker, sir, my ministry submits data on AMR annually to WHO's Global Antimicrobial Resistance and Use Surveillance System, GLOS, while antibiograms created using this data are being uploaded on the Mobianet app for use by healthcare workers. Mr. Speaker, sir, antimicrobial stewardship teams comprising of specialists in internal medicines, registered medical officers, IPC, nursing officer, and pharmacists have been set up this year for each health region with a view to reducing the misuse of antibiotics. In the same breath, the national guideline on antibiotics was endorsed by the ministry in January 2024 with a view to helping to guide healthcare workers to optimally use antibiotics.
Thank you, Mr. Speaker, sir. From his reply, the Minister mentioned that there is a misuse of antibiotics. May we thus know what is being done at the level of his ministry to prompt medical practitioners to prescribe antibiotics optimally? Thank you.
Yes, Mr. Speaker, sir. As already stated, antimicrobial stewardship teams have been set up in this year in each region. This will help to reduce the misuse of antibiotics. National guideline on antibiotics was endorsed by ministry again this year. This again will help to guide healthcare workers to optimally use antibiotics. CMEs on AMR were conducted in last year, 2023. New presentations on AMR being developed this year, and antimicrobial stewardship teams are expected to carry out new CMEs in each region, as well as a diploma course, IPC and AMR, was organized by MIH and Bordeaux, which ended last month. That is last month in June 2024.
Next question, MP Béranger, absent. MP David.
B576.
Mr. Speaker, sir, I'm informed that Kensington in Pointe-aux-Sable falls under the CWA's water supply zone, Port Louis. The regions of Grande Rivière Northwest and Port Louis West are supplied with potable water from three sources, namely Pai Water Treatment Plant, which receives raw water from municipal dike, Bagatelle Water Treatment Plant, which is fed with water from Bagatelle Dam, and Pierrefonds Tunnel. The Pointe-aux-Sable region, including Kensington, is primarily supplied with potable water sourced from the new Bosquet Reservoir. This reservoir receives water from the Pierrefonds Tunnel and the La Forge borehole. Currently, the water supply to approximately 4,100 subscribers in Pointe-aux-Sable is on a 24-hour basis, except the Kensington area, where some 100 CWA subscribers experience intermittent water supply during peak hours, resulting in low water pressure since it is located on the highest spot. In response to this challenge, the CWA has planned improvement works. These include pipe laying works to boost pressure and flow to the Kensington area from the La Forge borehole. Additionally, there will be an upgrade of the La Forge borehole pump, thereby increasing daily production for Pointe-aux-Sable region from 2,100 meter cube per day to 4,000 meter cube per day. I am informed that these enhancements are expected to be completed by the end of July 2024. Once these works are implemented, it is expected that residents in the Kensington area will have a significant improvement in water supply and pressure. I thank you, Mr. Speaker.
Merci, Monsieur le Président. J'ai bien entendu donc le calendrier des travaux qui prendront fin juillet, donc à la fin de ce mois-ci. En attendant que ces améliorations soient faites et effectives sur le réseau de distribution d'eau à Kensington, puis-je demander au ministre s'il pourrait envisager auprès de la CWA une fourniture plus régulière d'eau à travers les camions-citernes auprès de ces 150-160 familles qui sont réellement en souffrance quotidiennement.
Yes, Mr. Speaker, sir, I shall convey the message of the request of the honourable member to the CWA.
Next question.
7.
Mr. Speaker, sir, in the aftermath of COVID-19 pandemic in 2020 and its impact on workplaces, the National Training and Reskilling Scheme was introduced as one of the components of the Economic Recovery Program. The main purpose of the scheme is to assist those who have lost their jobs due to COVID-19 pandemic by training and reskilling them so that they can rejoin the workforce, and also to ensure that people are work ready by improving their employability skills once the economy recovers from the impact of the pandemic. The NTRS targets unemployed individuals between 16 and 59 years. Training costs and stipend payable to trainees under the scheme are borne by the government through the Ministry of Finance, Economic Planning and Development. Mr. Speaker, sir, I am informed that the HRDC is implementing the NTRS since January 2021 in collaboration with various stakeholders. The courses are dispensed through training institutions registered with the MQA or the Higher Education Commission. In principle, the HRDC receives applications for training courses from industry associations, government-funded institutions with training capabilities, and Rodrigue Regional Assembly. courses under the NTRS have to be approved by either the MQA or HEC. Industries associations choose their own registered training institutions based on their skills, needs, and capabilities of registered training institutions to mount NTRS courses. The MITD also partners with the HRDC to implement courses under the NTRS. Mr. Speaker, sir, I am informed by the HRDC that since the start of the scheme in 2021 up to 30th of June 2024, 16 registered training institutions have been providing training under the scheme. During the same period, a total amount of 78,662,045 rupees was paid to these 16 institutions during 3 financial years as follows: 2021-2022, 18,452,365 rupees; 2022-2023, 30,317,778 rupees; 2023 and 2024, 29,891,902 rupees. Mr. Speaker, sir, as requested by the honourable member, I am tabling the list of the training institutions and the amount paid to each of them under the NTRS during the last 3 financial years.
Thank you, Mr. Speaker, sir. Will the Honourable Minister inform the House if any research or survey has been carried out to identify areas where skills development are needed in view of the emerging demands of the labour market?
Well, Mr. Speaker, sir, the honourable member must come with a specific question, as this question pertains to the economic recovery programme and the course delivered by the NTRS.
Next question.
B578.
Mr. Speaker, sir, the Central Water Authority operates an extensive potable water distribution network covering all sectors of the economy with a total length of 5,246 kilometers. Within this network, approximately 1,500 kilometers of pipelines ranging from 50 to 80 years old are outdated and exhibit significant deficiencies, including substantial losses, frequent bursts, and inadequate carrying capacity. These aging pipes, composed of asbestos cement, cast iron, galvanized iron, steel, and polyvinyl chloride, are challenging to repair and account for 50 to 60% of the system's wastage. To address this issue, the CWA has prioritized the replacement of about 500 kilometers of these critical pipelines across all 6 water supply zones for the calendar years 2023 and 2024. The CWA's strategy for the replacement program comprises the following: A, in-house replacement plans that focuses on the replacement of pipelines less than 1 kilometer in length. B, through small and medium contractors that target pipe replacements between 1 kilometer and 3 kilometers, specifically on medium lateral roads and unclassified roads throughout the island. And C, capital projects that concentrate on the replacement of pipelines exceeding 3 kilometers, primarily on classified RDA roads. Mr. Speaker, sir, I am informed by the Central Water Authority that Great Standard Solution Limited has been awarded 5 contracts for the renewal of service mains and replacement of pipeline under the pipe replacement program in the regions of Bramstan, Bel Air, Isidore Rose, and Plaine Magnon. Mr. Speaker, sir, the CWA has informed that Bramstan region received its potable water supply from Reservoir Bonne Mer and a containerized filtration plant at Bramstan. To address leakage in the existing water distribution network, CWA has planned a comprehensive pipe replacement project spanning approximately over 6.9 kilometers. This project has been divided into 4 phases. I am informed that Great Standard Solutions Limited has been awarded contracts for 2 phases, namely 1, renewal of service main in the region of Bramstan, Zone 4, awarded on the 9th of February 2024 with a contract value of 7,758,098.25 rupees. The project began on 18th March 2024 and is scheduled to be completed by end of July 2024. CWA has informed that 1.8 kilometer of pipelines is planned for replacement. The project covers several roads in Zone 4 of Bramstan, such as Lagete Road and Laterals and Shivala Road. 2, renewal of pipeline in the region of Bramstan along Dominic Road, Kalimai Road, number 1, Gibbon Lane and Laterals, awarded on the 25th of March 2024. The contract is valued at 7,537,962.08 rupees. The project started on 13th May 2024 with a scheduled completion date set for 11th August 2024. As of now, 0.23 kilometers of the planned 1.3 kilometers of pipelines have been laid. Mr. Speaker, sir, the Bel Air region is supplied with potable water from Reservoir Belrose and Borehole 42C. Its aging network is subject to frequent leaks and bursts that disrupt water supply, and to address these issues, CWA has identified approximately 7.7 kilometers of pipes for replacement. The project is divided into 4 phases. I am informed that Great Standard Solutions Limited has been awarded on the 1st of April 2024 the contract for 1 phase, namely the renewal of the service main along Railway Road, Damri Road, Dorbeck Road, and their respective laterals in the region of Bel Air Flag. The contract is valued at 8,429,908.20 rupees. The project started on the 19th of June 2024 with a scheduled completion date set for 18th September 2024. Mr. Speaker, sir, the region of Isidore Rose received its potable water supply from Constance and Bonne Mer reservoirs. The aging AC pipes in the current network cause significant disruptions in water supply due to frequent bursts and leakage. To address same, CWA has identified approximately 1.4 kilometers of pipelines for replacement in the region. The contract for renewal of pipeline along Swami Vivekananda, Palmier Road, Kalimai Road, and Baiswa Road in the region of Isidore Rose was awarded to Great Standard Solutions Limited on 31st of May 2024 with a contract value of 8,462,334.30 rupees. The tentative start date is the end of July 2024 with a scheduled completion date by the end of September 2024. Mr. Speaker, sir, I am informed that the region of Résidence Balance in Plaine Maillan relies predominantly on aged AC pipes for its water supply infrastructure. Frequent bursts and leakages severely affect water distribution in the area. To alleviate these issues and enhance water supply reliability, approximately 1.2 kilometers of pipelines have been identified for replacement in the region. I am informed that the project for renewal of pipeline at Résidence Balance, ex-Cité, Plaine Maillan, has been awarded to Great Standard Solutions Limited on the 28th March 2024 for a value of 7,407,235.50 rupees. Work started on the 13th of May 2024 with a scheduled completion date of 10th August 2024. As at date, I am informed that 600 meters of HDPE pipe have already been laid. I thank you, Mr. Speaker, sir.
Si, Monsieur le Président, si mon compte est bon, 37 millions, plus de 37 millions de roupies à Great Standard Solution Limited, incorporé, Monsieur le Ministre, en février 2023. La question qui se pose, Monsieur le Ministre, est-ce que Great Standard Limited, puisque ces pipes, ces tuyaux sont sous terre, quelle garantie la CWA a que Great Standard Limited, avec quelques mois d'existence, a l'expérience voulue pour la pose de ces pipes à la hauteur de 37 millions de roupies?
Mr. Speaker, so I cannot reply on that because I don't have the details with me. It is for the CWA to assess the contractor whenever they are allocating contracts to that contractor, whether he has the required experience to carry out works that will be entrusted to him.
Next question.
Thank you, Mr. Speaker. B7579.
Mr. Speaker, sir, it has been a long-standing practice over the years for students following full-time courses at tertiary institutions to have a job placement in organizations, including in the public sector. In some cases, the job placement may form part of the mandatory academic requirements of the universities concerned. However, the job placement for the university student was being done in the public service without a proper framework. In that context, my ministry has come up with a defined structure where a centralized digital platform has been developed to facilitate work placement of university students in the public service. The objective of this initiative is to promote transparency, accountability, visibility, equity, and fairness in the treatment of requests for job placement. Mr. Speaker, sir, in spite of the fact that working in the public sector is hectic and demanding, many young graduates are willing to join and embrace a career in the public service. My ministry recognizes that young talents have an instrumental role to play in the socio-economic development of our country. Indeed, the public sector provides an unmatched and attractive work environment in view of its diversity, complexity, and stable organization setup. Such an environment represents a unique value proposition for our university students to gain valuable insight. Mr. Speaker, sir, my ministry issued a circular letter number 50 of 2nd July 2024 to all ministries and departments to inform them that the operationalization of the centralized work placement scheme. Some of the salient components of this scheme are as follows. First, the scheme targets undergraduate and postgraduate Mauritian students who are enrolled on full-time courses in tertiary education institutions in Mauritius and which are accredited by the Higher Education Commission. Application for work placement should be submitted by the tertiary education institutions on the centralized digital platform for and on behalf of the student. My ministry will thereafter channel the student to the respective ministry department of the parastatal organization. The work placement will not exceed 3 months. A monitoring and evaluation mechanism will be put in place by my ministry to ensure the work placement undertaken by students in the respective ministry and department and parastatal organization are relevant and have contributed to the employability. Stipends amounting to 750 rupees per week, inclusive of transport, which may be subject to revision, will be met under the vote item of the respective ministries, department, and parastatal organizations.
Thank you, Mr. Speaker. So may we know from the Minister when this scheme will be launched?
Mr. Speaker, I'm informed that my ministry will officially launch the scheme on 18 July 2024, followed by a training session for all users nominated by the University, Ministry and Department in order to ensure a seamless implementation of the scheme. Thank you.
Okay.
Thank you, Chair. B580.
Mr. Speaker, sir, food security remains the priority of this government. As indicated in my reply to Parliamentary question B518 last week, efforts of my ministry are geared primarily towards the improvement of our food security, especially with the repercussions of global strife and adverse climatic conditions which bring about food shortage. This explains the reason why my ministry has elaborated a strategic plan on our food system for the years 2024-2030. Mr. Speaker, sir, this plan has been worked out following une assise de l'agriculture held in March last year and which was attended by some 150 experts, academia, researchers, and stakeholders from the public and private sectors, including farmers, Outer Island Development Corporation, and the Rodriguez Commission for Agriculture. The strategic plan is aligned with the Sustainable Development Goal, SDG 2, which is to end hunger, achieve food security, and improved nutrition and promote sustainable agriculture. It highlights all the current and upcoming challenges in the agricultural sector and the related areas of intervention. It also builds on achievements and on lessons learned over the last 5 years while addressing and mitigating the identified shortcomings. In this respect, cluster analysis have been made for the food crop sector comprising of potato, onion, garlic, cucurbits, crucifers, legumes and pulses, starch crops, tomato and fruits, and our livestock cluster that is on the production of poultry, cattle, deer, goat, sheep, pig, and apiculture. Provisions for Rodriguez and Agalega has also been made in the plan. It is to be highlighted that the plan excludes fish production, which falls under the Ministry of Blue Economy, Marine Resources, Fisheries, and Shipping. As per the plan, our agricultural sector is expected to grow at an average rate of 6% per year over the next 5 years. Mr. Speaker, sir, to achieve this target, the plan makes provision for a three-pronged approach. Firstly, boosting production of resilient food security. The targets are to increase production of food crops by 15% under open field, increase production by 100% under protected structures, increase meat production by 50%, and increase honey production by 20%. The areas of intervention are to develop and upgrade appropriate production infrastructures, improve access to inputs, like planting materials and animal feed, and research and development. Secondly, promoting sustainable and resilient production. The targets are to train all farmers in sustainable agricultural practices and increase by 10% acreage under sustainable agriculture. The areas of intervention are geared towards sustainable agricultural practices, integrated pest and disease management, promotion of biofarming, and developing smart and innovative production systems. And thirdly, encouraging entrepreneurship and agro-processing. The targets are to train 100 agro-entrepreneurs per annum with a view to increasing by 10% per annum the number of entrepreneurs involved in agribusiness. The areas of intervention are to promote value addition, develop appropriate market structures, and capacity building and professionalization of operators and institutions. Mr. Speaker, sir, it is good to note that the targets have been set in line with the government program and Vision 2030. In addition, the areas of interventions in the strategic plan are pursuant to international and regional commitments such as the United Nations SDGs, the United Nations Food Systems Summit, the Comprehensive Africa Agriculture Development Programme, the Southern African Development Community, SADC Plant Genetic Resources, the SADC Harmonized Fertilizer Regulatory Framework, SADC Harmonized Seed Regulatory System, the World Organization for Animal Health, the Indian Ocean Commission Regional Programme for Food Security and Nutrition, as well as the agricultural commitments to the United Nations Framework Convention on Climate Change, as outlined in the nationally determined contributions. Mr. Speaker, sir, the strategic plan will thus ensure inclusive participation of all stakeholders in line with the United Nations approach to leave no one behind in the transformation of our agri-food systems into a more efficient, inclusive, resilient, and sustainable one, and for better production, better nutrition, as well as for a better environment and better quality of life. I must also say, Mr. Speaker, sir, that the strategic plan acknowledges the constraints and challenges faced by the agricultural sector. As we all know, the sector is continuously facing several threats and emerging challenges, namely climate change and its adverse impacts, health emergencies, land scarcity, aging farming population, lack of quality standards, as well as international conflicts, amongst others. As a consequence, building resilience is critical for vulnerable small island states like ours. Mr. Speaker, sir, the strategic plan also focuses on strengthening the governance, regulatory, and institutional capacity of the agricultural sector at local, regional, and international levels. There is thus need to develop appropriate legal and institutional frameworks to enable its effective implementation, as well as create a right and enabling environment for the agriculture sector development and a sound governance systems. Same are underway. Pending the release of the strategic plan, which is for soon, Mr. Speaker, sir, various measures have been taken to boost the agricultural sector, the details of which I have provided in my reply to Parliamentary question B572. The House may wish to note that we are self-sufficient in local food crops and poultry. Our milk and honey production are increasing gradually, while our importation in fresh fruits is on the decreasing trend. Thank you, Mr. Speaker, sir.
Thank you, Chair. Given that the government has been in power for nearly 10 years now, is the Minister aware of the growing public dissatisfaction and loss of confidence in the government ability to achieve?
This is not a supplementary question, you see. You should know by now what is a supplementary question, honorable member. You can't make comments and observation and supplementary question and debate. Where have you learned all this? Where did you see that? Put your question if you have one.
What measures are being taken to restore public confidence and provide a tangible results in self-sufficiency?
Well, Mr. Speaker, sir, had the honourable member listened to the previous question put to me by Honourable Boda, he would have got the reply already.
So we move to the next question.
B582.
Mr. Speaker, sir, I am informed that for the period 2019 to date, a total of 449 drug users under the age of 18, of which 7% girls were admitted in our public health institutions, namely Nénuphar, Frangipane, and Orchidée, for detoxification and rehabilitation, and also in hospitals as follows: 138 in 2019, 89 in 2020, 59 in 2021, 54 in 2023, 77 in 2023, 32 in 2024, that is up to date. Moreover, for the same period, 309 minors, of which 7% were girls, have attended the addiction treatment units of my ministry as follows: 74 in 2019, 74 in 2020, 85 in 2021, 36 in 2022, 31 in 2023, 9 in 2024. Mr. Speaker, sir, as regards to part B of the question, I'm informed that at the Nénuphar Center, in 2019, among 99 cases, 53 were readmissions. In 2020, there were 65 admissions and 22 were readmissions. 2022, 85 admissions, 53 were readmissions. 2023, among 89 admissions, 43 were readmissions. That is around 50% of youngsters who have been admitted at Nénuphar ward have been stabilized for a period of time or are in the process of being stabilized. Since addiction is a chronic illness characterized by the possibility of relapses and which requires long-term and in some cases lifelong care. The main objective of any treatment given to a drug user is to stabilize the patient on medical, psychological, family, societal, social, and professional level to enable the latter to reintegrate the mainstream society. However, such treatment, care, and support vary from one individual to another. The harm reduction unit of my ministry currently offers the following treatment programs for drug users, including minors: medication-assisted treatment, including methadone substitution therapy, and detoxification using Suboxone and naltrexone, and residential rehabilitation centers at Long Mountain, Nénuphar Center, Centre Frangipane, and Centre Orchidée at Beaubassin. The psychosocial aspect in the management of drug users is carried out by psychologists and healthcare professionals with the collaboration of a number of NGOs. In addition, the following therapies are also provided to the patient: family therapy, group therapy or therapy, emotion management, sports, cognitive behavioral therapy, music and basic skills, among others. Mr. Speaker, sir, with regard to part C of the question, I'm informed that according to statistics received from the police medical unit, 6 deaths due to overdose have been recorded among those below 18 years old from 2019 to 2023. Thank you.
Honorable Ministre, peut-il nous dire s'il existe des mesures d'accompagnement aux parents des enfants usagers de drogue qui sont en détresse?
Yes, Mr. Speaker, sir. Already stated in my replies, therapies include family therapy, group therapy, and all the therapies existed, that is l'accompagnement pour des parents.
Next question.
Thank you, Mr. Speaker, sir. B583.
Mr. Speaker, sir, artificial intelligence is increasingly transforming various aspects of education, providing new opportunities to enhance learning, teaching, and administrative processes. However, generative AI, with its ability to autonomously create content, presents both exciting opportunities and significant challenges in education. Post-pandemic, a wide array of open AI sources, software, and applications, such as ChatGPT and Microsoft Copilot, have been increasingly used. In the education sector, students have readily embraced these AI tools as part of their educational journeys to enhance their learning, and so have educators and lecturers as part of their teaching experiences. Mr. Speaker, sir, as stated in the UNESCO document, Generative Artificial Intelligence in Education, Think Peace, Despite its numerous benefits, the integration of generative AI in education presents several challenges. Ethical concerns are significant, ranging from over-reliance on AI tools, reduced engagement, and active learning, and a possible decline in critical thinking and problem-solving skills to issues related to data privacy and intellectual property rights. There is a need to harness AI's potential while safeguarding educational standards and ethical considerations. It must be highlighted that at the international level, UNESCO recently produced the first ever global standard on AI ethics, the Recommendation on Ethics of Artificial Intelligence, a framework adopted by all 193 member states. It stresses that governments must ensure that use of AI always adheres to the principles of safety, inclusion, and diversity, transparency, and quality. In fact, not later than in May 2024, a UNESCO global survey of over 450 schools and universities found that fewer than 10% have developed institutional policies or formal guidance concerning the use of generative AI applications. Mr. Speaker, sir, controlling the use of AI in tertiary education to maintain examination standards is indeed complex and yet crucial. Our higher education institutions are aware of the challenges and risks associated with AI tools, particularly regarding assessment, student evaluation, and academic integrity. To address these concerns, higher education institutions have so far proactively integrated technological tools and established internal guidelines, such as regulations on academic dishonesty, to safeguard the standards of assignments, coursework, projects, and examinations. Tools like Turnitin and SafeAssign are employed to ensure academic integrity and originality in students' project submission. These softwares, along with the traditional role of checking for plagiarism, are now also able to detect contents created with AI. It is important to note that there are acceptable limits for similarity indices concerning generative AI matches in dissertations and other assignments. In addition to these digital safeguards, higher education institutions in Mauritius have clear guidelines on viva voce examinations for all students. Universities appoint external examiners to moderate scripts and examinations, ensuring that marking schemes and results are of the highest standard and free from bias. Mr. Speaker, sir, my ministry is currently working on the use of AI in higher education. An internal technical committee has been set up to prepare the relevant guidelines based on the guidance document from UNESCO for policymakers. HEIs in Mauritius will need to review their evaluation process to ensure that students have a good mastery of the topics dealt with in their assignments. More weighting would be placed on value addition by candidates on topics presented than on content. Thank you, Mr. Speaker.
Yes, please. Thank you, Mr. Speaker, sir. Can the Honourable Minister inform the House whether there will be the new role of educator in regard to AI automating processes?
Mr. Speaker, sir, educators will obviously have to be trained because it's a new situation, and the educators, as I've just stated, as well as the lecturers, because we were talking about the tertiary sector, will be recommended to review their assessment mode, their evaluation mode, and to lay more emphasis on value addition than on content. And it is now, with the new apps available, it is now possible to even detect whether any piece of work has been generated from AI.
Next question.
B584.
Mr. Speaker, sir, there is no doubt that performance, productivity, and delivery of service are linked with the well-being of public officers. Thus, the work environment plays a critical role. The Safety and Health Division and set up under my ministry is responsible for the safety and health matters in respect of public officers in ministries and departments. To this effect, a team comprising of 45 trained and dedicated officers of the Occupational Safety and Health Division is deployed to carry out inspection visits to places of work falling under the broad umbrella of the public service with a view to advising the different ministries and departments on how to comply with the provision of the safety and health legislations. Their role is to ensure that public officers operate in a physical, conducive environment which has a direct bearing on their performance. Each ministry and department from its own budget promotes safety and health within its workplace. Mr. Speaker, sir, the enhancement of work environment program is geared towards uplifting the safety and health standards in the working environment of ministries and departments through funding by my ministry. The enhancement of work environment program refers to a scheme that brings some incremental improvement on a yearly basis to the physical working environment so that public officers can operate in their best possible manner. It provides a meaningful opportunity to the ministry and departments in identifying relevant projects and implementing them with the required funding from the budget of my ministry within one financial year. A fixed amount of 4.5 million had been provided under this scheme for the last 3 years. Since its inception, all ministries and departments have no doubt benefited from this scheme for the implementation of numerous projects aimed at enhancing the work environment of public officers. I am pleased to announce that all the budgeted amount has been fully utilized and have benefited some 78 ministries and departments. Mr. Speaker, sir, as regards Part A of the question for financial year 2023-2024, 205 projects have been funded to the tune of 4.37 million under the Enhancement of Work and Environment Program. The projects funded were categorized under projects for greening of the public sector and safety and health-related projects. With your permission, Mr. Speaker, sir, I am tabling a list of projects funded and the amount disbursed in each case. Mr. Speaker, sir, with regard to the Part B of the question, I am pleased to announce the House that the scheme has been maintained with a total amount of 4.5 million for this financial year 2024-2025. I take this opportunity to thank my colleague, Honorable Minister of Finance, Economic Planning and Development, who has provided this amount to my ministry. Should the need arise, a request will be made to the Ministry of Finance, Economic Planning and Development for additional funds in the light of the number of projects that will be received from my ministry and department in this financial year. Mr. Speaker, sir, enhancing the work environment involves addressing multiple factors that contribute to the overall well-being, job satisfaction and productivity of public officers. This initiative promotes eco-friendly practices within the workplace, improves the physical work environment and fosters a good safety and health culture.
Next question.
Thank you, Mr. Speaker, sir. B/585. Thank you.
Monsieur le Président, j'ai été informé par Landscope Mauritius Limited que les terrains détenus se trouvent principalement dans la région de Côte d'Or, Bagatelle, Hermitage, Valletta et Belle-Rive. À ce jour, Landscope Mauritius Limited a loué environ 731 arpents de terrains agricoles à 79 planteurs dans les régions mentionnées. Landscope Mauritius Limited ne possède pas de terres dans les régions de la Marie, Glen Park et Plaine Sophie. Merci.
Est-ce que je peux demander à l'honorable ministre quels sont les critères pour l'allocation de ces terrains?
Monsieur le Président, je n'ai pas ces renseignements avec moi. Je vais trouver les informations et déposer à la Chambre.
Question, Monsieur le Président. Est-ce que je peux demander à l'honorable ministre le nombre d'applications pour ces terrains?
Encore une fois, Monsieur le Président, je vais trouver les informations et déposer à la Chambre.
Next question.
B586.
Mr. Speaker, sir, on Tuesday, the 2nd of July 2024, at around 10 hours, my ministry was informed by the Pointe-aux-Sables police station of the presence of heavy fuel oil in a watercourse located next to the Pointe-aux-Sables public beach. A team of officers comprising officers of the Department of Environment of my ministry, the Police de l'Environnement, the Special Mobile Force, and the National Coast Guard immediately proceeded on site. 2 patches of heavy fuel oil of an area of about 10 square meters were observed near the bridge and along the banks of the watercourse upstream. No oil was observed in the lagoon. Subsequently, other stakeholders, including the Ministry of Blue Economy, Marine Resources, Fisheries and Shipping, the Water Resources Unit, the Forestry Service, the Solid Waste Management Division of my ministry, the City Council of Port Louis, the Beach Authority and the Mauritius Ports Authority were informed and requested to initiate actions at their level. Following an inquiry on the matter, the Police de l'Environnement served a fixed penalty notice of 25,000 rupees on the 3rd of July 2024 for causing to be deposited heavy fuel oil into watercourse at Pointe-aux-Sables, Latouquenique region. Mr. Speaker, sir, as regards Part A of the question, preliminary investigation conducted by my ministry and the Police de l'Environnement sourced the oil spill from FM Denim Company Limited, located at SLDC Industrial Park, Latouquenique. Around 20 liters of heavy fuel oil leaked into a stormwater drain leading to a watercourse. With regard to Part B of the question, in accordance with the Environmentally Sensitive Areas GIS Datasets 2013, this stormwater drain is classified as a canal without any categorization and is therefore not considered ecologically sensitive. Following prompt intervention, the spill has been contained in the stormwater drain, and tests carried out by the National Environmental Laboratory of my ministry showed that there has been no contamination of the lagoonal and seawater. Likewise, ambient air monitoring exercise conducted at 5 sites comprising the affected area and nearby residential areas revealed that all toxic gases measured were below the detection limits and no odor was discerned in the surrounding. Monitoring of water quality and ambient air quality is being maintained by the National Environmental Laboratory. Mr. Speaker, sir, monitoring of seawater quality was also conducted by the Albion Fisheries Research Center at 3 stations located along the shoreline at Pointe-aux-Sables on the 2nd and 3rd of July 2024. I am informed that the test results of samples analyzed were within the limits of coastal water quality guidelines for parameters tested. No oil and grease was detected at the monitoring stations. According to the National Parks and Conservation Service of the Ministry of Agro-Industry and Food Security, a site visit conducted on the 4th of July 2024 revealed that no damage occurred to wetlands, migratory birds, endemic plants, and any freshwater living organisms during the oil spill. Mr. Speaker, sir, concerning Part C of the question, the following actions were taken on site. A total of 477 meters of sorbent booms and 515 absorbent pads were placed in the watercourse to contain and recover the spilled heavy fuel oil by the SMF, National Coast Guard, along with Vivo Energy Mauritius Limited and Polygreen Mauritius Limited, whose services have been enlisted by FM Denim Company Limited. Some 1.5 tons of waste have been collected and carted away for safe disposal. Follow-up of the cleaning operations being conducted by Vivo Energy and Polygreen is being maintained on site by my ministry. The costs incurred by the various stakeholders are being compiled and will be submitted to FM Denim Company Limited, the owner of the pollutant. Mr. Speaker, sir, as regards part D of the question, I am informed that FM Denim Company Limited is envisaging to construct a burn wall around its heavy fuel oil pump in the boiler room to avoid any risk of oil spill in the future. In terms of preparedness and response to potential accidental spill of liquid fuel and or any chemicals of hazardous nature, my ministry started an assessment of industries since 20th of March 2024 to ensure that adequate preventive measures are being taken by these industries where liquid fuel and or chemicals of hazardous nature are being stored in order to prevent any potential spill or other accidents. In line with Section 33 of the Environment Protection Act 2002. In March and April 2024, 146 industries were accordingly requested to submit information in respect to their contingency plan. I am further informed that joint site visits by officers of my ministry, along with concerned authorities, namely the Mauritius Fire and Rescue Service, the National Parks and Conservation Service, National Disaster Risk Reduction and Management Center, the district and municipal councils to 14 industries have been conducted since the 12th of April 2024 to assess any risk of liquid fuel or spill of chemicals. According to Section 60 of the new Environment Act 2024, which will come into force on the 1st of August 2024, any person conducting an activity associated with storing or using of liquid fuel within their premises shall undertake a risk assessment to identify all potential hazards, risks associated with storage of the liquid fuel, and prepare and submit to the Director of Environment a contingency plan to address those risks. The Director may also direct any person conducting an activity associated with storing or using of liquid fuel to review the contingency plan at a specified frequency depending on the level of risk and location of the activity. For an existing activity, the contingency plan shall be submitted within a time frame of 3 to 12 months after the coming into force of the Act. For any new activity, the contingency plan shall be submitted prior to its coming into operation. Any person who fails to comply with this requirement shall commit an offense.
Monsieur le Président, vu la vulnérabilité écologique de la région, de par sa proximité avec cette zone industrielle qui a été donc la cause de cette pollution dans ce cours d'eau, puis-je demander au ministre de l'Environnement s'il compte mettre en place, au niveau des officiers de son ministère, des visites de contrôle surprises chez les opérateurs industriels pour empêcher que de tels accidents de déversement industriel ne se reproduisent dans la région de Pointe-aux-Sables.
Monsieur le Président, comme je l'ai mentionné dans ma réponse, il y a cette enquête qui est en train d'être faite et aussi l'inventaire des industries qui manipulent actuellement ce qu'on appelle les heavy fuel oil, etc. Donc, toutes ces industries ont cette obligation de soumettre un contingency plan en cas de oil spill, en cas de déversement. Donc, nécessairement, il y a ce contrôle qui est fait par les officiers du ministère de l'Environnement. Ça peut être des contrôles avec préavis, mais ça peut être aussi des contrôles sans préavis.
So, time over. The table has been advised that PQB 587, 592, 593 have been withdrawn.
Motion.
Mr. Speaker, sir, I move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
Seconded? Second. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favor say aye, those against say no. Aye. Ayes have it.
Prime Minister's none. Public Bill, second reading.
Honorable Vice Prime Minister.
Mr. Speaker, sir, let us at the very outset be clear about the purpose of the two bills before the House. They guarantee fair and transparent elections. They favor accountability. It is as simple as that. Indeed, Mr. Speaker, sir, true democracy thrives on the prevalence of fair and transparent elections. And for elections to be thus seen, we must promote a level playing field. When parties compete for electoral seats, Mr. Speaker, sir, there is always an expectation for fairness and honest practices. And we have to see to it that all attempts made to skew the process are stymied and nipped in the bud. Mr. Speaker, sir, I will not time and again repeat that members of the opposition decide to leave the parliament whenever there is a serious discussion, a serious debate on. In fact, it shows their mindset. Nothing is good. Everything is fine as long as I'm not disturbed. They feel better sitting in the drawing room or sitting in the lobby than to be here and to represent the people that have elected them to sit into this parliament. They have absolutely nothing to say. And when they open their mouths to say things, I will not use improper words, Mr. Speaker, sir, but it's worth nothing. Mr. Speaker, sir, the issue is in fact a very simple one. When we look at the legislation, the explanatory note explains that clearly. It states the following. The Representation of the People Act is being amended to impose a limit on the election expenses of a political party or a party alliance at a National Assembly election. And that party or party alliance will have a legal obligation to submit a return of such election expenses. Secondly, for an increase in election expenses that a candidate may incur at a National Assembly election, Rodrigues Regional Assembly election and local government election as well. Mr. Speaker, sir, the third one, for the regulation of temporary political headquarters and campaign quarters, commonly known as bars, during a National Assembly election, the Rodrigues Regional Assembly election, or local government election. Mr. Speaker, sir, it's true. It's a last year of our mandate. We are most probably in an election year. And we all in this House would want to see elections being conducted in a sound, transparent manner. In short, we want the financing of elections to be transparent. Now, Mr. Speaker, sir, how do you explain the opposition members refusing to accept transparency and accountability? I see no reason why the honourable members on the other side of the House should be so reticent as to outright reject voting in favour of this bill. This is more than surprising, Mr. Speaker, sir. Ont-ils oublié les pétitions électorales qu'ils sont venus avec pour semer le doute dans la tête des Mauriciens et qui ont tous été rejetés par la Cour? Quand nous agissons pour prévenir des dérapages et assainir la situation, ils refusent de soutenir le projet de loi. On one hand, they are crying out loud that things should be changed, and when actions are being taken, they back out, Mr. Speaker, sir. They view this bill as inadequate, restrictive, and to crown it all, engage in mudslinging. All this without bearing in mind the number of positives that are highlighted in this bill. They talk about political mileage we are trying to gain. And what is the bottom line? Elections, Mr. Speaker, sir, are a costly process, and some occult forces may see this as a boon to use their financial leverage to squeeze personal benefits. Mr. Speaker, sir, so the questions are, when we find banknotes tumbling down the safes, the coffers, when we see acres of land being leased to certain close friends without any tendering procedures. I won't go into the details right now, I'll come later to it. So the questions are, who is funding the elections? Where does the funding come from? And how much? The bill makes clear provision so that everybody knows where the money comes from and the amount and its utilization. J'éviterai, Monsieur le Président, de reprendre les remarques faites par l'honorable Attorney General. Je ne parlerai pas, moi, des millions dépensés sur les produits Louis Vuitton ou Chanel. Now, Mr. Speaker, so with this bill, we shall know for sure through this legislation that promises to dot the I's and to cross the T's for political financing. The recipients of monetary donations will have to keep a register with the dates they have received the funds, with the names of the donors and their addresses. And they will also have to state and report on any unused, unutilized donations. Mr. Speaker, sir, the honourable members on the other side of the House should not come back with their lame excuses of manque de consultation ou de consensus. The Honourable Prime Minister made it very clear during his second reading of the bills that plenty of opportunities had been provided for comments and proposals from within and outside the House as far back as in April 2024. Views, opinions, and proposals were definitely received from many bodies. International Institute for Democracy and Electoral Assistance, from Transparency Mauritius, from Business Mauritius, from the Electoral Commissioner, from the FCC, and they all commended the bill. And International Institute for Democracy and Electoral Assistance went further, stating that the provisions were very much in line with the global trends, regulatory trends, Mr. Speaker, sir. But members in the opposition did not deem it important to bring in their contribution. It was too underneath them to do so. And I'm being mild, Mr. Speaker, sir. Quel culot de venir maintenant parler de manque de consultation, de manque de consensus. Monsieur le Président, quelle hypocrisie. Ils ont tous reçu ces projets de loi. But they didn't deem it fit for them to come and to give any proposal, to make any suggestions. Et le leader du MMM, l'honorable Paul Béranger, nous demande d'attendre qu'il vienne, lui, avec un bon projet de loi, Monsieur le Président, digne de ce nom. Mais franchement, soyons sérieux, pour quelqu'un qui a passé sa vie à dire que nous avons un devoir de venir avec une législation par rapport au financement des élections, lui-même, il a, non pas moins de 3 fois, dressé des barrières, des obstacles, et a refusé de voter ces projets de loi. Et cela même quand il était Premier ministre. Quand les recommandations du Select Committee, présidé par l'Attorney General de l'honorable Liang Xing, à l'époque, sont venus, on n'a jamais pu venir avec un projet de loi à l'Assemblée, parce qu'il y a toujours eu des barrières, il y a toujours eu la réticence, Monsieur le Président. J'ai parlé de l'époque de 2000 à 2005. Ensuite, en 2019, quand le projet de loi fut présenté à l'Assemblée nationale, encore une fois, non, ils ne voteront pas. Et cette année-ci, aujourd'hui, en 2024, ils gardent toujours la même position. Mr. Speaker, sir, it is unfortunate, but true, that traditionally and over the years, many negatives have been associated with political financing. When the financing is unregulated, a number of ills may well arise, Mr. Speaker, sir. Some donors may well be expecting favors in return for financial support provided. If these donors happen to belong to the sectors like business and the like, there may be a perception that such financing may influence policies in their favors, in the interest of some corporate donors, and often to the detriment of public interest. Mr. Speaker, sir, scandals linked to political financing need to be addressed urgently to avoid risks of clientelism. We have in this very House, Mr. Speaker, sir, heard of the infamous case of unsolicited bid, or should I rather say, the handing out of state land at Agaliga as lease for projects for the construction of chalets without any call for interest, nor any tendering procedures, Mr. Speaker, sir. Mr. Speaker, sir, we're talking about 87 acres of land, followed by 25 acres of land, with a total 400 meters of beach frontage to a private operator without any call for interest. If this is not clientelism, Mr. Speaker, sir, then what is? Mr. Speaker, sir, in effect, if we make a brief recapitulation of the bill, it simply seeks to regulate donations such that when they are handed over to political parties or individuals, these are registered. Limits on expenses during the electoral period are imposed, as are the number of temporary campaign quarters, bars during elections. This bill, Mr. Speaker, sir, covers a vast territory. It does not only set clear guidelines regarding donations, monetary and in kind, it also imposes obligations relating to the keeping of records for a sound submission of returns of election expenses. And, Mr. Speaker, sir, the purpose should be clear to all: an uptick for fairness and accountability, and a downtick for improper influence in political financing. And the bill presented to the House, Mr. Speaker, sir, is in line with the recommendations of the United Nations Convention Against Corruption and the African Union Convention on Preventing and Combating Corruption. Therein, Mr. Speaker, sir, lies the relevance of reading the Constitution Amendment Bill and the Political Financing Bill together, since the role of the Electoral Commissioner becomes now even more prominent. The Commissioner is being empowered to assume a supervisory role to oversee the financing and is being vested with investigative powers. The production of a report on political donation is also part of the Commissioner's responsibility. Monsieur le Président, permettez-moi d'ouvrir une parenthèse pour souligner que j'apprécie fortement le changement d'attitude des membres de l'opposition vis-à-vis le commissaire électoral. Ceux qui demandaient tantôt sa démission ont changé d'avis. I'm glad to note that his integrity is no longer doubted nor questioned, and that brings hope to the diligence in the fulfillment of his future role. Mr. Speaker, sir, I have listened to Honorable Utim, taking exception to Section 22, subparagraph 3 of the bill that states, and I quote, "Where writs for general elections have been issued, no application for registrations shall be entertained by the Commission during the period starting 5 days after the day on which the writs are issued and ending on the day on which the election results are proclaimed." The contention rests, according to the Honourable Member, on the fact that, and I quote, Mr. Speaker, sir, un parti politique n'a que 4 jours. 4 jours pour s'enregistrer. Et dans ces 4 jours-là, Ils doivent trouver leur leader, leur trésorier, les office bearers, le président, le secrétaire. Ils doivent aussi pouvoir ouvrir un compte en banque. Mr. Speaker, sir, he caps it all by wondering whether le but de ce projet de loi n'est pas d'empêcher un maximum de partis de l'opposition et des candidats des partis de l'opposition d'avoir de l'argent pour les élections. Mais franchement, Monsieur le Président, ces gens doivent vraiment vivre dans un autre monde. Si un parti a l'intention de participer à une joute électorale, de surcroît à une élection générale, on s'attend à ce que ce parti soit déjà structuré et ce n'est pas à la dernière minute qu'il ira chercher son leader, son trésorier et je ne sais quoi encore. Do we really expect that political parties that are genuine and committed to their identified missions to wait for the writs of election to be issued for them to look for their office bearers? At one time, in the 2019 political financing bill, the argument was also brought forward by the opposition, and it was that in case of rejection of an application for registration by the ESC, there was no right of appeal. Mr. Speaker, sir, this point was well taken and heard, and now this has been taken care of in this present bill. The crux of the matter, Mr. Speaker, sir, where financing of political parties is concerned, resides ultimately in the matter of donations made. Donations, we all know, may well come from deep ideological conviction or to multiple other reasons. Sadly, however, they are not all provided in a spirit of disinterestedness. This is why Section 9 clearly delimits the frontiers of acceptability. Who in this House, Mr. Speaker, sir, can or will quarrel with the fact that donations cannot be accepted from a religious body or a statutory body, or again, a non-government organization which is in receipt of subsidy or grant from government? Can we ever say yes to an offer of donation when it is suspected to originate from the proceeds of crime? There are others as well that have to be placed on the other side of the wall. A foreign government, a foreign entity whose motives may well be eminently suspect. Allow me here, Mr. Speaker, sir, to highlight that as a sovereign nation, the very idea of external interference in the internal affairs of our country and elections should be obnoxious to us all in this House. I also appreciate that one cannot accept donations from an anonymous source. For Mr. Speaker, sir, once we start, there is no knowing where and when to stop. Soit on assainit la situation, soit on ne le fait pas. Seen from that angle, Mr. Speaker, sir, it's evident that other guardrails are necessary to ward off the potential of lack of transparency. These have also been put in this bill. Thus, private companies have to get their official imprimatur from their boards prior to the sanctioning of a donation. Again, the principle of disclosure in financial statements of amount of donation given, monetary or in kind, as well as bestowments to be made in cash, by check, or by electronic means, would help to ensure the above-board nature of the donation. Mr. Speaker, sir, there is one element underlying the bill before the House I would wish to highlight. It is something that has been hardly talked about and thus rarely heard. Anonymous or even undisclosed donations tend to nail the coffin of transparency. This bill fixes a spotlight on the necessity to eliminate the negative effects of non-accountability for funds received by political parties. Some may not be happy about that, but then again, that's a legitimate expectation of the population. Let me ask a question. Isn't it a right for voters to know who are those individuals or entities or organizations that fund political campaigns? Isn't it a duty on part of political leaders and their parties to be transparent? We know that misappropriation of funds or any such fund-related scandal have adverse effects resulting in misgiving and mistrust of a political body. Should that ever happen, once the harm is done, once the slanders take root, efforts aimed at sanitizing the system will ultimately prove to be inadequate and futile. Would we genuinely wish to witness an erosion of the public trust in not only the elected officials, but in the entire system? Haven't we shocked people enough with the banknotes tumbling down the coffers? Monsieur le Président, il faut être de mauvaise foi pour venir dire qu'on ne votera pas ce projet de loi. Et cela pour des raisons farfelues, telles que les élections sont proches, parce que c'est contre l'intérêt des petits partis, et j'en passe. Il n'y a pas un membre de l'opposition qui est venu avec des propos solides ou des commentaires raisonnables. C'est en effet une reconnaissance implicite du fait que ce projet de loi présenté par ce gouvernement contient des propositions qui sont très valables, justes et assurant la transparence. Eux, ils ne trouvent rien de concret à dire, pas un seul argument, Monsieur le Président. Je suis à la fois peinée et choquée d'entendre ces honorables membres d'en face, ils ne sont plus là, venir dire que pour assainir la situation, ils viendront, eux, avec un projet de loi, leur projet de loi à eux. Ils ont tous vu ces sommes faramineuses, ces nouveaux billets, bien coupés, cram-cram, sortant des coffres de leur allié, mais ils ne veulent guère éviter une répétition de ce spectacle à travers les garde-fous énoncés dans ce projet de loi. Ces honorables membres de l'opposition qui sont venus avec plus d'une dizaine de pétitions électorales insinuant qu'il y a eu du money politics sont paradoxalement réticents aujourd'hui à voter ce projet de loi qui prône la transparence dans le financement des élections. C'est l'hypocrisie à son apogée, Monsieur le Président. Et comment ne pas parler de cette ironie? On vient pointer du doigt le Sun-Trust, un quartier général qui sert comme lieu de rencontre, de rassemblement de tous les membres et les adhérents de ce parti, car il mérite bien un lieu digne et accueillant pour organiser ses activités. Le Sun-Trust démontre clairement à ceux qui ont contribué pour le parti que les donations ont été utilisées à bon escient. On n'a pas rempli les coffres forts, Monsieur le Président. C'est une autre culture. La culture MSM est une culture transparente. Pendant que ces gens de l'autre côté de la Chambre, eux, préfèrent entasser des liasses de billets, que dis-je, des millions de roupies, des devises étrangères jamais utilisées sur le circuit local, et cela dans des coffres forts. Et quand on questionne l'origine de cet argent, d'où provient-il? Mystère, mystère, Monsieur le Président. Silence assourdissant. Car, Monsieur le Président, le leader du Parti travailliste, ancien Premier ministre, a choisi de garder le silence. Généreuse donation, Monsieur le Président. Je pense que le peuple suit de près ce qui se passe et la population sera en mesure de juger la sincérité de ces honorables membres de l'opposition. Leur réticence d'apporter plus de transparence en refusant de voter ce projet de loi sera aussi inscrit dans l'histoire, Monsieur le Président. Mr. Speaker, sir, supporting and voting this bill is an unequivocal step towards strengthening our democracy and ensuring the integrity of our political process. The robust oversight provisions embedded in this bill guarantee effective monitoring and enforcement, leaving no room for doubt about their effectiveness. Opposing such initiatives without any valid reason is nothing but a blatant attempt to undermine our efforts to enhance transparency and accountability in our electoral system. By backing this bill, the leader of the House and members on this side of the House are championing a more transparent, accountable, and democratic future for our nation. And let me, Mr. Speaker, sir, thank the Honourable Prime Minister for his courage and his determination for presenting these pieces of legislation to the House. L'histoire retiendra que l'honorable Pravin Kumar Jagnat, Premier ministre, a eu le courage, la détermination de venir de l'avant avec cette législation à 2 reprises, mais que le Parti travailliste, le MMM et l'opposition dans son ensemble a refusé de voter pour ce projet de loi, de voter pour la transparence, de voter pour la redevabilité dans le financement des élections. They are voting, Mr. Speaker, sir, against transparency and accountability in political financing. L'histoire retiendra cela aussi, Monsieur le Président. Merci pour votre attention.
Honourable members, allow me to welcome Honourable Colin Davelu, who is attending this sitting, although not completely recovered from his illness. I will now call Honourable Deputy Prime Minister.
Merci, Monsieur le Président. La démocratie est-elle en péril? La démocratie est-elle menacée? C'est la question que je pose aujourd'hui. C'est la question que je me pose et que je pose à notre Assemblée nationale. Car, Monsieur le Président, je crains que la démocratie, fondée sur le principe d'une personne, un vote, est en face, doit faire face à un grave danger. Celui d'être pris en otage par l'argent privé. Je ne me réfère pas à la seule République de Maurice. Mais je me réfère à toutes les démocraties, des États-Unis d'Amérique au Chili, de la Grande-Bretagne ou la France, jusqu'à l'Afrique du Sud, de l'Inde à l'Australie. La réalité, c'est que les candidatures, les campagnes électorales et même le libre arbitre de l'électeur sont désormais sous l'influence sans cesse croissante du pouvoir de l'argent. Ce que les observateurs, les commentateurs appellent « money politics ». Et voilà donc le pourquoi de notre démarche. Afin de résumer mon argumentaire, Monsieur le Président, je vais me reposer sur 5 constats que j'emprunte à Julia Cagé, professeure d'économie à Sciences Po Paris, pour vous livrer l'analyse sans complaisance qui est la mienne après 7 participations aux législatives et 2 participations aux municipales au cours des derniers 33 ans. Premièrement, la démocratie a un coût. La démocratie a un coût. De fait, les partis politiques et les candidats aux élections doivent faire face à d'énormes dépenses. Et ce ne sont pas nos plus jeunes députés qui me démentiront, à d'énormes dépenses dont ils ne peuvent s'acquitter sans un apport financier qui disqualifie le citoyen moyen et défavorise les partis antisystème. Deuxième constat, les citoyens ne sont pas égaux quant à la profondeur de leur poche. Citation. Seuls les candidats connectés peuvent se présenter avec une chance de l'emporter. Un homme politique sera d'autant plus susceptible d'accepter pot de vin et financement occulte s'il doit dépenser plusieurs millions pour avoir une chance d'être élu. Troisième constat, cette lacune favorise certaines dérives et permet aux partis politiques bénéficiant de financements occultes de la part des riches et des puissants d'avoir un avantage certain. Ce qui pousse les observateurs à nous dire que la démocratie, c'est à qui paye, gagne. Quatrième constat, si l'on ne limite pas le poids de l'argent privé dans le jeu politique, alors les hommes politiques seront condamnés à continuer à courir derrière les chéquiers et ce sont les seules préférences des plus favorisés qui seront représentées demain. Et cinquièmement, il y a donc urgence à mener des réformes afin que soit contenu le rôle de l'argent privé dans le fonctionnement de la démocratie et restaurer le principe fondateur de toute démocratie, une personne, une voix. Donc, ce qui m'amène à dire, Monsieur le Président, qu'en l'absence de financement public, la démocratie risque d'être prise en otage par le financement privé. Voyez le rôle croissant joué par l'argent dans nos démocraties. Un des chercheurs que je lisais constatait que l'argent se tient désormais au centre du jeu politique. Et les dons privés des plus favorisés ont un impact non négligeable sur le résultat des élections. Le rapport Sachs, il y a 20 ans, 20 longues années, nous le rappelait déjà. Je cite, « There is no need to insist on how powerful and rich corporations have, through financial pressure, tried the world over to influence those likely to exercise political decisions. » Sachs, rapport Sachs, il y a plus de 20 ans. Quelques exemples. Savez-vous qu'en France comme au Royaume-Uni, les 10% des plus gros donateurs représentent plus des 2/3 du total des dons? Savez-vous qu'en Allemagne, la firme Philip Morris finance à la fois la CDU, la CSU, le FDP et le SDP? Et, fait exceptionnel en Europe, on a dû attendre 2022 pour que l'Allemagne interdise finalement la publicité pour le tabac. Philip Morris. La démocratie, nous dit Julia Cagé, repose sur une promesse d'égalité qui trop souvent vient se fracasser sur le mur de l'argent. Voyez les dépenses électorales moyennes des candidats victorieux aux élections parlementaires. Aux États-Unis, les dépenses moyennes pour un candidat victorieux élu au Sénat seraient en 2016 de plus de 10 millions de dollars. 2016. En France, il est estimé cette année qu'un candidat aura dû dépenser jusqu'à 60 000 € pour se faire élire. Au Royaume-Uni, une étude de 2018 nous dit que les candidats du Parti conservateur ayant remporté les élections avaient dépensé en moyenne plus de 121 000 livres sterling. Et le journal The Independent qui commente « Ordinary people are being priced out of standing for Parliament by the huge personal cost of becoming a party candidate. » Et en Inde, en 2018, l'on a calculé que les dépenses moyennes d'un candidat victorieux se montaient à 1,7 million d'euros. Voilà la réalité des faits, Monsieur le Président. À Maurice, nos dispositions existantes datent de la Constitution de 68 et de la Representation of People's Act de 1958, même s'il y a eu plusieurs retouches, dont la dernière remonte à 2016. Les dépenses des candidats, dépenses autorisées, se montaient en 1958 à 800 roupies, mais uniquement pour living expenses et petty expenses. Puis passe pour les party candidates, les candidats appartenant à un parti politique, à 20 000 roupies en 2085 et à 200 000 roupies maximum pour les législatives en 1989. Ça fait quoi? 35 ans de cela. Le plafond est fixé. Il n'y a pas eu de mise à jour depuis. Et même là, c'est le plafond de 1989. 12 ans, 13 ans plus tard, le rapport Sachs nous dit « It is common knowledge that these ceilings on expenditure are observed only in their breach ». Le rapport qu'avait cité notre Premier ministre lors de la présentation des projets de loi qui sont devant nous. Donc, la dernière fois que le plafond a été relevé, c'est 35 ans de cela. Et dans les faits, il n'y a que 2 obligations qui s'imposent aux candidats, c'est de respecter ce plafond et de présenter un rapport à un magistrat dans un délai imparti après les élections. Bon, ensuite, bien sûr, il y a dans notre législation des dispositions relatives aux infractions à la loi telles que la fraude électorale, mais aucune mention concernant la limite de dépenses d'un parti ou d'une alliance. Cela n'existe tout simplement pas dans nos lois électorales. C'est à se demander s'il y a réellement, dans les faits, une réglementation quelconque des dépenses électorales. Et que nous apprend l'histoire? La genèse de ce débat relatif au financement des partis politiques remonte, je crois, aux années 80. Et je me souviens très bien qu'en 1995, lors de l'alliance Parti travailliste MMM, qui se proposait de moderniser Maurice et de tout changer, le discours-programme présidentiel, prononcé donc après l'arrivée au gouvernement du Parti travailliste MMM, disait déjà en 1995 « Government is concerned with the influence of private political funding of political parties and its potential effect on the decision-making process. » 95, pratiquement 30 ans de cela. Lourd de sens. Et que se passe-t-il par la suite? Je suis tombé sur un document du MMM produit en avril de l'année 2000, dont le titre c'est « The Financing of Political Parties in Mauritius, MMM Proposals for Reform and Regulation ». Et ce document rappelle les engagements du manifeste Parti travailliste MMM de 1995, avant d'observer, et je cite, et c'est dommage que nos amis du Parti travailliste et du MMM ne sont pas là. Donc le rapport du MMM, je cite, disait « Like so many other crucial aspects of national interest, no action has been taken by the Labour government on political funding. The MMM condemns the Labour Party for its refusal to engage in a reform of political finance to strengthen democracy in our country. » En avril de l'année 2000. Le MMM d'antan et que de documents oubliés. Par contre, 2000 à 2005, dès le discours-programme de l'année 2000 du gouvernement MSM-MMM, on annonce la couleur, la commission Sachs se met en action, soumet son rapport au début de 2002, il est suivi du comité d'élite, du Select Committee présidé par notre ami, monsieur le député Ivan Kolendavelou, dont je salue le retour au sein de l'Assemblée, et aussi le rapport Liang-Xing de 2004, si je ne m'abuse. Donc, arrivé 2005, l'on est prêt pour avancer avec des recommandations précises. Le chemin est tout tracé. Après intervient le régime travailliste, 2005 à 2014. La politique du boost fixe rien, absolument rien, pour traiter de cette question du financement de la politique à Maurice, une léthargie, une absence d'action qui est sévèrement condamnée à nouveau par le MMM, auquel j'appartenais durant toute cette période, comme Alain Ganou et d'autres de ce côté de la Chambre. Ensuite, c'est le retour aux affaires donc, du MSM, en compagnie du PMSD et du ML, et tout de suite, l'action du régime de 2000-2005 reprend. D'ailleurs, il est intéressant qu'en 2014, à la fois le manifeste de l'alliance MSM-MMM, MSM-PMSD-ML et le manifeste du Parti travailliste MMM se réfèrent à une nouvelle loi, mais aussi à l'octroi de pouvoirs accrus, non seulement à l'Electoral Commissioner, mais aussi à l'Electoral Supervisory Commission, qui sont venus par la suite critiquer. Il y a le comité interministériel présidé par le Premier ministre adjoint d'alors, Xavier-Luc Duval, monsieur le député Xavier-Luc Duval, puis celui présidé par Saniro Jagnot, qui débouche sur le projet de loi de 2019. J'ai fait l'objet d'attaques de la part du leader de l'opposition quant à une prétendue vol de face, un big U-turn. Donc je voudrais, avec votre permission, Monsieur le Président, retourner sur les prises de position de mon parti, la plateforme militante, qui fait de cette question un élément central de notre programme politique dès notre création, donc dès début 2019. Et ce que la plateforme militante propose alors, c'est afin de diminuer le rôle pernicieux de l'argent privé dans la politique, la plateforme militante propose de s'attaquer aux items de dépenses, aux principaux items de dépenses, donc de diminuer la somme d'argent que doit dépenser un candidat. Et quels sont les items principaux? Nous les connaissons. Les bases, ces quartiers généraux qui poussent comme des champignons à tous les coins de rue lors d'une campagne électorale, l'organisation de meetings et de réunions, location de salles, de moyens de transport, campagne de communication, banderoles, oriflammes, affiches, transport des électeurs et rémunération des agents quand cela s'avère nécessaire lors des campagnes électorales. Deuxième proposition, c'était d'assurer le financement public de la démocratie. Par exemple, le transport des électeurs, la mise à la disposition de salles de l'État, de registres électoraux, etc. Troisièmement, limiter les dons privés, les montants des dons monétaires et en nature. Quatrièmement, limiter les dépenses autorisées. Et cinquièmement, renforcement des sanctions allant jusqu'à la disqualification. Et c'est ainsi qu'au lendemain de la présentation des projets de loi en 2019, nous tenons une conférence de presse citée par le leader de l'opposition, mais avec des citations sélectives. Et ce que nous disons alors, c'est que le fait d'agir du gouvernement de l'époque, le simple fait d'agir était positif en soi, et que c'était un pas historique. Nous avions alors regretté le timing, parce que le projet de loi avait été introduit 4 ou 5 mois avant les élections générales, en disant que cela créait un soupçon de dessein de partisans, mais aussi pour l'opposition une tentation de posture démagogique, pandering to public opinion. Et nous regrettions le financement de l'État évacué pour cause d'impopularité, parce que les médias ont souvent présenté le financement public comme donner de l'argent du contribuable aux leaders des partis politiques. Et nous réclamions donc des mesures immédiates, telles que l'interdiction du transport des électeurs. Vous savez, Monsieur le Président, sans doute, que cela est considéré en Grande-Bretagne depuis 1988 comme une forme de corruption, et le transport d'électeurs est interdit en Inde. Nous proposions un seul quartier général par centre de vote, reprenant les propositions de la loi, l'interdiction d'oriflammes et de banderoles dans les lieux publics tels que recommandés par le rapport Liang-Shing de 2004, l'interdiction d'agents rémunérés tels que recommandés par le rapport Liang-Shing, l'interdiction des dons de l'étranger. À l'époque, nous étions en faveur des dons des Mauriciens à l'étranger. Mais aujourd'hui, je suis convaincu que cela ouvre la porte à des financements occultes, illicites, et cela peut être très dangereux pour la transparence. Et nous proposions aussi l'interdiction des dons des compagnies d'État, donc des items, des éléments qui se retrouvent dans la loi de 2019 et dans les projets de loi d'aujourd'hui. Ensuite arrivent les élections de 2019, et je crois que le Premier ministre l'a souligné. La proposition d'introduire une nouvelle loi sur le financement figure dans notre manifeste de l'Alliance mauricienne, dans le manifeste du MMM, mais pas dans celui du Parti travailliste. Rappelez-vous l'absence d'action de 1995 à 2000, le fait que rien ne se passe de 2005 à 2014 et coïncidence, le manifeste électoral du Parti travailliste en 2019 ne se réfère pas à une loi sur le financement des partis. Que se passe-t-il après 2019 ? Il se passe le Covid. Et pendant 2 ans à 2 ans et demi, tous les efforts du gouvernement se focalisent sur le comment de surmonter le risque, le danger posé par le Covid et de relancer notre économie. Mais dès 2022, un comité interministériel présidé par le Premier ministre lui-même se met en place. Et ce comité interministériel, j'en suis témoin, va commencer par analyser dans le détail les prises de position des députés de l'opposition en 2019 pour voir si et comment on peut inclure ces propositions. Quand propositions il y avait. Il y en a une. Ensuite, au début de cette année, les consultations deviennent possibles. Les projets de loi que nous avons devant nous sont expédiés à chaque député de cette Assemblée et sont disponibles en ligne. Certaines organisations, certains individus réagissent, mais silence radio du côté de l'opposition. Aucun commentaire, aucune réaction, aucune proposition. Néanmoins, le comité interministériel, et j'en suis témoin, je peux en témoigner, analyse au cas par cas toutes les représentations qui nous sont faites et le projet de loi évolue. Parce que là où cela s'avère possible, nous incorporons les propositions qui nous sont faites pour aboutir sur les projets de loi qui sont devant nous. Donc, la plateforme militant, évidemment, aurait souhaité, dans l'idéal, que nous allions beaucoup plus loin et beaucoup plus vite pour limiter les dépenses et introduire le financement public des élections ou de la démocratie. Mais la question essentielle aujourd'hui, c'est quelles sont les réformes qui doivent sans tarder être conduites afin que soit contenu le rôle de l'argent privé dans le fonctionnement de nos démocraties. La réalité nous impose de saisir les forces en jeu aujourd'hui et de proposer des alternatives concrètes, crédibles et efficaces. Et c'est ici que je voudrais saluer l'initiative du gouvernement présentée par le Premier ministre et dire toute notre solidarité entière avec les propositions qui sont devant l'Assemblée nationale aujourd'hui. Ces 2 projets de loi qui sont devant nous constituent un pas en avant, un pas sans précédent. Et quel pas? Un pas historique qui vient proposer l'obligation obligatoire des partis qui prétendent recevoir de dons. Pas de dons sauf à un parti ou individu enregistré à cette fin auprès des instances régulatrices. Et j'ai entendu le député Outim exprimer son désaccord. Deuxièmement, la définition dans la loi des dons en nature, une définition encore plus large que celle de 2019. Troisièmement, l'obligation pour une entité privée de divulguer tout don à des fins politiques. Et j'entends les protestations de monsieur le député Ramphol, mais qui veut en même temps réguler le financement de la politique, sans nous dire comment. Quatrièmement, l'obligation de déclarer les dons en nature. Cinquièmement, l'interdiction de dons anonymes ou d'entreprises d'État ou d'un corps religieux ou de l'étranger, à cause du risque de financement illicite et l'impératif de préserver l'indépendance et la souveraineté du processus électoral mauricien. Ensuite, l'obligation faite aux récipiendaires de dons politiques de tenir des comptes financiers transparents et les soumettre à un contrôle régulier par les organismes compétents. Ensuite, l'obligation faite au commissaire électoral de faire rapport auprès de l'Assemblée nationale, donc auprès du législatif. Ensuite, les amendements constitutionnels pour permettre la dotation en pouvoir de contrôle de l'Electoral Commission et de l'Electoral Supervisory Commission. Et je crois que j'ai entendu le député, monsieur le député Xavier Duval, souligner l'évolution positive dans le dernier projet de loi à cet effet. D'ailleurs, des pouvoirs de contrôle qui seraient sujets néanmoins à au recours garanti au judiciaire. Ensuite, les sanctions pour agissement non conforme aux dispositions légales, donc avec des effets dissuasifs. Et finalement, les amendements au Representation of People's Act pour revoir les limites de dépenses imposées aux partis et alliances de partis, la limitation des dépenses associées aux élections telles que la prolifération des bases, véritable trou sans fond. Là aussi, j'ai écouté les calculs arithmétiques de certains députés de l'opposition nous disant que cela équivaut à trop d'argent, mais aucune contre-proposition. Nous disons concrètement, si ce n'est le plafond proposé par le gouvernement, que devrait-il y avoir comme plafond? C'est ainsi que nous avions, il y a quelques jours de cela, lancé un appel public à l'opposition pour qu'elle assume ses responsabilités en démontrant d'abord un sens de responsabilité, deuxièmement, pour qu'elle fasse preuve de sérieux, et troisièmement, qu'elle fasse preuve de cohérence. Sens de responsabilité de par sa présence lors des débats à l'Assemblée nationale. Certes, ils ont participé au débat jusqu'à la dernière fois, mais regardez aujourd'hui le spectacle pitoyable que nous offrent les bancs de l'opposition. Merci au PMSD et à monsieur le député Baudin d'être au moins là présent. Au moins eux, ils ont le sens de la responsabilité de députés. Nous avons tous un devoir de présence, que l'on soit de la majorité ou de l'opposition. Deuxième appel, c'était faire preuve de sérieux, de venir avec des propositions alternatives et constructives. Avez-vous entendu une seule contre-proposition de monsieur le leader de l'opposition? Aucune. De monsieur le député Paul Béranger? Aucune. De monsieur le député Ramphol? Aucune. De monsieur le député Mohamed? Aucune. Et monsieur Ramphol nous parle de maintenir the privacy of the donor. Et comment, dès lors, réguler le financement de la politique? Donc, du sérieux, je n'ai pas constaté du sérieux de la part de l'opposition. Ensuite, j'ai demandé à ce qu'on fasse preuve de cohérence, parce que lors du débat de 2019, il y avait différentes prises de position au sein même du Parti travailliste. Les députés se contredisaient. Cette fois-ci, il y a eu encore moins de propositions, mais néanmoins, j'ai entendu le député Béranger, lors de son discours plus qu'expéditif, prendre l'engagement, comme à son habitude, de proposer une bonne loi, une fois qu'ils seront, c'est leur ambition, au gouvernement. Quelle est cette bonne loi? Personne ne le sait. Mais le pire, c'est que parmi les autres députés de l'opposition, personne n'a pris un tel engagement, sauf le leader de l'opposition, mais lui semblait se favoriser plutôt un Serious Fraud Office, ce qui semble suggérer qu'il n'y a eu à ce stade aucune réflexion sérieuse au sein de l'Alliance Parti travailliste MMM quant à un projet de loi hypothétique pour traiter de cette question du financement de la politique. Un engagement du MMM, qui reflète tous les manifestes électoraux du MMM depuis 2015, mais une timidité frappante du Parti travailliste de s'engager dans ce sens. Et le résultat final, je me dis, pourquoi l'opposition n'aurait-elle pas pu voter ces deux projets de loi comme un premier pas, puisqu'elle nous dit être sûre d'être au gouvernement après les prochaines élections? Elle l'aurait fait évoluer. Pourquoi ne pas avoir présenté un projet d'amendement à nos projets? Pourquoi ne pas être venu avec des contre-propositions précises en nous disant, si vous acceptez cette proposition, nous votons la loi? Mais il n'y a eu rien. Parce que la vérité, c'est qu'il n'y a aucun accord entre eux, aucun projet commun. Et une fois de plus, je constate que le MMM se fait avoir par le Parti travailliste. Je ne crois pas qu'il pourrait remporter une élection. Mais si par malheur cela se faisait dans le pire des cauchemars, le Parti travailliste ne ferait rien pour adopter un tel projet de loi. Et mes collègues de ce côté de la Chambre ont bien expliqué pourquoi. Je ne vais pas y revenir. Donc en conclusion, Monsieur le Président, la réalité, c'est que la démocratie, oui, est en péril si nous n'agissons pas. Nous dire que la démocratie repose sur une promesse d'égalité qui trop souvent vient se fracasser sur le mur de l'argent n'est que trop vrai. Il faut agir concrètement et il faut agir vite. Rien n'obligeait le Premier ministre et le gouvernement à présenter ces projets de loi. Il aurait été tellement aisé que nous venions dire, à cause du Covid, on n'a pas eu le temps. À cause de l'attitude de l'opposition, c'est peine perdue. Mais non, c'est dans le respect des engagements pris que nous nous sommes sentis le devoir de présenter les projets de loi qui sont devant la Chambre. Les projets de loi qui introduisent pour la première fois, qui se proposent d'introduire pour la première fois, mis à part le projet de loi de 2019, le principe de la transparence et de la redevabilité, comme l'a dit si bien avant moi Madame la ministre de l'Éducation, dans le financement de la politique. Une fois de plus, ce qui, pour le MMM, reste une déclaration d'intention jamais concrétisée, nous la traduisons dans la réalité, dans le concret. L'histoire retiendra le comportement indigne et irresponsable de l'opposition travailliste à MMM. Ce que nous proposions de faire était un pas historique et sans précédent. Mais une fois de plus, cela sera probablement une occasion ratée à cause du comportement de cette opposition travailliste MMM. Mais l'histoire retiendra aussi cet acte de courage de la part de notre Premier ministre et de notre gouvernement. Mr. Speaker, let history judge. Merci, j'en ai terminé.
Honourable members, I'll suspend the sitting for 30 minutes.
Announcements.
Honourable members, I have to inform the House that Mr. Niteshan Tailame has joined the clerk's table as clerk assistant. Mr. Tailame joined the civil service as management support officer in August 2014. He was subsequently appointed as court officer at the judiciary in October 2017 and court usher in January 2019. Prior to joining the National Assembly, he held the post of analyst at the Ministry of Finance, Economic Planning and Development. He holds a bachelor's degree in law and management from the University of Mauritius, a Master of Business Administration from the Open University of Mauritius, a Master of Laws in Financial and Commercial Law from the University of Central Lancashire. On behalf of the House and in my own name, I extend a warm welcome to Mr. Niteshan Tailame and wish him a successful professional career. I now invite Mr. Niteshan Tailame to join the table. I have taken cognizance of a press article entitled La sanction contre Rajesh Bhagwan considérée comme injustifiée, which appeared in the Express of today. In the said article, referring to the suspension of Honorable Bhagwan, the Honorable Shakil Mohammed is reported to have stated that I have given a wrong interpretation of standing orders. I wish to set records straight. Honorable members, the House will recall that at the sitting of 5th July 2024, I made an announcement in regard to the intervention of Honorable Bhagwan during a press conference whereby he uttered undignified words to my address. I accordingly requested the Honorable Bhagwan to present his unreserved apologies to the House, failing which I will be left with no other alternative than to ask him to withdraw from the chamber. The Honorable Bhagwan, instead of presenting his apologies, replied the following: I call a spade, and I won't withdraw. It is a fact, ou un agent politique, to un agent politique. In the light of the reaction of the Honorable Member, and considering that this amounted to a grossly disorderly conduct and to disregarding the authority of the Chair, I took the decision to name him under Standing Order 49-4, and there was no need to proceed under the National Assembly Privileges, Immunities and Powers Act, as grossly disorderly conduct occurred in the House itself. I further wish to inform the House that any member who is aggrieved by the decision of the Speaker may challenge same by way of a substantive motion. Therefore, the remarks made by the Honorable Shakil Mohammed in today's article in Express are not justified. Today, I ordered Honorable Juman to withdraw from the chamber for arguing with the chair. Thereafter, Honorable Juman stated, "You're cheap, you're shame." Thereupon, I named Honorable Juman. Honorable Juman continued to argue with the chair in a grossly disorderly manner and challenged the authority of the chair in a most undignified manner by uttering the following words: "Do whatever you want. Couvert, combien te pour capable couvert? Bientôt te pour dehors." To the address of the Speaker. I ordered Honorable Juman to leave the chamber several times, and the Honorable Member refused to leave, and the sitting became unruly. I therefore suspended the sitting.
Mr. Speaker, sir, in view of your decision to name Honorable Juman, I beg, under Standing Order 17.3, to take the time of the Assembly for urgent business.
Seconded. Seconded. The question is that the Honorable Deputy Prime Minister be allowed under Standing Order 17.3 to take the time of the House for urgent business. Those in favor say aye, those against say no. The ayes have it.
Mr. Speaker, sir, having obtained your permission, I now beg to move under Standing Order 29.1 to present a motion without notice.
Seconded. Seconded. The question is that the Honorable Deputy Prime Minister be allowed under Standing Order 29.1 to move a motion without notice. Those in favor say aye, those against say no. Aye. The ayes have it.
Mr. Speaker, sir, in view of your decision to name Honourable Juman, I beg to move that the Honourable Juman be suspended from the service of the Assembly for today's sitting and the next 6 sittings, unless on reserved apologies are tendered to the House.
Seconded. The question is that the Honourable Juman be suspended from the service of the Assembly for today's sitting and the next 6 sittings, unless unreserved apologies are tendered to the House. Those in favor say aye, those against say no. Aye. Ayes have it.
The Constitution Amendment Bill. D'après ce explanatory memorandum qui fait circuler dans le Parlement, l'objectif de ce projet de loi-là, c'est pour amender la Constitution pour accorder un pouvoir et une responsabilité additionnelle à la Electoral Commission, qui nous appelle Commission électorale, et au commissaire électoral dans une matière qui concerne le financement politique. Political Financing Bill. D'après ce explanatory memorandum qui fait circuler dans le Parlement, ce projet de loi-là pour garantir la transparence et que la responsabilité dans le financement d'un parti politique afin qu'il empêche la corruption et qu'en même temps promouvoir une concurrence ou une compétition juste et équitable. Il interdit une donation politique à un parti qui n'est pas enregistré ou un individu qui n'est pas affilié à un parti qui est enregistré. C'est pourquoi Representation of People Act peut bien être modifié comme suit. Pour imposer une limite aux dépenses électorales, que ce soit pour un parti ou alliance, qui peut avoir une obligation légale pour déclarer de dépenses. Pour avoir une augmentation dans les dépenses électorales qui un candidat gagne droit à faire dans l'élection à l'Assemblée nationale, élection régionale Rodrigue ou élection municipale et villageoise. Pour régulariser un quartier général politique temporaire qui met en place dans l'élection, qui nous appelle aussi base. Resources Bill. D'après ce explanatory memorandum qui fait circuler dans le Parlement, le principal objectif de ce projet de loi-là, c'est pour établir un cadre juridique complet pour l'utilisation, gestion, contrôle, protection, conservation et développement durable des ressources de l'eau dans Maurice. Sauvegarde l'intérêt public dans les médias et à long terme pour un accès équitable à de l'eau. Garantir sécurité et résilience de l'eau. Établir une Water Resources Commission. Encourage utilisation efficace de l'eau. Prend disposition pour et en relation avec les affaires connectées et par rapport à ce sujet-là.
Please be seated. Now I call the Honorable Prime Minister.
Monsieur le Président, nous continuons les débats sur le Constitutional Amendment Bill et the Political Financing Bill, deux projets de loi extrêmement importants pour le pays, pour la population et pour les partis politiques. Que voyons-nous aujourd'hui? Alors que moi, en tant que Premier ministre qui a présenté ces deux projets de loi, je fais mon summing up. À l'exception du PMSD, donc l'honorable Xavier-Luc Duval, l'honorable Armance et l'honorable Boda, tous les bancs de l'opposition est vide. Le Parti travailliste, le MMM et le, comment s'appelle le nouveau parti, le nouveau démocrate. Bon, enfin, ils sont, à l'exception de ceux-là que j'ai mentionnés, ils sont tous absents. Et vous savez où ils sont? Nous étions là pendant le tea break. Certains sont en train de se reposer dans le salon, le réceptorium. D'autres qui ont eu faim et soif sont en train de à la buvette. Hein? Monsieur le Président, je le dis avec tout le sérieux. C'est pas parce que j'ai envie de faire une blague. Parce que moi, j'ai été là à écouter tous les intervenants. Tous les intervenants. Au moins ceux qui sont intervenus du côté de l'opposition, comme j'ai dit, à l'exception de l'honorable Xavier-Luc Duval et l'honorable Boda, au moins eux, ils auraient dû être là pour écouter, parce qu'ils ont fait des critiques, au moins pour écouter ma réaction, mes explications, les éclaircissements et répondre à ce qu'ils ont dit. C'est ça la version, la définition de la démocratie de la part du Parti travailliste et du MMM et du Nouveau démocrate. Je dis, Monsieur le Président, c'est une opposition MMM, travailliste, Nouveau démocrate, indigne. Indigne pour représenter cette population. Mais néanmoins, nous avons un travail sérieux. Comme j'ai toujours dit, nous savons exactement où nous allons. Nous savons exactement nos responsabilités. Nous savons that we have to deliver on what we have promised to the people. Et c'est ce que nous sommes en train de faire aujourd'hui. So, let me thank all the honorable members, first from this side of the House who have intervened, and those who are outside the House, who are enjoying themselves, who have intervened and contributed to the debate on those, as I say, two historic bills. Mr. Speaker, sir, as I stated in my second reading speech on Tuesday last, these two bills have the lofty objectives of enhancing transparency and accountability in political financing and strengthening our democracy. I stressed on the fact that for too long, political donations in our country have been shrouded in secrecy and opacity. leaving our political system exposed to the risks of policy capture and distortion of the democratic process. I also explained how the absence of an effective regulatory framework for political financing not only precludes a scrutiny of the sources of funding of parties, but it also prevents an assessment of the lawfulness of such donations and fuels all sorts of suspicion around this issue. Mr. Speaker, sir, I have listened carefully to all the interventions. And I must say, Mr. Speaker, sir, that I am once again extremely disappointed by the stand taken by the opposition on such important pieces of legislation with laudable objectives. I must also say that I'm surprised at the tenor and superficiality of their so-called arguments, most of which are totally untenable, and I would say some are simply ridiculous. Heureusement que le ridicule ne tue pas, Monsieur le Président. In fact, they have no arguments at all. What we have heard from the other side since Tuesday last were only lame excuses which betray the hypocrisy and the bad faith. I was honestly not expecting anything better from the Labour Party. But for the party like the MMM, which has always claimed to be progressiste et avant-gardiste, one would expect that they would, on such an important matter, stay true to their values, which they usually boast of, and would not, at least this time, betray their own identity. I was hoping that they would rise above petty politics and allow the national interest to prevail over political and personal ego. But perhaps I was a bit too optimistic. The whole opposition once again missed the forest for the trees and failed lamentably to see the bigger and more important issues around political financing embodied in these bills. C'est encore une fois une occasion ratée. And it is indeed a sad day for our democracy. Mr. Speaker, sir, members from this side of the House have very proficiently rebutted all their arguments and exposed their bad faith. Nevertheless, I would like to respond to a few points which were raised by some members from the other side in order to call their bluff and also to dispel any remaining doubt or confusion that they may have created in the minds of the people. Mr. Speaker, sir, the leader of the opposition and several other speakers from the opposition have stated that there were no proper consultations on these bills before the introduction. I think they did not pay enough attention to the content of my second reading speech. I very clearly explained, and the whole nation is aware, that government had indeed carried out wide consultations on its proposals on political financing. As a matter of fact, on 29th April 2024, copies of the bills were sent to each and every member of the National Assembly personally. The Electoral Supervisory Commission, the Electoral Commissioner, the Financial Crimes Commission, Business Mauritius, and the International Institute for Democracy and Electoral Assistance, International IDEA. I also mentioned that a copy each of the two bills was also posted on the website of the Prime Minister's office, and members of the public were invited to submit their views, comments, and or counter proposals. Mr. Speaker, sir, following the consultation exercise, my office has indeed received comments and counter proposals from several stakeholders, including International IDEA, who made some very favorable comments on the bills. All the constructive counter proposals received were duly examined and taken on board. This is precisely the reason why certain aspects of the present bill is different from the 2019 bill. This is also testimony of the fact that we are a government that favors dialogue, are ready to listen, and open to proposals, contrary to what Honorable Mohammed wanted to make believe. But I must remind that the Ministerial Committee did not receive a single counter-proposal from any political party in the opposition represented in the National Assembly. And listening to the opposition, I have the impression that for them, consultation means a right to impose their own point of view. Mr. Speaker, sir, the leader of the opposition and others from the opposition side also accused the government of introducing this legislation on the eve of the dissolution of the Assembly. I don't know how they come to know when the Assembly is going to be dissolved, first of all. But let me remind them that the government has a 5-year mandate, the end of which is still 4 months away. In any case, the opposition adopted the same negative stand for the 2019 bill, which was introduced in July 2019, that is, well before the dissolution of the National Assembly in 2019. But, Mr. Speaker, sir, 4 months before the National Assembly will automatically be dissolved is, according to the opposition, on the eve of the dissolution. When is it not on the eve of dissolution? 6 months? 1 year? 1.5 years? 2 years? 3 years? 4 years? 5 years? They will always have a pretext. And like the leader of the MMM, Honorable Paul Raymond Béranger, used to say, after every general election, he will keep on saying, élection derrière la porte. And when he says that, it seems that then no government can function because we will be on the eve of general election. Forget about those bills. We won't be able to bring any bill to Parliament because we would be on the eve of general election. I don't know what kind of reasoning is that. Well, Mr. Speaker, sir, I like watching football, especially at this time. But a football match is over when the referee blows the whistle and says, that's over. But in the meantime, you can score. Well, you can try to score. So our mandate is 5 years. We are still working, and we will continue to work very hard till the end of this mandate. So, Mr. Speaker, sir, this government, as I say, is still within its mandate. And we have every legitimate right to fulfill the promises which we made to the nation in 2019. These bills, as I said earlier, are in the national interest as they seek to reinforce our democracy. It is a huge step in the right direction. And as Martin Luther King Jr. used to say, and I quote, "The time is always right to do what is right," unquote. And any argument, as frivolous and untenable as it may be, will be good if one does not have the intention to support these bills. As Albert Camus said, and I quote, "Those who lack the courage will always find a philosophy to justify it," unquote. Mr. Speaker, sir, Honorable Béranger, Paul Raymond Béranger, pleaded in favor of increasing the representation of women in the National Assembly. I heard him saying loud and clear that once in power, they will introduce what he calls une vraie réforme électorale avec au moins un tiers des femmes sur la liste des candidats pour les élections générales. Mr. Speaker, sir, the House will recall that the same Honorable Paul Raymond Béranger refused to vote in favor of the Constitution Amendment Bill of 2018, which precisely one of the aims was to guarantee a better representation of women in the National Assembly. What an irony. Had the opposition supported the initiative at that time, most probably the configuration in the National Assembly today would have been different. Mr. Speaker, sir, the House will also recall that it is the MSM-led government which amended the law to increase participation of women in the Rodrigues Regional Assembly elections. However, it is a matter of deep regret that our attempt to replicate the same formula for the National Assembly elections was thwarted by the same opposition, which is pretending today to be an advocate of gender balance in politics. Mr. Speaker, sir, after all, there is no need for legislation for political parties to align more female candidates. It all depends on the party's philosophy, their foundational values, and their sincerity of purpose. I therefore hope that Honorable Béranger, Paul Raymond Béranger, will stay true to his words and lead by example by fielding at least 1/3 or more female candidates for the forthcoming general elections. Mr. Speaker, sir, I also heard most of the speakers from the opposition side stating that the bill should have been referred to a select committee for a more in-depth discussion. As I said earlier, the government did not receive a single suggestion or counter-proposal from this opposition during the consultation process. They have made extensive comments on the bills in the media. They were heard on private radios, giving interviews, and making all sorts of accusations and imputing ulterior motives to this initiative of government. But they never deemed it necessary or cared to make any suggestion or counter-proposals when invited to do so. So, we do not see the rationale of referring the bill to a select committee. And in any case, there is no guarantee that the select committee would have been able to iron out all the issues and secure a consensus over these bills, given that in 2019, there were, as we all knew, profound dissension among the parties in the position on certain major aspects of the bill, to which Honorable Deputy Prime Minister has referred earlier. So we really do not believe
that a select committee would have been able to resolve all the important differences and find a consensus. I believe that what we need now is action, and this requires courage, determination, and strength of purpose, which we do have. Mr. Speaker, sir, the House must have noted that at no point in time did the Leader of the Opposition or Honorable Paul Raymond Béranger make any comment on the content of the bill. They did not mention even a single clause in the bill. So we are not aware what are they really contesting in the bill. Honorable Paul Raymond Béranger simply said, nous voulons une bonne loi, une loi digne de ce nom, which they are going to bring once they come to power. But he did not give the slightest clue about the content of that bonne loi and how it would be different compared to the present one. Mr. Speaker, sir, the fact of the matter is that any political financing legislation worth the name has got to have certain essential elements for it to be effective, namely an independent oversight mechanism, appropriate record keeping and reporting, sufficient disclosure, and dissuasive sanctions for breaches of the rules. The political financing bill which is before the House today does include these fundamental elements that guarantee its effectiveness. There is therefore no reason really not to vote for this bill. Mr. Speaker, sir, I would like to take a point raised by Honorable Ramphal, and I think Honorable Utim also made the same remark, insinuating that there have been only cosmetic changes in the proposed bill compared to the 2019 version. This is simply not true. And I must say, Mr. Speaker, sir, that the Ministerial Committee has brought certain important changes to the bill, which are far from cosmetic ones. And some of them were suggested by the opposition themselves in 2019. And I must say that the Ministerial Committee, Mr. Speaker, sir, has worked very hard. And I'm happy today to see my friend, Honorable Ivan Kolenda-Velu, who was part of the Ministerial Committee, who has made valuable contribution. And we all together, we looked at each and every criticism that was made by the opposition then. And let me mention a few of those changes that have been incorporated in the new bill. The Electoral Supervisory Commission will now have to give reasons in case it decides to reject an application for registration made by a political party. Provision has been made for a right of appeal in case of refusal of registration by the ESC. The definition of donation in kind has been widened to include high-cost items such as marquees, transport, and public address system. A party leader, candidates, and their agents are now allowed to accept political donations, thus eliminating the apprehended bottlenecks when all donations were required to be channeled through the treasurer only. Any loan written off will be considered as a cash donation and will have to be accounted for accordingly. In order to reduce burden on political parties, they will no longer be required to have their statement of accounts audited by a qualified auditor before submission to the Electoral Commissioner. Non-resident citizens are being included in the list of prohibited donors. Enhanced powers are being vested in the Electoral Commissioner for monitoring and investigation purposes. Tougher sanctions are being provided for breaches of the rules in terms of fine, which is being increased from up to 1 million rupees to up to 5 million rupees. This new bill mentions all the specific information which the ESC will be required to submit in its annual report to the National Assembly on the statement of accounts of registered political parties. The monetary value of donations in kind received has been integrated in the allowable expenditure ceilings of parties and candidates. The expenditure ceiling for the Rodrigues Regional Assembly elections has been revised upwards to 300,000 rupees. And for better traceability of funds, a bank account will be a requirement for registering a party. Mr. Speaker, sir, these are important changes that have been brought to the bill in order to enhance its implementability and effectiveness compared to the one which was presented in 2019. The Ministerial Committee, as I say, has invested a lot of time and efforts to bring these improvements on various aspects of the bill. It is certainly not a bill which has been réchauffé, as mentioned by Honorable Utim. And the changes brought to the bill are not cosmetic by any standard. Mr. Speaker, sir, several speakers from the other side, including Honorable Utim and Honorable Ramphol, criticized Honorable Obigadu and Honorable Ganu for changing their initial stand on the political financing bill. Well, both Honorable Obigadu and Honorable Ganu have already given a fitting rebuttal to the accusations during their interventions. However, on my part, I would like to refer Honorable Utim and Honorable Ramphol to what Dr. Desmond Ford rightly said, and I quote, "A wise man changes his mind sometimes, but a fool never. To change your mind is the best evidence that you have won." Unquote. Mr. Speaker, sir, I also wish to dissipate the confusion which may have been created in the minds of people following certain statements made from the other side. Mr. Speaker, sir, there will be no obligation on political parties to disclose the identity of donors, whether big or small, while submitting their return to the Electoral Commissioner. However, the parties will have an obligation to maintain a register of donations which will record, inter alia, the name of the donors, and the Electoral Commissioner will have the right to have access to that register in the course of any of his investigation. In regard to corporate donations, Honorable Ramphol criticized the bill for not imposing an obligation on the corporate entity to obtain the agreement of its shareholders before making a political donation. Mr. Speaker, sir, the bill requires any private entity to secure a written resolution of its governing body before making a political donation. The bill also enjoins a private entity to disclose all political donations, whether in cash or in kind, in its financial statements. These provisions are there precisely to safeguard the interests of shareholders. In any case, it will always be open to a private entity to seek their shareholders' agreement prior to making a political donation. Now, Honorable Xavier Duval, on his part, argued that the conditions being imposed on private entities for this bill will discourage them from making political donations, given that they will have to disclose in their financial statements the names of the recipients. Mr. Speaker, sir, this is an erroneous interpretation of Clause 7.2 of the bill. In fact, the private entity will only be required to disclose in their financial statements the amount of monetary donation and the monetary value of donation in kind. They will not have to disclose the identity of the recipients as wrongly stated. Honorable Xavier Duval also stated that disclosure provisions in the bill are excessive and will do more harm than good. Mr. Speaker, sir, let me remind that one of the main objectives of this bill is precisely to introduce transparency in political financing, and as the former Secretary General of the United Nations, Mr. Kofi Annan said, and I quote, "If corruption is a disease, transparency is a central part of its treatment," unquote. Mr. Speaker, sir, I must say that I also find very regrettable the remarks made by Honorable Xavier Duval, who is still indirectly questioning the integrity and independence of the Electoral Supervisory Commission. In spite of the several Supreme Court and Privy Council judgments dismissing all the electoral petitions lodged by the opposition following the last general election, and which, at the same time, I must say, it did also one great thing, Mr. Speaker, sir, which probably we have not enough emphasized. It has, those judgments have restored the credibility and reputation of the Electoral Supervisory Commission. Mr. Speaker, sir, Honorable Ramphal and a few others have also argued that there should have been a ceiling on corporate donations. Well, this issue of imposing a cap on political donations from private entities was carefully examined at the level of the Ministerial Committee. And we need to understand that political parties are an essential element of our democracy. They play a crucial role, whether in government or in the opposition. And for this, they of course need adequate funding. This is a fact. This is reality. And if they are to play their role as effectively as possible, so our aim is not to undermine any party in any way, as some speakers from the other side want to make believe. On the contrary, through these bills, we are ensuring that parties obtain their funds in ways which are free of suspicions of favors or improper influence. It is also to be noted that in the absence of public funding, which we have not recommended, for the reasons I have explained last week, political parties will have to rely, therefore, only on private donations. The fear of Honorable Ramphal that uncapped corporate donations will unlevel the playing field and corrupt the political process is unjustified, for the simple reason that there is a limit on the amount that a party or candidate can spend during an election period. As long as there is such a cap on expenditure, and of course an effective oversight mechanism, the apprehended risk of undermining the integrity of the political process, I must say, is greatly minimized. Honorable Ramphal also raised an issue regarding the need to bring a consequential amendment to the Declaration of Assets Act to take into account political donations received by a party member or candidate. Well, I would like to clarify that there would be no need for any such amendment, given that political donations received is not an asset of the candidate, as it is considered that donation was made to him in his capacity as a member or candidate of a party. This is also the reason why, in case he is not elected, he is required to remit any unutilized monetary donation to the leader or treasurer of that party. This is also why, when a party member dies, any balance of the monetary donation held in his separate bank account shall be deemed to belong to his party. Because the donation is either to the party or for the candidate being a member of the party for the specific use for campaigning for an election or for election expenses. Therefore, the question of amending the Declaration of Assets Act does not arise. Another issue which was raised by Honorable Rampol was whether a party or candidate can accept cash donations in excess of 500,000 rupees. Well, the answer, I'm really surprised coming from a barrister, because the answer is clearly no, as it would constitute already an offense under Section 37(1) of the Financial Crimes Commission Act 2023 for any person to give or to accept an amount in excess of 500,000 rupees in cash. This means that all cash donations in excess of 500,000 rupees would have to be made by check or electronic transfer. Let me now take a few issues raised by Honorable Utim. In fact, I need to dispel a confusion created by Honorable Utim through his wrong interpretation of Clause 22(3) of the bill. According to him, a political party would have only 4 days to register with the ESC after the issue of writs, and past that delay, a party would not be able to be registered. In the same breath, he accused government of attempting to oust its political opponents from participating in the democratic process by depriving them access to adequate financial resources. Mr. Speaker, sir, Honorable Utim has either totally misread Clause 22, or, which I presume is more so, it is a deliberate attempt on his part to instill fear and confusion in the minds of people. Because being a barrister, he should have known better. In fact, I thought some members of the opposition would have come back. In fact, Mr. Speaker, sir, registration of political parties under this act would be open at all times, except during the period starting 5 days after the day on which writs have been issued and until the proclamation of results. A party does not have to wait for the issue of the writs of elections to get itself registered. This is clearly stated in Clause 22(2), which provides as follows, and I quote, "Subject to subsection 3, an application for registration shall be made at any time to the Commission in such form as may be prescribed and shall contain the following particulars," unquote. Mr. Speaker, sir, I wish to highlight the fact that for the purpose of fielding candidates for a general election, Regulation 7 of the National Assembly Election Regulations 2014 provides that a political party shall register itself with the ESC at least 10 days before the nomination day. This means that a party may not apply or get registered prior to the issue of writs and after the proclamation of the results, contrary to Clause 22 of the present bill, which allows registration at all times except during the period which I have just mentioned. Honorable Utim also spoke about the advantage of incumbency of the government, arguing that the latter having the prerogative to decide on the date of elections, would have an unfair advantage over other contestants. He wanted to create an impression that somehow this law would not apply to the party in power. Mr. Speaker, sir, this law, if passed and proclaimed, would apply equally to all political parties without discrimination, and we on this side of the House have absolutely no issue about complying with the provisions of this law. Mr. Speaker, sir, Honorable Xavier Duval and Honorable Outim both raised concerns, unjustified of course, regarding the expenditure ceilings, which they said have been increased further in the present version of the bill, and are therefore very much on the high side, according to them. Mr. Speaker, sir, let me clarify this matter. Indeed, in the 2019 version of the bill, the expenditure ceiling for a party was set at 1 million rupees per constituency. And for party candidates, it was 1 million rupees per candidate. But what Honorable Duval and Honorable Outim do not seem to realize is that these ceilings initially excluded donations in kind, which was set at 50% of the allowable cash ceilings. Now, with a view to simplifying the accounting and reporting of donations in kind, the ministerial company, in its wisdom, considered that it would be more appropriate for the monetary value of the donations in kind to be integrated into the allowable expenditure ceilings of a party and candidates. It means, therefore, that the expenditure ceilings for a party and candidates have not actually been increased. It has remained the same. Regarding the assertion of Honorable Duval and Outim that the proposed new ceilings are on the high side, I would like to refer them to the observations and proposals made in the Leung report in this respect. And to put things in the right perspective, let me read the relevant part from the Leung report of 2004, and I quote, "Limits must undoubtedly be set on the maximum amount of money that may be spent by an individual candidate or by a political party during a general election. However, the spending limits for individual candidates and political parties are currently set at unrealistically low levels and constitute a mighty inducement to candidates to under-declare their expenditure when making their returns. To quote the Sachs report, these ceilings are observed only in their breach. It is the opinion of the Select Committee that those levels should be revised upwards to a level which a campaign would reasonably cost in order to abate and reduce the potential for violations. At the request of the Select Committee, the Central Statistics Office has carried out an exercise to estimate the costs borne by candidates in 2000 and the costs expected to be borne by candidates in 2005. The results of the exercise show that the estimated mean expenditure in 2000 was 633,700 rupees, and the expected mean expenditure in 2005 will be around 1 million rupees. In the light of the exercise of the Central Statistics Office, the Select Committee is of the opinion that the spending limit should be set at a more realistic ceiling in order to remove the perception that such ceiling is observed only in their breach. The spending limit at the general election should accordingly be set uniformly at 1 million rupees for individual candidates, as well as candidates forming part of a political party. It must further be made possible to revise this figure by way of regulations, unquote. Yeah. Yeah. 2000, by candidates in 2005. Can you imagine at that time? Mr. Speaker, sir, according to the report, the expected mean election expenditure in 2005 would have been around 1 million rupees. And that figure, 1 million rupees, if adjusted for inflation, would today stand at nearly 2 million rupees. Therefore, Mr. Speaker, sir, clearly the new ceilings which are being proposed 25 years later in the present political financing bill are very realistic, fair, and reasonable, and they cannot, by any standard, be said to be unreasonable or exaggerated. May I also remind Honorable Xavier Duval and Honorable Utim that the present ceiling of 250,000 rupees per candidate was set as far back as 1989. That is almost 35 years ago. That is why I say we need to move with time. Mr. Speaker, sir, I also heard Honorable Utim questioning the rationale behind prohibiting non-resident citizens from making political donations. As I mentioned during my second reading speech on Tuesday last, this issue was thoroughly examined by the Ministerial Committee. And the committee came to the conclusion that if non-resident citizens were allowed to make political donations, it would constitute a serious loophole in the law, as it would allow other prohibited sources to circumvent the law and allow the channeling of illicit or tainted money from other prohibited sources and corrode the local political process. Honorable Utim and Honorable Lubin also spoke in favor of diaspora voting and financing. Well, Mr. Speaker, sir, I have, I think on more than one occasion in this House, explained the implications and challenges associated with diaspora voting. I'm not going to repeat all of that today, but let me remind Honorable Utim of the content. Unfortunate that he's not here to listen to everything that he's been saying, to listen to my rebuttal. But, well, I hope they are listening elsewhere in their cozy salon. So, Mr. Speaker, I was referring to the reply to a parliamentary question on diaspora voting, which was given in August 2006 by the then acting Prime Minister. And I quote, "According to Section 42 of the Mauritian Constitution, in order to qualify as an elector, a person must be a Commonwealth citizen not less than 18 years and must have resided in Mauritius for a period of not less than 2 years before such date as may be prescribed by Parliament. For the purpose of residence qualifications, Section 4 and Section 4A of the Representation of the People Act provides that the residence qualifications for the purpose of eligibility to vote, the qualifying date in respect of the register compiled in a year is 1st January of that year. Unless a person satisfies these criteria, he or she will not be allowed to vote. Government is not in favor of voting outside Mauritius. One must have a commitment to the country in order to vote. Experience in other countries has shown that voting outside the country is open to irregularities." Unquote. This is Labour Party. Mr. Speaker, sir, Honorable Utim made several other erroneous statements, such as his assertion that the proposed law will lead to a dictatorship of the leader, as all political donations will ultimately have to be remitted to the leader, which of course is not the case. It's not the case in the bill. But may I ask him, well, he's not here, no, how would I say, no incentive to ask questions. How is it now? How is it now? What happens now? And for the past so many years, is it not the leader who has been getting most of the political donations? Let us be honest. Well, it's given, yes, members also do get political donations, but compare the donations that are given to candidates as opposed to leader of the party. Why leader of the party? Because it is for the party, and it is the leader that has, let's say, the influence on the party. So we should be honest. It's as if now with this law, it's going to be, let's say, different. Giving and allowing also candidates to be able to get financial donations. And not only financial donations, other donations as well. So, as I say, a candidate can accept and retain political donations meant for him. And the only obligation that he has is to submit a report to his leader. And last week I explained the rationale behind this provision is to give a legitimate droit de regard to the leader to ensure that the party and its reputation are protected, especially from dirty money. Honorable Utim also accused that the objective test, which was present in the 2019 bill, in regard to acceptance of suspicious transaction involving proceeds of a crime, has been replaced by what he calls a subjective test. Well, again, it is clear that Honorable Utim has once again misread the bill. As a matter of fact, Clause 10 provides that a recipient must not accept a donation even if he merely suspects that it may originate from the proceeds of a crime. Mr. Speaker, sir, Honorable Xavier Duval and a few others spoke in favor of state funding, underlying that it did form part of the government's initial proposals in 2016 and that it is a current practice in many countries. Well, in my second reading speech on Tuesday last, I delved extensively on the issue of public funding, explaining that this was carefully examined by the Ministerial Committee, which took note of the international practice in this regard, and also previous reports precisely on the issue of public funding. I explained that the main argument in favor of public funding is that it can contribute to ensure a certain level playing field. However, the Ministerial Committee considered that it could be otherwise also, because public funding may well exacerbate the disparity between major political parties and emerging ones. The reason being that a qualified threshold will necessarily have to be imposed for the allocation of public funding. And it is unlikely that smaller parties will be able to attain that threshold. And consequently, even with fair eligibility and allocation criteria, we may end up with polarization of the political arena, with the risk of smaller parties being driven out from the political context. In this regard, let me again quote the relevant observations from the Leung report, and I quote, "The limitative application of the fund may result in two outcomes, which we deem would do injustice to the whole electoral process. Firstly, the strict application of the funding mechanism recommended by the Sachs report would mean that essentially a major political parties would benefit from the fund, thus denying emerging political parties the opportunity for development. This may lead to a natural selection process taking place in the political arena and resulting in the ossification of older political parties which have been in power for a long time. In other words, there will be little or no possibility of turnover of political parties sitting in the National Assembly as a result of this. The reader will certainly appreciate how vital the ease of turnover of political parties in power is in a dynamic democracy. Unquote. Mr. Speaker, sir, when advocates of public funding claim that this is a common practice in many countries, they also fail to highlight the fact that there are great variations in the way such funds are allowed to be utilized by the recipients. Studies carried out in 2012 by International IDEA revealed that 42% of countries having state funding do impose certain limitations on its use. In some countries, the funds are to be used only for campaign purposes, while in others, they may be used for ongoing non-electoral party activities as well. In other countries, the funds are to be used only for fostering international relations, civic education, or for research purposes. Mr. Speaker, sir, these are important questions which we need to carefully reflect upon before envisaging the introduction of public funding. Monsieur le Président, l'opposition a, encore une fois, choisi de se ranger du mauvais côté de l'histoire. Elle a choisi la fuite en avant pour s'opposer à la transparence et maintenir l'opacité sur ses sources de financement. Les prétextes des membres de l'autre côté de la Chambre ne tiennent pas la route. Eux, les donneurs de leçons, ont démontré que leurs belles paroles ne sont que des chimères, alors qu'en fait, ils sont les défenseurs de ces différentes mafias qui remplissent leur coffre-fort. Monsieur le Président, personne n'a oublié les tristement célèbres coffres-forts contenant 220 millions de roupies découverts au domicile de l'ancien Premier ministre, le docteur Navin Chandra Ramgoolam. Les images des dollars et autres monnaies déferlant de ces coffres-forts ont choqué la nation. C'était l'expression même du niveau de corruption qui avait gangréné notre société durant le règne du Parti travailliste entre 2005 et 2014. Jusqu'à présent, le docteur Navin Ramgoolam, leader du Parti travailliste et leader de l'Alliance travailliste MMM Nouveau démocrate, n'a fait que fournir des explications contradictoires sur les sources de ce pactole et encore plus sur la provenance de 3,1 millions de dollars neufs et jamais mis en circulation qui avaient atterri dans ce coffre-fort à Riverwalk. Il est sur le coup de très graves charges incluant le blanchiment d'argent, mais agit comme si de rien n'était. Il se permet des tactiques dilatoires pour retarder, là je prends des mots qui ont été servis dans le passé, pour retarder les délibérations en cours et gagner du temps. Et son grand frère autoproclamé, l'honorable Paul Raymond Béranger, trouve tout cela normal et acclame ses arguments bancals. Fait marquant, Monsieur le Président, le MMM est aujourd'hui complice de cette conspiration du Parti travailliste pour justifier la corruption et l'opacité. Quelle honte! Certaines sections de la presse trouvent tout cela normal, alors que l'affaire des coffres-forts de Ramgoolam, c'est ça le vrai scandale du siècle. C'est prendre les Mauriciens pour des imbéciles, Monsieur le Président. Et l'avenir nous dira quel sera le sort de tous ceux qui se sont ligués pour cautionner la corruption sous sa forme la plus révoltante. Ce sont ces mêmes personnes, politiciens et certains journalistes, qui se sont ligués pour présenter les projets de loi devant la Chambre comme monnaie, avant même de prendre connaissance de leur contenu. Quelle insulte à l'intelligence de nos compatriotes. Monsieur le Président, les vraies raisons derrière la position adoptée par l'opposition parlementaire contre la réforme du financement politique demeurent leur allégeance envers les mafieux qui remplissent leurs caisses. J'ai dit et je redis que la mafia de la drogue finance cette opposition parti travailliste, MMM, et le nouveau parti Subitex, je crois. Parce que mon gouvernement agit sans pitié contre les marchands de la mort. Il faut se rappeler qu'au temps du parti travailliste au pouvoir, cette mafia a été montée en puissance, tellement elle est protégée. La preuve, le parti travailliste et son leader, le docteur Navin Ramgoolam, n'ont jamais voulu instituer une commission d'enquête sur la drogue. C'est un fait, et la population en connaît la raison. Surtout que la connexion entre le parti travailliste et des individus mêlés au trafic et possession de drogue saute aux yeux. J'avais donné des exemples lors de mon summing up sur le Financial Crimes Commission Bill. Et je crois utile, en la circonstance, de rappeler certains faits indéniables qui établissent cette connexion mafieuse. Un certain Hashish D. Hashish, je ne parle pas de la drogue, là, hein, je parle du prénom. Hashish D. Protégé de Nita et grand agent du Parti travailliste à Belle-Rose, 4-Beaune, a été condamné aux assises à 40 ans de prison au trafic de 2 kilos d'héroïne d'une valeur de 30 millions de roupies. Un certain Jonathan A., alias Tipapier, très proche du leader du Parti travailliste, le docteur Navin Ramgoolam, a fait l'objet d'une enquête concernant le trafic de drogue et le blanchiment d'argent. Il a été condamné pour outrage à la cour. Vimen S., bodyguard, pas seulement bodyguard, manger, boire avec le leader du Parti travailliste, le docteur Navin Ramgoolam, a été arrêté pour possession de 10,35 kilos d'héroïne d'une valeur de 155 millions de roupies. Un certain Michael Ricardo Gilbert KCTM, chauffeur attitré de l'honorable PA dans la circonscription numéro 18 durant la campagne électorale de 2014, a été, alias Lampoule, peut-être, a été arrêté pour possession et trafic de drogue après la saisie à son domicile de 7,3 kilos de cannabis d'une valeur marchande de 6,5 millions de roupies et de 9 166 graines de cannabis. Un certain Akil B. Celui-là, c'est un star. Hein, il est membre du Parti travailliste parce qu'il a été filmé. Nous avons tous vu comment il essaie de se débarrasser de sa cargaison. A été arrêté en compagnie de sa concubine pour possession de 53 grammes de drogue synthétique d'une valeur de 260 000 roupies. Ce même individu a été encore arrêté pour l'importation de drogue, en l'occurrence 1022 comprimés d'ecstasy d'une valeur supérieure à 20 millions de roupies. Un autre individu adoré et ouvertement défendu par le leader du Parti travailliste, le docteur Navin Ramgoolam, et d'autres dirigeants, notamment le docteur Arvin Boulel, leader de l'opposition, un certain Bruno L., a été arrêté pour possession de 44 0,25 kg d'hachiche d'une valeur supérieure à 221 millions de roupies. Et ajoutez à cela maintenant, comme si pour renchérir ce groupement, nous avons Nouveau Démocrate. Qui ne connaît pas la proximité de son leader, Richard Duval, avec une certaine Cindy Le Galant, qui transitait par le VIP Lounge à l'aéroport sur intervention de cet honorable membre de l'Assemblée nationale pour faire entrer des milliers de comprimés de Subitex dans le pays. Monsieur le Président, la position adoptée par les députés du MMM décline encore une fois leur connexion, hypocrisie, malhonnêteté et complicité. Et a-t-on oublié comment, avec quel verbe le député Outim avait défendu un caïd de la drogue sur le plan international, un certain Peter Jurisek, que les autorités mauriciennes avaient logiquement remis aux autorités slovaques. Ce criminel que d'autres membres de l'opposition avaient aussi défendu dans cette chambre a été condamné à 22 ans de prison en Slovaquie pour fabrication, possession et trafic de drogue. La population avait pu constater comment ces membres de l'opposition s'étaient mis dans le camp d'un marchand de la mort. Dois-je encore rappeler que le MMM, qui se gargarise du slogan « l'âme est propre, la tête haute », n'a pas hésité une seconde à encaisser les 10 millions de roupies venus de la BAI, qu'il avait pourtant dénoncé en premier pour des transactions financières illicites opérées par le biais d'un Ponzi scheme. Et ce n'est pas tout concernant le MMM. J'ai dit à plusieurs reprises dans cette auguste chambre que le MMM bénéficie de financements occultes d'une compagnie privée, parmi plusieurs. Là, je parle d'une compagnie spécifique. Et chaque mois, un pactole atterrit dans ses caisses à travers les bons services d'une compagnie dans le secteur des services financiers, que connaît très bien l'honorable Amir Mia. J'ajouterai aujourd'hui un autre élément à ce dossier. Ce financement occulte découle d'un deal secret concocté depuis 2001, au temps où un certain JMG, officier comme General Manager de la dite compagnie, et au moment de l'interdiction de l'extraction du sable corallien pour la construction au profit du Roxane. Les protagonistes avaient profité d'une cause environnementale pour exécuter leur agenda caché. L'honorable Bagwan sait de quoi je parle. Et le MMM, c'est le parti le plus pauvre que les partis extra-parlementaires aussi. Ils n'ont pas d'argent. Ils n'ont pas d'argent. Et vous savez, Monsieur le Président, où se tiennent leurs conférences de presse, leurs réunions chaque semaine dans des hôtels. Je ne sais pas si c'est gratos, c'est offert gratos, mais on connaît également le financement occulte dont a bénéficié le MMM et le Parti travailliste du réseau mafieux des courses hippiques. Il n'y a qu'à voir la liste des membres de certains clubs privés pour se rendre compte des connexions tissées au fil des années. Voilà ce que le MMM et le Parti travailliste veulent cacher. Voilà pourquoi ils s'opposent à la transparence que les deux projets de loi veulent apporter en ce qui concerne le financement politique. Monsieur le Président, on a aussi témoigné comment les membres de l'opposition se sont prononcés avec véhémence contre le réenregistrement des cartes SIM. Pourtant, cette initiative découle d'une recommandation de la commission d'enquête Lam Shangling sur le trafic de la drogue. Que veulent-ils protéger encore une fois? Il n'est pas difficile d'en tirer la conclusion. L'opposition s'est aussi opposée au texte de loi sur la création de la Financial Crimes Commission. Elle continue de s'opposer à cette nouvelle institution. Leur motif, une nouvelle fois, est lié à leur proximité avec les mafieux, qui contribuent à leur war chest politique. Cette opposition ne veut pas que la population découvre les tenants et aboutissants des coffres-forts de Navin Chandra Ramgoolam. Le Parti travailliste veut continuer à cautionner les abus de son leader, qui s'est permis de dévaliser même l'argent de son parti pour séjourner dans des palaces en Europe et s'acheter des produits super luxueux, mentionnés par l'Attorney General, donc que je ne vais pas répéter aujourd'hui. Encore une fois, comme en 2019, les membres de l'opposition s'attaquent au projet de loi sur la réforme du financement politique pour les mêmes raisons. Loin de se soucier des intérêts nationaux et celui de leur propre parti. C'est cela la vérité. L'Attorney General l'a bien dit. Les donneurs de leçons de l'opposition qui prônent la transparence depuis belle lurette s'opposent à des projets de loi qui, justement, visent la transparence en ce qui concerne les financements et les dépenses politiques. Contrairement à eux, nous traduisons nos paroles et nos engagements en des actions concrètes. Nous n'avons aucune mafia à défendre. Nous n'avons rien à cacher. Nous avons la conscience claire. C'est pourquoi nous agissons avec fermeté, courage et détermination. Les allégations faites par l'opposition en relation au financement qu'aurait reçu le MSM d'un businessman sont totalement fausses. La personne en question a lui-même déclaré qu'il n'a pas donné un sou à mon parti. C'est cela la vérité. Monsieur le Président, c'est un fait que la lutte contre les barons de la drogue et autres groupes mafieux, immensément riches et puissants, n'est pas une bataille facile. Mais mon gouvernement ne ménage aucun effort pour traquer ces individus et groupes et mettre fin à leurs activités illicites. Nous sommes résolument engagés à lutter contre toute forme de mafia qui menace notre société et nos traditions démocratiques. De par leur comportement et la position adoptée contre les projets de loi devant la Chambre, l'opposition se démasque davantage. La population sait maintenant qu'elle a affaire à des défenseurs de multiples mafias qui veulent perpétuer l'opacité au détriment de la transparence, l'état de droit et de la bonne gouvernance. En choisissant de ne pas voter en faveur de ces projets de loi, c'est un autre clou qu'enfonce l'opposition dans ce cercueil politique. Le peuple enfoncera le dernier clou au moment venu, j'en suis convaincu. Time will tell whose chapter will be closed. Monsieur le Président, l'opposition, en particulier l'honorable Boutim, a qualifié le projet de loi sur le financement politique comme étant un mot-né. Permettez-moi de vous dire que ce projet de loi restera vivant dans la mémoire de la nation. Mais hélas, oui, l'histoire retiendra qu'il y a eu un assassin qui est nul autre que la présente opposition. Quant à nous, nous avons fait que notre devoir envers notre pays. Mais comme disait l'humoriste français Raymond DeVos, et je le cite, « On a toujours tort d'essayer d'avoir raison devant des gens qui ont toutes les bonnes raisons de croire qu'ils n'ont pas tort. » Mr. Speaker, sir, there is no doubt that political funding has the potential to undermine democratic governance. Corruption through undue influence is arguably more insidious and damaging to the democratic process than explicit forms of corruption, where the receipt of private funds leads directly to political power being used to favor financial contributors. When campaigns are fueled by uncontrolled or undisclosed money, the outcome may not reflect the will of the voters. This is why, in recent times, all democracies, both advanced and emerging, have embraced broad-based reforms in political finance. Countries have been active in creating more transparent and accountable political finance systems to enhance the integrity of the political process and ensure a level playing field. Mauritius cannot afford to remain an exception. As far as this government is concerned, it has consistently tried to improve accountability and transparency in the management of public affairs. The passing of the new Declaration of Assets Act in 2018, and more recently, the Financial Crimes Commission Act, are two major and concrete initiatives, amongst others, which testify to our commitment to enhance our overall governance framework. Mr. Speaker, sir, as I said in my speech last week, regulating political finance raises complex and challenging issues, especially in a small country like ours. Nevertheless, the Ministerial Committee has painstakingly but effectively addressed all these issues and finally come up with the proposals embodied in the political financing bill. I must say it was a complicated task, requiring much of our time and efforts, as we had to take into account and strike a fair balance between different factors, such as the specific nature of our electoral system, our institutional regime, our unique combination of political, historical, economic, and societal factors. The bill has therefore been carefully shaped to fit our local context and realities. It is also carefully balanced against the need to respect freedom of expression and association. It is simple, yet robust and implementable. This bill represents a major and decisive step in the right direction, and the measures embodied therein will only fortify the pillars of our democracy. And it is therefore a bill that serves the national interest. Therefore, Mr. Speaker, sir, it is really a pity that this opposition is bent on thwarting, once again, such a laudable initiative aimed at introducing the much-needed transparency in the political life of this country. The consequence of this irresponsible boycott by this opposition of this initiative will mean that control and supervision of political financing in Mauritius will continue to remain a dead letter. Mr. Speaker, sir, I find no better way to conclude my speech than by quoting the philosopher and political thinker, Mr. Edmund Burke, who said, and I quote, "Nobody makes a greater mistake than he who does nothing because he could only do a little," unquote. Mr. Speaker, sir, we on this side of the House, we have decided not to commit the mistake of doing nothing. We have decided to act for the sake of our country, and our response is embodied in the two bills which we have presented to this House. Thank you.
Commend the bill. Seconded. Question is that the Constitution Amendment Bill number 5 of 2024 be read the second time. Those in favor say aye, those against say no. The ayes have it. The question is that the Political Financing Bill number 6 of 2024 be read the second time. Those in favor say aye, those against say no. The ayes have it.
Public Bills Committee stage.
Please be seated.
The Constitution Amendment Bill number 5 of 2024, Clause 1 short title, Clause 2, Section 41 of Constitution amended.
Question that clauses 1 and 2 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
The title and enacting clause.
The question is the title and enacting clause stand part of the bill. Those in favor say aye, those against say no. The ayes have it. Question that I do report to the House that the Constitution Amendment Bill number 5 of 2024 has passed the committee stage without amendment. Those in favor say aye, those against say no. The ayes have it.
The Political Financing Bill number 6 of 2024, Clause 1 short title, Clause 2 interpretation, Clause 3 application of Act, Clause 4 political donations only to recipients, Clause 5 political donations received on behalf of registered political party, Clause 6 political donations received on behalf of candidate, Clause 7 political donations by private entity, Clause 8 unutilized monetary donations, Clause 9 prohibited political donations, Clause 10 suspicious donations, Clause 11 register of political donations, Clause 12 report on political donations, Clause 13 accounting records of political parties, Clause 14 statement of accounts of political parties, Clause 16 restatement of non-compliant statement of accounts.
Question that clauses 1 to 15 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 16 report of electoral commissioner, Clause 17 supervisory role of commission, Clause 18 functions and powers of electoral commissioner, Clause 19 powers of investigation, Clause 20 powers of entry and search, Clause 21 directives, Clause 22 application for registration, Clause 23 deregistration of political parties, Clause 24 change in office bearers, Clause 25 offences, Clause 26 jurisdiction, Clause 27 regulations, Clause 28 consequential amendment, Clause 29 commencement.
A question that clauses 16 to 29 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
The schedule.
Question that the schedule stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
The title and enacting clause.
Question is that the title and enacting clause stand part of the bill. Those in favor say aye, those against say no. The ayes have it. The question is that I do report to the House that the Political Financing Bill number 6 of 2024 has passed a committee stage without amendment. Those in favor say aye, those against say no. The ayes have it. Please be seated. Honourable members, I have to report to the House that the Constitution Amendment Bill number 5 of 2024 and the Political Financing Bill number 6 of 2024 have passed a committee stage without amendment.
Public Bills third reading.
Mr. Speaker, sir, I beg to move that the Constitution Amendment Bill number 5 of 2024 be read the third time and passed.
Seconded. Question that the Constitution Amendment Bill number 5 of 2024 be read the third time and passed. Those in favor say aye, those against say no. The ayes have it.
Division of vote.
I beg to move that the Political Financing Bill number 6 of 2024 be read the third time and passed.
Let us we first deal with the Constitution Amendment Bill number 5 of 2024. So you're moving for a division of vote?
Yeah.
Division of vote. Clerk, please proceed with the division.
We will now record the individual votings. Honorable Yang Sik Young, absent. Honorable Wuchit. Honorable Utim. Honorable Sominaden. Honorable So, yes. Honorable Ramphol. Honorable Kirin. Honorable Kirin. Honorable Navamari, suspended. She's absent. Honorable Nagalingam. Honorable Shakil Mohamed, absent. Honorable Osman Mohamed.
No.
Honorable Lobin, absent. Honorable Leopold.
Yes.
Honorable Juman, suspended, absent. Dr. Honorable Ganga Persad, absent. Honorable Mrs. Fukyun Basha.
No. No.
No. Honorable Richard Duval, absent. Honorable Xavier Luc Duval.
Abstain.
Honorable Dahlia.
Yes.
Honorable David.
No.
Honorable Kolenda Velu. Honorable Boda.
I will abstain.
Honorable Bagwan, suspended, absent. Honorable Paul Raymond Béranger, absent. Honorable Johanna Béranger.
No.
Dr. the Honorable Omir, absent. Honorable Armance.
Abstain.
Honorable Anctil.
No, no.
Honorable Amir Mia.
No.
Honorable Abbas Mahmoud.
Yes.
Honorable Danu.
Aye.
Honorable Lakshman Roy.
Yes, yes, yes.
Honorable Mayot.
Aye.
Honorable Nakchedi. Yes. Honorable François.
Yes.
Honorable Diol.
Yes.
Honorable Babli.
Yes.
Honorable Ramcharan.
Yes.
Honorable Rao.
Yes, I support.
Honorable Jatan, absent. Honorable Ramkor. Honorable Tour. Honorable Asiavaden.
No.
Honorable Itu. Honorable Dulab. Honorable Nazur Ali. Dr. the Honorable
No.
Aye.
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 Yes.
Yes. Aye. Aye. Aye.
Aye. Aye. Aye.
Aye.
Aye.
Yachi.
Aye.
Honorable Ganu.
Aye.
Dr. the Honorable Asnu.
Yes.
Honorable Mrs. Dukan Lachman.
Yes.
Honorable Obigadu.
Yes.
Honorable Prime Minister.
Honorable members, résultat officiel. No Privy Council. The results of the division are as follows. The ayes have 42, noes 13, abstentions 3, absent 11. Honorable members, I have to inform the House that the Constitution Amendment Bill number 5 of 2024 has on final voting obtained 42 votes, that is, has not been supported by a three-quarter majority as required by section 47(2)(b) of the Constitution. I therefore declare that the bill has not been read a third time and passed.
Public bills, third reading.
Mr. Speaker, sir, I beg to move that the Political Financing Bill number 6 of 2024 be read a third time and passed.
Seconded. Question is that the Political Financing Bill number 6 of 2024 be read the third time and passed. Those in favor say aye, those against say no. Division. Clerk, please proceed with the division.
Individual voting of the Political Financing Bill number 6 of 2024. Honorable Young Sikian, absent. Honorable Uchit.
No. No.
Honorable Utim.
No.
Honorable Sominaden.
Yes.
Honorable Ramphol. Honorable Kirin.
No.
Honorable Navarre-Marie, suspended, absent. Honorable Nagalingam.
No.
Honorable Shakil Mohamed, absent. Honorable Osman Mahomed.
No.
Honorable Lobin, absent. Honorable Leopold.
Yes.
Honorable Juman, suspended, absent. Dr. the Honorable Ganga Persad, absent. Honorable Mrs. Fukyun Basha.
No.
Honorable Richard Duval, absent. Honorable Xavier Luc Duval.
Abstain.
Honorable Dalia.
Yes.
Honorable David.
No.
Honorable Kolenda Velu.
Aye.
Honorable Boda.
I abstain.
Honorable Bagwan, suspended, absent. Honorable Paul Raymond Béranger, absent. Honorable Johanna Béranger.
No.
Dr. the Honorable Omir, absent. Honorable Armance.
Abstain.
Honorable Antil.
No.
Honorable Amir Mia.
No.
Honorable Abbas Mahmoud. Honorable Danou. Honorable Lachman Roy.
Aye.
Honorable Mayot.
Aye.
Honorable Nakchedi. Honorable François.
Yes.
Honorable Diol.
Aye.
Honorable Babli.
Yes.
Honorable Ramcharan.
Yes.
Dr. the Honorable Rao.
Aye.
Honorable Jatan, absent. Honorable Ramkon. Yes. Honorable Tour.
Yes.
Honorable Asiavaden. Honorable Itu.
Yes.
Honorable Dulab.
Yes.
Honorable Nazour Ali. Dr. the Honorable Boulel.
No.
Honorable Ramiad.
Aye.
Dr. the Honorable Ramdani.
Aye.
Dr. the Honorable Chakori.
Aye.
Honorable Tilak.
Aye.
Honorable Mrs. Kunjusha. Yes. Honorable Modu.
Yes.
Dr. the Honorable Jagatpal.
Yes.
Honorable Kalichan.
Aye.
Honorable Balgobin.
Aye.
Honorable Ariram.
Aye.
Honorable Toussaint.
Aye.
Honorable Gobin. Aye. Honorable Siratan.
Aye.
Honorable Ramano.
Aye.
Honorable Bola. Honorable Missy Jiwa Doriaou.
Aye.
Honorable Lejonga.
Aye.
Dr. the Honorable Padayachi.
Aye.
Honorable Ganu.
Aye.
Dr. the Honorable Asnu.
Yes.
Honorable Mrs. Dukan Lachman.
Aye.
Honorable Obigadu.
Yes.
Honorable Prime Minister.
Honourable members, the results of the division are as follows. The ayes have 42, the noes 13, abstention 3, absent 11. Honourable members have to inform the House that the Political Financing Bill number 6 of 2024 has on final voting obtained 42 votes, that is, has not been supported by a three-quarter majority as required by section 47(5)(b) of the Constitution. I therefore declare that the bill has not been read a third time and passed.
Public Bill, second reading.
Public Bill, second reading.
Mr. Speaker, sir, I beg to move that the Water Resources Bill number 8 of 2024 be read a second time. This bill, Mr. Speaker, sir, is a landmark piece of legislation, one that is highly significant for the Republic of Mauritius. L'eau est une des ressources essentielles pour l'humain et pour le développement économique d'un pays. Permettez-moi, Monsieur le Président, de citer Saint-Exupéry, et je cite, « L'eau n'est pas nécessaire à la vie, l'eau est la vie. Cependant, sa disponibilité est de plus en plus limitée et le monde est confronté à des défis sans précédent pour approvisionner les citoyens et aussi à nourrir les populations, vu l'importance de l'eau dans l'alimentation et l'agriculture. Aujourd'hui, on l'appelle l'eau bleue. L'eau devient de plus en plus rare et à travers les décennies, à Maurice et dans le monde, l'accès à l'eau est de plus en plus difficile avec les effets du réchauffement climatique et la pollution des ressources en eau. Nous faisons face à un double défi pour les années à venir. Prévoir l'approvisionnement en période sèche et répondre à une demande qui continue à augmenter chaque année. Au-delà d'être précieuse, l'eau est au cœur du développement durable. Elle est capitale pour assurer un développement socio-économique inclusif. L'importance de ce sujet n'est plus à démontrer. Les gouvernants dans le monde sont appelés à mieux conserver, à mieux utiliser, à mieux gérer et à mieux protéger les réserves en eau. L'eau en tant que domaine public nécessite que sa gestion soit régie par des principes d'équité et de justice sociale. En gérant judicieusement cette ressource précieuse, nous assurons un approvisionnement équitable au peuple, la stabilité économique et la résilience face aux défis environnementaux. Ce projet de loi, Monsieur le Président, va dans cette direction et, comme dans d'autres pays du monde, il y a eu l'intervention de l'État pour un contrôle sur les ressources en eau afin que la population et le secteur agricole puissent avoir un approvisionnement adéquat en période de sécheresse. Monsieur le Président, cela nous a pris du temps pour la préparation de ce projet de loi, vu la complexité du secteur de l'eau et les différentes lois régissant ce secteur. Actuellement, plusieurs ministères et organismes du gouvernement sont concernés par les législations par rapport à l'utilisation, la protection et la conservation de l'eau, et ce, avec des objectifs différents, notamment the Rivers and Canal Act de 1863, the Public Health Act de 1925, the Groundwater Act de 1969, the Central Water Authority Act de 1971, the Irrigation Authority Act de 1979, the Forest and Reserve Act de 1983, the Environment Protection Act de 2002, maintenant the Environment Act 2024, the Local Government Act de 2011. Pendant longtemps, ces lois sont restées inchangées. Certaines ne répondent plus aux exigences socio-économiques actuelles et aux défis liés à la gestion de l'eau, particulièrement dans le contexte d'un État insulaire. D'autres sont vétustes et ne permettent pas une approche intégrée et durable pour la gestion de nos ressources. Monsieur le Président, il n'existe à ce jour aucun cadre légal global régissant la gestion intégrée et durable de nos ressources en eau. C'est impératif que pour mon ministère de présenter une politique de gestion intégrée de ressources en eau et un cadre légal moderne capable de répondre à ces défis. Nous devons considérer l'ensemble du cycle de l'eau dans nos politiques et nos pratiques, depuis la collecte jusqu'à la distribution, en passant par la réutilisation, la préservation et la protection. Le cadre légal doit prévoir des réglementations sur l'utilisation des ressources en eau, la protection des sources d'eau, la gestion des eaux usées, ainsi que des mesures de conservation. Il doit également encourager l'innovation et l'adoption des technologies durables pour une meilleure efficacité dans l'utilisation de nos ressources. Mr. Speaker, sir, all this is clearly reflected in a main object of the Water Resources Bill in the explanatory memorandum. The bill thus provides, 1, a legal framework for the use, management, control, protection, conservation, and sustainable development of water resources in Mauritius. 2, it seeks to safeguard the immediate and long-term public interest for an equitable access to water. 3, ensures water security and resilience. 4, establishes a Water Resources Commission under the aegis of the Ministry. 5, promotes the efficient use of water. And 6, makes provision for and in connection with matters incidental and connected thereto. Mr. Speaker, sir, before I go on to explain the various provisions of the bill to the House, I must say à cette Chambre en toute humilité, Monsieur le Président, that today is a momentous occasion for me. This is the second time in my political career that I'm bringing to this August Assembly another landmark legislation. In the year 2002, under the leadership of late Sir Nehru Jagannath, I introduced the Regional Assembly Bill for the decentralized system of administration for our brothers in Rodrigues. Today, under the able leadership of Honorable Pravin Kumar Jagannath, I have yet again the honor to pilot the Water Resources Bill, another crucial piece of legislation that seeks to address perennial issues in the water sector with a view to building our water security and resilience, thus providing the necessary strong foothold for our republic to pursue a socio-economic growth for the benefit of our population. Monsieur le Président, la gestion des ressources en eau doit être bénéfique pour tous. Les conventions internationales préconisent que les ressources limitées doivent être partagées au bénéfice et à la prospérité de tous les citoyens. Nous avons aussi, en tant que citoyens, la responsabilité de mieux utiliser et protéger cette ressource. Le changement climatique impacte grandement nos ressources en eau. Au cours de mon mandat comme ministre des Services publics, j'ai été témoin de 2 épisodes de sécheresse prolongée causés par des changements dans les régimes de pluie et le volume de précipitations. L'île Maurice est déjà classée comme un pays en situation de stress hydrique et devrait entrer dans la catégorie des pays pauvres en eau d'ici 2030. Monsieur le Président, la gestion intégrée et durable de l'eau est donc essentielle pour construire un secteur de l'eau résilient. Les périodes prolongées de sécheresse affectent à la fois les sphères sociales et économiques. Monsieur le Président, plusieurs facteurs expliquent l'interruption de l'approvisionnement en eau, notamment la disponibilité des ressources en eau, l'inefficacité dans les systèmes de distribution, un manque de planification dans l'utilisation des ressources en eau, une gestion non intégrée du secteur et une demande des citoyens et des opérateurs économiques qui augmente annuellement. Une des solutions serait une approche axée sur une meilleure gestion et l'utilisation de nos ressources limitées, leur conservation et protection. Il n'existe actuellement pas d'approche planifiée ou intégrée pour les projets d'investissement des secteurs publics et privés. Nous avons noté plusieurs manquements à ce niveau. Le résultat d'un manque de planification et de coordination, en somme, Monsieur le Président, une approche en silo et inefficace. Il est donc primordial d'adopter une nouvelle politique de l'eau capable de s'adapter aux changements climatiques, d'augmenter nos ressources en eau de manière efficace et durable afin d'améliorer l'approvisionnement en eau et répondre aux besoins croissants des différents secteurs. Monsieur le Président, augmenter nos ressources en eau seulement ne suffira pas. Il nous faut impérativement réduire le niveau élevé de pertes sur le réseau, ce qui rendra plus viable financièrement le service de distribution de l'eau. Il est aussi nécessaire de mettre en place un cadre légal pour le développement de sources d'eau non conventionnelles telles que le dessalement, la collecte des eaux pluviales, l'utilisation de la technologie pour la production de l'eau, le recyclage et la réutilisation des eaux usées traitées. Ce nouveau cadre légal viendra aussi renforcer les mesures de protection de nos ressources en eau en raison de la menace causée par l'augmentation des activités industrielles, agricoles et commerciales. Pour ce faire, le projet de loi prévoit la mise en place d'une entité nationale dotée d'un mandat clair et des pouvoir réglementaire qui sera chargé de gérer de manière durable et équitable l'allocation des ressources en eau qui appartiennent à l'État de manière juste et transparente, en tenant compte des besoins des différents utilisateurs tels que les agriculteurs, les industriels, les commerciaux et les abonnés domestiques. En outre, elle veillera à la mise en œuvre de mesures de conservation tout en promouvant une pratique efficiente et en encourageant l'adoption des technologies modernes. La protection des ressources en eau sera également au cœur de ces missions. En assurant une coordination nationale, cette entité garantirait une approche intégrée et cohérente de la gestion des ressources en eau, essentielle pour faire face aux défis actuels et à venir. Monsieur le Président, la croissance socio-économique a redéfini le paysage économique et démographique de notre pays. Selon les chiffres du Bureau des statistiques du pays, de l'an 2000 à 2023, c'est-à-dire en 23 ans, le nombre de consommateurs de la CWA est passé de 241 383 à 394 890, une augmentation de plus de 150 000 consommateurs en 23 ans. À travers les décennies, il y a eu l'émergence des nouveaux secteurs économiques au détriment d'autres secteurs. Il est donc impératif que le secteur de l'eau s'adapte à ces changements. Il nous faut une nouvelle politique pour rendre le secteur plus soutenable à travers une protection de nos ressources en eau et aussi à travers une distribution plus équitable. Mr. Speaker, sir, another key rationale underpinning the development of a new and modern water resources legislation is the adoption of a new process in the allocation of water resources. Our main sources of water currently are groundwater and surface water. According to the latest water statistics, rainfall for the year 2023 has been of the order of 4,742 million meter cube, of which surface runoff is 2,845 million meter cube, and evapotranspiration is 1,423 million meter cube. The net recharge to groundwater stands at around 474 million meter cube. According to the same statistics, usage of water resources in year 2023 has been as follows: hydropower, 337 million meter cube out of 956 million meter cube, representing 35%. Domestic, industrial and tourism, 313 million meter cube out of 956 million meter cube, representing 33%. Agricultural, 296 million meter cube out of 956 million meter cube, representing 30%. The domestic sector uses a ratio of 54% surface water and 46% groundwater. Agriculture uses 98% of surface water and 2% of groundwater. And hydropower uses solely surface water. Moreover, average domestic water utilization has increased from 210 million meter cube per year for the period 2000 to 2012 to 260 million meter cube per year for the period 2013 to 2020. For the same periods, agricultural water utilization has declined from 390 million meter cube per year to 335 million meter cube per year. In the year 2023, it has further decreased to 296 million meter cube. This can be in part explained by the fact that agricultural lands are either being abandoned or converted for residential and commercial purposes. It is equally fundamental to highlight that some major water users have been claiming an absolute property right of ownership over water as a prescriptive right in the different rivers flowing through their lands on the basis that they have been availing of these waters over the past several decades or even centuries. Mr. Speaker, sir, utilization of river waters can be either through titles of concession or by order from the Supreme Court. The judgment of the Judicial Committee of the Privy Council in February 2022, in a case lodged by Ciel Limited and Tropic Needs Limited against the Central Water Authority, clearly establishes that, and I quote, the waters of the river formed part of the domain public and could not be acquired by prescription under Mauritian law, end of quote. Moreover, and I quote, public rights cannot be acquired by prescription. The borderers could only hold rights to use water on the basis that their rights could at any time be removed or reduced by the Supreme Court. In any event, it is well established that there can be no prescription against public property, end of quote. The Water Resources Bill accordingly provides that all surface water, including springs, which are the sources of a river, the tributary of a river or stream, are part of the domain public and are inalienable and imprescriptible. Monsieur le Président, de plus, à travers le temps, il y a eu des changements considérables dans l'utilisation des terres qui étaient auparavant principalement sous culture de la canne à sucre et d'autres activités agricoles. Il y a donc lieu d'évaluer et de réévaluer les droits de prélever et d'utiliser un certain volume d'eau d'une rivière à l'origine accordée pour l'irrigation. L'étendue des terres utilisées sous culture de la canne et agricole a été considérablement réduite. Il est donc, Monsieur le Président, opportun de définir un cadre légal solide et moderne et des mécanismes institutionnels appropriés pour remédier aux incohérences et inefficacités qui se perpétuent et aussi d'entreprendre des changements dans une gestion durable pour assurer la sécurité d'approvisionnement de l'eau à Maurice pour les secteurs économiques, mais particulièrement pour le besoin domestique. Le texte de loi, je dois le souligner, Monsieur le Président, met l'accent sur une gouvernance efficace, intégrée et durable des ressources en eau, ainsi qu'à l'intérêt prioritaire de son usage à des fins potables et domestiques, conformément au ODD, c'est-à-dire Objectif de développement durable. Monsieur le Président, je dois préciser que mon ministère a eu plusieurs sessions de travail avec les différentes institutions publiques et les organisations du privé dans le cadre de la préparation de ce projet de loi. Les ministères concernés, les collectivités locales, les associations des consommateurs, Business Mauritius, la Chambre d'agriculture et les représentants des petits planteurs ont été consultés. J'ai également eu une réunion avec les représentants de Business Mauritius, la Chambre d'agriculture et l'ARIM, où ils m'ont fait part de leurs commentaires et propositions. Monsieur le Président, mon ministère a eu recours au service d'un consultant, en l'occurrence M. Melvin Woodhouse, qui a plus de 40 ans d'expérience dans ce secteur et qui a participé à la rédaction de plusieurs lois pour le secteur de l'eau dans plusieurs pays, notamment le Nigeria, la Tanzanie, le Népal et le Chili, entre autres. Nous avons aussi eu recours à l'expertise de l'ancien chef-juge, son Excellence M. Ashraf Ali Konai, comme conseiller légal pour la préparation et la finalisation de ce projet de loi. Mr. Speaker, sir, I will now go through the main provisions of the Water Resources Bill, which comprises 8 parts. At the outset, I would like to outline that the provisions of the bill will apply to the Republic of Mauritius with specific provisions regarding Rodrigues at Part 7 of the bill. It advocates an integrated and holistic approach to the management of water resources. Mr. Speaker, so water secure planning relies on a coherent water policy. The globally accepted framework for the holistic and sustainable management of water resources is the IWRM, that is, the Integrated Water Resources Management. This is a process organized on 3 principles, namely social equity, economic efficiency, and ecological sustainability. It is endorsed by the UN Water Conference, the World Water Forum, and reiterated in the UN Global Sustainable Agenda under SDG 6. The global endorsement of IWRM underscores its importance in achieving sustainable development goals and addressing the complex challenges of water security in the 21st century. Thus, Mr. Speaker, sir, the objects of the bill listed at Section 4 are inter alia, to promote the efficient use of water and to provide for an integrated management of water resources, safeguard the immediate and long-term public interest for an equitable access to water and its beneficial use for social and economic development, promote and coordinate the coherent, orderly, and optimal use of water resources for the public benefit, develop preparedness, adaptation, and resilience strategies to address the adverse effects of climate change in relation to water resources, adopt appropriate management approaches and technologies for the purpose of reducing the waste or loss of water, promoting water recycling, reuse, desalination, and alternative water sources, encourage and require water users to contribute towards the protection of the quality of water and to carry out their activities by way of cooperation and a mutually shared understanding of the growing stress upon finite water resources. Mr. Speaker, sir, it is important to outline that this bill provides a clear demarcation of responsibilities in respect of development and mobilization of water resources on one hand, and the treatment and distribution of water by the CWA for potable use and other uses on the other hand. Infrastructure that belongs to the Central Water Authority or that is being run by the Central Water Authority for the purpose of supplying treated water on the coming into operation of the Act will continue to be vested in the Central Water Authority. Hence, the CWA will continue to develop, operate, and maintain its boreholes, pumping stations, service reservoirs, water treatment plants, containerized pressure filtration plants, and distribution network. On the other hand, infrastructure used for mobilization and development of water resources, such as dams and feeder canals, will be vested in the Water Resources Commission. These are listed in the first schedule. Part 2, Mr. Speaker, sir, deals with the framework for water resources management. Mr. Speaker, sir, Part 2 of the bill elaborates on how water resources would be managed, the establishment of a Water Resources Commission with a legal entity as a department within my ministry, as well as the powers and duties of the minister. The current Water Resources Unit will be revamped into the Water Resources Commission. This commission will be responsible for the management of all surface water, underground water, springs which are part of domain public, and the vested publicly owned water resources infrastructure. The commission will be responsible to the supervising officer of the ministry for the proper discharge of its functions. The main functions of the Water Resources Commissions are A, to be responsible for the use, management, control, and development of water resources in relation to water use for all purposes. B, to monitor and enforce measures for the conservation, efficient use, and protection of water resources and their related environment. C, to be responsible for the management of bulk raw water. D, construct or cause to be constructed dams, barrages, and such other works, structures, and devices as may be necessary to provide bulk raw water supplies. E, elaborate and implement plans for the development, mobilization, and sustainable use of water resources, which incorporate integrated water resources management, optimal utilization of water resources, schemes for desalination, and other alternative water resources. F, maintain and update a national inventory and database of water resources and hydrological data and registers of the water use permits and existing water rights. G, monitor the quality of surface and underground water and ensure protection against the discharge of effluents or any other activity which may adversely impact upon the quality of any water resource. H, ensure safety and maintenance of vested water resources, infrastructure, and inspect and monitor privately owned water resources infrastructure on safety requirements. I, maintain, monitor, and manage restricted areas, buffer zones, and reserve uses of water as are prescribed and required. And J, undertake measurements and analyses to determine availability of water resources. In the discharge of its functions, the Water Resources Commission can enter into agreements with public departments for the supply of bulk raw water, establish and maintain accredited laboratories and monitoring stations, as well as establish hydrological areas and define river basins for proper water resources management. Mr. Speaker, sir, the duties and responsibilities and powers of the minister in this governance structure are decisive. The minister will set national objectives and goals to ensure long-term water security and sustainability of water resources, and will have developed and implemented the relevant strategies and policies. Given that water resources cut across several institutional jurisdictions, there is a duty to ensure cooperation and coordination among public and private stakeholders, as well as monitor activities in relation thereto. With a view to ensuring that adequate water is available for public consumption and to meet the water requirements of the population, the minister will have the power, upon the recommendation of a multi-sectoral committee established under Section 16 of the bill, to vary temporarily the use of water granted to a user, authorized drawing of surface or underground water for a specific period of time, authorized drawing of water from surface and underground or desalination of seawater until a permit is issued, initiate procedure for land acquisition in accordance with the Land Acquisition Act for the management, use, and protection of water resources if deemed necessary in the public interest. It will be the Water Resources Technical Committee, comprising stakeholders from various ministries and institutions, that will make recommendations for the minister to exercise such powers. The actions referred to at Section 7G are of a temporary nature and for a specific period of time and are dependent on circumstances. Mr. Speaker, sir, as I have mentioned previously, I have witnessed 2 prolonged drought periods during my tenure as minister responsible for public utilities. It has been deemed important to include the above section in order to ensure that necessary action can be taken promptly in times of emergency or dry season to prioritize potable water for public consumption through mobilization of adequate water resources from surface or ground. In fact, Mr. Speaker, sir, there have been instances of public outcry over the past years, particularly in water-stressed regions where there is an inadequate volume of water mobilized by the CWA due to a declining levels of boreholes and reduced flow in rivers during prolonged dry period. The above provision in the bill should provide the necessary leverage for the minister and the Commission to intervene positively and affirmatively in the public interest. Mr. Speaker, sir, one of the reform areas in the governance of water resources is the introduction of a water allocation system, whereby all the waters in the domain public or vested in the state would be shared with water users in accordance with clearly spelled out and transparent criteria. This process and its mechanism are defined at parts 2 and 3 of the bill. Any person wishing to draw water from a surface source or underground will have to apply for a water use permit to the Water Resources Commission. A multi-sectoral committee, that is the Water Resources Technical Committee, comprising representatives from concerned ministries such as agriculture, environment, housing, local authorities, etc., will examine applications received in compliance with procedures specified in the bill and make recommendations to the minister. The criteria to be taken into consideration by the committee in determining the water entitlement is already laid out in the bill at Section 8 and include the following: priority to be given to ensuring adequate supply of water for the needs of the population and for purposes of public utility and safety in the national interest. Current and future social and economic needs, availability of water resources in the catchment or hydrological area, need for conservation and protection of water resources, environment protection of ecosystem, and preparedness for climate change. In addition, Section 23 of the bill specifies the factors to be taken into consideration for the purpose of making a recommendation, and these include, inter alia, A, the availability, intended volume and purpose of use of water; B, the requirements laid down in Section 8 for the purpose of determining the entitlement to the use of water. C, whether any construction work, abstraction or discharge of surface or underground water, or the abstraction of brackish or seawater is in a location or area protected by law from such development or use. D, whether the use of the water, discharge of water, or any associated construction work would contravene or is likely to contravene this act or any other enactment. E, whether the use of the water or the consequences of its use would pose a direct risk to the public health or the environment. And F, whether the applicant has the ability and capacity to comply with and to fulfill all the requirements under this Act. Sections 8 and 23 of the bill together ensure a transparent and objective approach to determining water allocation to applicants and water users. Mr. Speaker, sir, the composition of the Water Resources Technical Committee is such that it will enable it to fulfill its function as per Section 19 of the bill. Mr. Speaker, sir, all recommendations of the Water Resources Technical Committee made to the Minister will be submitted for approval of Cabinet. The House may note that water allocation through permits for a defined period subject to renewal is a global trend. It is an internationally adopted practice where existing entitlements are appraised and reassessed for increased efficiency. So, Speaker, sir, an article published in 2021 in the Review of European Comparative and International Environmental Law Journal analyzes 220 policies and laws governing water use permits of 60 Anglophone and Francophone countries of Africa and Asia. The article concludes that most states have put water in the domain public and governments are the custodians of the nation's fresh water. Mr. Speaker, sir, as regards the duration of the water use permit, the key issue is to strike an appropriate balance between the security needed to encourage investment and the need for flexibility as regards future allocations of water. The article also concludes that permits of indefinite duration are not considered feasible. Mr. Speaker, sir, several countries that have transitioned away from traditional water regimes have adopted such modern frameworks to better manage water resources, especially taking into account factors that influence water resources such as climate change, seasonal variation, shifting of societal needs and priorities, efficiency of use, technological advancements, economic consideration, and ease of regulatory oversight. A noteworthy point to highlight is that, unlike the right to use water under the Rivers and Canals Act of 1863, which was for an indeterminate duration and for a fixed purpose, which is irrigation, the water use permit provided under the Water Resources Bill is flexible, first in terms of volume allocated and purpose and duration of use. Mr. Speaker, sir, Part 3 of the Water Resources Bill caters for the process of applying for a water use permit, processing and examination of the application under a predefined criteria by the Water Resources Technical Committee, payment to be effected, and alterations to be made to the permit. Under Section 26, a water use permit is valid for a period not exceeding 5 years and may be renewed for successive periods of 5 years or less. The validity period is a function of the rate of decrease of surface underground water flows generated by climate variability, simultaneous increase in demand for the resource, and the proposed regular review of the hydrological areas. Subsection 26(4) lists out what the permit will cover, such as period of validity, purpose of use, any special conditions during dry season or for environmental concerns, and fees applicable. Sections 26 and 30 set out the obligations of each permit holder and conditions attached to the permit. This includes regulating the use of water during times of shortage or emergency or in the public interest, and obligating the permit holder to actively conserve, protect, and use water efficiently and have recourse to alternative water sources as may be available, for example, using recycled water to reduce strain on conventional water sources. Mr. Speaker, sir, yet another provision of the bill which contributes towards making available adequate water resources for the needs of the population during times of water shortage or emergency is at section 29 in respect of variation of permit in public interest. Section 29 specifically authorizes the minister, acting on the recommendations of the Water Resources Technical Committee, to direct the Water Resources Commission to limit in whole or in part the water allocated under any existing water use permit where the minister has reasonable cause to believe that it is in the public interest during times of water shortage or emergency to vary or modify the terms and conditions of any entitlement to the use of water in order to supply water for the needs of the public. Such action will call, Mr. Speaker, sir, for a protocol to be put in place by the Commission so as to safeguard the interests of concerned stakeholders while keeping in view priority to be given to water for public consumption. Mr. Speaker, sir, this protocol will be elaborated in close consultation between the public and private stakeholders. The protocol will provide for the setting up of a joint committee to assess and monitor the water resources situation prevailing during the year and the forecast of availability of resources prior to onset of rainy season. A persistent deficit in the rainfall situation and its impact on our water resources will trigger appropriate actions under the protocol. The Water Resources Technical Committee will thereafter make relevant recommendations to the Minister in the event that the Minister will have to exercise his statutory powers under the bill. Section 32 of the bill exempts the Commission from the requirement to obtain or hold a water use permit in respect of any enterprise or activity undertaken in the discharge of its duties and functions under this Act, for example, for the construction of a dam. Subsection 3 exempt the CWA from the requirement to obtain or hold a water use permit in respect of water which is already being abstracted or taken or used by the CWA and the commencement of this part of the Act. However, for the purpose of maintaining a national register of water resources, the CWA will have to submit all details of water abstraction to the Water Resources Commission. Moreover, the bill provides at Section 25 for a water resource to be declared as reserve use, that is, to be used only to supply water for public consumption or for purposes of public utility and safety. Mr. Speaker, sir, in order to cater for the immediate supply of water for public purposes during times of acute water shortage or emergency, the bill further provides for CWA to be exempt from the requirement to hold or obtain a permit for both surface and underground water so as not to allow it to act promptly and expediently in such challenging times. For all projects undertaken during times of acute water shortage or emergency, the CWA will be required to submit to the Commission details such as the location of such water sources and volume abstracted to enable the Commission to update its inventory register of water sources and for subsequent water allocation to applicants. Mr. Speaker, sir, Part 4 of the bill is divided into 4 subparts, namely relating to general provisions, rivers and canals, dams, and underground water. The Water Resources Bill at Section 36 supports small planters in their agricultural activities by exempting them from a water use permit when using water from any river, stream, or water course. However, the small planter has to notify the Water Resources Commission accordingly. Mr. Speaker, sir, currently there is no legal framework to govern non-conventional users of water or alternative water sources, especially relevant in light of fluctuating rainfall patterns that affect seriously the surface and groundwater situations. The Water Resources Bill will promote, as per Section 35, the development of alternative water sources such as desalination, reuse of treated water, rainwater harvesting, and other technologies. The bill makes provision for such non-conventional water to be promoted, and the Commission may, as part of the conditions of a water use permit, require a water user or applicant to avail of such non-conventional resources where available, thereby making optimal use of the national water resources mix that would over time comprise surface water, underground water, harvested rainwater, recycled water, desalinated water, and others. In addition, a promoter who has set up a desalination plant or who is producing water by any non-conventional means can also sell its water to the CWA and to approved buyers. The CWA Act will, in this connection, be amended to allow the authority to enter into water purchase agreements with such developers of alternative water sources. Mr. Speaker, sir, there is in fact adequate volume of waste water treated yearly at different levels at the wastewater treatment plants. However, for acceptability factors, about 15% of the yearly treated effluents is being used for irrigation. This figure will be required to evolve in the water resources mix. In addition, it must be outlined that some private and public entities such as hotels, shopping malls, IRS, hospitals, prisons, and the airport are already using on-site tertiary treated wastewater for irrigation of lawns and green space. It is considered that the potential of wastewater for reuse is significant, no more so as it is a constant and secure source of water, not dependent on rainfall, and can substantially reduce pressure on freshwater balance, thus leading to increased water availability for potable use. Mr. Speaker, sir, subpart C of this section of the bill relates to dams. Currently, there is no legal provision regulating the construction, operation, and maintenance of dams, including private dams. These structures are very sensitive and need to be monitored regularly for continued safety and structural integrity. The Commission will keep a register of all dams. The bill further places responsibilities on dam owners, for instance, to prepare emergency preparedness plan and to carry out regular check and safety assessment to ensure no prejudice is caused to downstream occupants or users of water. Mr. Speaker, sir, provision in respect of management and regulation of underground water and boreholes are made at subpart D. Currently, it is the Groundwater Act of 1969 and regulations made under it that regulate this water source. With the coming into operation of the Water Resources Act, the Groundwater Act will be repealed. However, a person holding a groundwater license before the commencement of the Act would be deemed to be holder of a water use permit. He will have to apply for a fresh permit before expiry of his groundwater license. Mr. Speaker, sir, given that our precious water resources have to be managed in an optimal manner, it will be ensured that water use permits provided for exploitation of underground water is properly utilized. Thus, in the public interest or for the purpose of providing water for domestic purposes, special arrangements have been made at Section 46 for the Commission to enter into an arrangement with a permit holder in case a borehole has not been used for at least 3 consecutive years or no permit has been issued or renewed in its respect during the last 3 years preceding the commencement of the Act. Moreover, in times of acute water shortage or emergency, and for the purpose of ensuring adequate water for public purposes, the Commission may use underground water or water from a borehole situated on a private land or premises by giving reasonable advance notice to the owner or occupier thereof. This is in accordance with provision at Section 46 of the bill. In case a person fails to comply with this section, the bill provides for the director to apply for a judge's order. Sir Speaker, sir, due care has been taken while drafting the bill to ensure the preservation of constitutional rights of a person, whether holder of a concession or as borderer, who shows legal documentary evidence of an entitlement to take water from a river or stream or by an order of the Supreme Court. These are commonly called water rights holders. Such persons have to apply for registration of existing water rights with the Water Resources Commission within 6 months of the commencement of Section 48. While processing an application for registration, the Water Resources Commission may require an applicant to furnish additional information as may be necessary, or make such inquiry as deemed necessary, or require the applicant to give public notice of the application or consider an objection made by an interested party. The Commission will keep a register of existing water rights as set out at Section 51, containing information such as the name of the person holding the existing water right, the site plan of the water source, the volume of the water entitled, and the purpose for which he is entitled to use the water. Mr. Speaker, a provision is also made in the bill for application for constitutional redress to the Supreme Court where a person alleges that any provision of the Constitution has been contravened or likely to be contravened in respect of an existing water right. In case the Supreme Court determines that there has been contravention of any provision of the Constitution and that the claimant has been affected thereby, the Supreme Court would fix the amount of compensation to be paid, make such order as necessary for the payment of the compensation, and secure the constitutionally protected right or interest of the claimant. Mr. Speaker, sir, in the case of existing water right holders, if considered necessary and urgent in the public interest, the bill makes provision for the Director of the Water Resources Commission to make an ex parte application for a temporary or immediate order from the Supreme Court for the supply, control, or protection of water resources. Part 6, Mr. Speaker, sir, deals with enforcement. Mr. Speaker, sir, under the 5th schedule of the Environment Act 2024, formerly known as Environment Protection Act, my ministry is the enforcing agency for effluent discharge and inland waters. The environment dimension of water supply is internationally gaining ground as a major concern in water legislation as water becomes scarce relative to demand and externalities increase. The need to control deterioration of water quality and protect water sources become vital. The Water Resources Bill will provide the legal and institutional framework for my ministry to better protect and conserve our water resources. The enforcement mechanisms are similar to the ones applicable under the Environment Act 2024, inasmuch as they provide for a spectrum of enforcement actions ranging from notice to remedy in case of a likely contravention to a stoppage of the activity causing the offense with respect to both quality and quantity. Under the law, the authorized officers of the Commission are designated to exercise enforcement and monitoring duties. Such officers also have powers of prosecution under Section 70 of the bill. Mr. Speaker, sir, should a person fail to comply with a notice or order, the Director of the Commission may make an ex parte application to a judge for an interim and immediate order necessary for the conservation or protection of any water resources or infrastructure or for the emergency supply of water for public purposes. An activity that adversely impacts the quality of water resources or causes damage to a water structure is severely punishable with a fine not exceeding 2 million rupees and to imprisonment for a term not exceeding 5 years. Mr. Speaker, sir, Part 7 deals with Rodrigues. Mr. Speaker, sir, as I have already indicated, the Water Resources Act will apply to the Republic of Mauritius. The island of Rodrigues will be required to comply with the general principles of integrated water resources management while catering for the island specificities. The Rodrigues Regional Assembly will be responsible for all matters relating to the management and administration of water resources on the island and will develop plans and put in place such mechanisms for the integrated management of water resources in accordance with the Act. Part 8, miscellaneous. Mr. Speaker, sir, under Part 8 of the bill, the Minister will be empowered to make regulations regarding inter alia, the effective management of water resources, including during periods of water shortage, efficient use of water, conservation of water and protection of water resources, alternative water resources, reserved use of water, and providing measures to ensure the cleaning, clearing, maintenance, safety, and security of water courses. Mr. Speaker, sir, given the complexity of the water sector, to allow for the smooth implementation of this act, the proper coordination and cooperation with all stakeholders, as well as the putting in place of all mechanisms and processes, a transitional period of 18 months is provided for under Section 81. Mr. Speaker, sir, any license or permit or authorization which has been granted under a repealed or amended legislation or is deemed to have been granted under this Act shall lapse after a period of 18 months from the commencement of the Act. Mr. Speaker, sir, consequential amendments will be made to the Rivers and Canals Act, the CWA Act, the Irrigation Authority Act, and the CB Act. The Groundwater Act would be repealed. Duties relating to mobilization and development of water resources under the CWA Act, which are already being performed by the Water Resources Unit, will now be reflected in the Water Resources Bill. Except for desalinated water, CWA remains the sole undertaker for supply of treated water for domestic, industrial, and commercial purposes. Monsieur le Président, en guise de conclusion, c'est avec un sentiment du devoir accompli que je termine mon intervention. Je tiens à remercier, premièrement, le Premier ministre pour son soutien, le personnel du ministère, de mon ministère, celui du bureau de l'Attorney General et aussi l'ancien chef juge, son Excellence, M. Ashraf Ali Konai, pour l'élaboration de ce projet de loi. Mr. Speaker, sir, done. I now commend the bill to the House. Thank you.
Honourable members, I suspend the sitting for 1 hour.
Finance.
Honourable members, I have to inform the House that Mr. Niteshan Tailame has joined the clerk's table as clerk assistant. Mr. Tailame joined the civil service as management support officer in August 2014. He was subsequently appointed as court officer at the judiciary in October 2017 and court usher in January 2019. Prior to joining the National Assembly, he held the post of analyst at the Ministry of Finance, Economic Planning and Development. He holds a bachelor's degree in law and management from the University of Mauritius, a Master of Business Administration from the Open University of Mauritius, a Master of Laws in Financial and Commercial Law from the University of Central Lancashire. On behalf of the House and in my own name, I extend a warm welcome to Mr. Niteshan Tailame and wish him a successful professional career. I now invite Mr. Niteshan Tailame to join the table. I have taken cognizance of a press article entitled La sanction contre Rajesh Bhagwan considérée comme injustifiée, which appeared in the Express of today. In the said article, referring to the suspension of Honorable Bhagwan, the Honorable Shakil Mohammed is reported to have stated that I have given a wrong interpretation of standing orders. I wish to set records straight. Honorable members, the House will recall that at the sitting of 5th July 2024, I made an announcement in regard to the intervention of Honorable Bhagwan during a press conference whereby he uttered undignified words to my address. I accordingly requested the Honorable Bhagwan to present his unreserved apologies to the House, failing which I would be left with no other alternative than to ask him to withdraw from the chamber. The Honorable Bhagwan, instead of presenting his apologies, replied the following: I call a spade, and I won't withdraw. It is a fact, ou un agent politique, to un agent politique. In the light of the reaction of the Honorable Member, and considering that this amounted to a grossly disorderly conduct and to disregarding the authority of the Chair, I took the decision to name him under Standing Order 49-4, and there was no need to proceed under the National Assembly Privileges, Immunities and Powers Act, as grossly disorderly conduct occurred in the House itself. I further wish to inform the House that any member who is aggrieved by the decision of the Speaker may challenge him by way of a substantive motion. Therefore, the remarks made by the Honorable Shakil Mohammed in today's article in Express are not justified. Juman to withdraw from the chamber for arguing with the chair. Thereafter, Honorable Juman stated, "You're cheap, you're shame." Thereupon, I named Honorable Juman. Honorable Juman continued to argue with the chair in a grossly disorderly manner and challenged the authority of the chair in a most undignified manner by uttering the following words. "Do whatever you want. Couvert. Combien te pou capable couvert? Bientôt te pou dehors." To the address of the speaker. I ordered Honorable Juman to leave the chamber several times, and the honorable member refused to leave, and the sitting became unruly. I therefore suspended the sitting.
Mr. Speaker, sir, in view of your decision to name Honourable Juman, I beg, under Standing Order 17.3, to take the time of the Assembly for urgent business.
Seconded.
Seconded. The question is that the Honourable Deputy Prime Minister be allowed under Standing Order 17.3 to take the time of the House for urgent business. Those in favour say aye, those against say no. The ayes have it.
Mr. Speaker, sir, having obtained your permission, I now beg to move under Standing Order 29.1 to present a motion without notice.
Seconded.
Seconded. The question is that the Honourable Deputy Prime Minister be allowed under Standing Order 29.1 to move a motion without notice. Those in favour say aye, those against say no. Aye. The ayes have it.
Mr. Speaker, sir, in view of your decision to name Honourable Juman, I beg to move that the Honourable Juman be suspended from the service of the Assembly for today's sitting and the next 6 sittings, unless on reserved apologies are tendered to the House.
Seconded.
Seconded. The question is that the Honourable Juman be suspended from the service of the Assembly for today's sitting and the next 6 sittings, unless unreserved apologies are tendered to the House. Those in favour say aye, those against say no. Aye. The ayes have it.
The Water Resources Bill. D'après ce explanatory memorandum qui finit circuler dans le Parlement, le principal objectif de ce projet de loi-là, c'est pour établir un cadre juridique complet pour l'utilisation, gestion, contrôle, protection, conservation et développement durable des ressources de l'eau dans Maurice. Sauvegarde l'intérêt public dans les médias et à long terme pour un accès équitable à de l'eau. Garantir sécurité et résilience de l'eau. Établir une Water Resources Commission. Encourage utilisation efficace de l'eau. Prend disposition pour et en relation avec les affaires connectées et par rapport à ce sujet-là.
Announcements.
Honourable members, I have to inform the House that Mr. Niteshan Tailame has joined the clerk's table as clerk assistant. Mr. Tailame joined the civil service as management support officer in August 2014. He was subsequently appointed as court officer at the judiciary in October 2017 and court usher in January 2019. Prior to joining the National Assembly, he held the post of analyst at the Ministry of Finance, Economic Planning and Development. He holds a bachelor's degree in law and management from the University of Mauritius, a Master of Business Administration from the Open University of Mauritius, a Master of Laws in Financial and Commercial Law from the University of Central Lancashire. On behalf of the House and in my own name, I extend a warm welcome to Mr. Niteshen Tailame and wish him a successful professional career. I now invite Mr. Niteshen Tailame to join the table. I have taken cognizance of a press article entitled La sanction contre Rajesh Bhagwan considérée comme injustifiée, which appeared in the Express of today. In the said article, referring to the suspension of Honorable Bhagwan, the Honorable Shakil Mohammed is reported to have stated that I have given a wrong interpretation of standing orders. I wish to set records straight. Honorable members, the House will recall that at the sitting of 5th July 2024, I made an announcement in regard to the intervention of Honorable Bhagwan during a press conference whereby he uttered undignified words to my address. I accordingly requested the Honorable Bhagwan to present his unreserved apologies to the House, failing which I would be left with no other alternative than to ask him to withdraw from the chamber. The Honorable Bhagwan, instead of presenting his apologies, replied the following: I call a spade, and I won't withdraw. It is a fact, ou un agent politique, to un agent politique. In the light of the reaction of the Honorable Member, and considering that this amounted to a grossly disorderly conduct and to disregarding the authority of the Chair, I took the decision to name him under Standing Order 49-4, and there was no need to proceed under the National Assembly Privileges, Immunities and Powers Act, as grossly disorderly conduct occurred in the House itself. I further wish to inform the House that any member who is aggrieved by the decision of the Speaker may challenge him by way of a substantive motion. Therefore, the remarks made by the Honorable Shakil Mohammed in today's article in Express are not justified. Juman to withdraw from the chamber for arguing with the chair. Thereafter, Honorable Juman stated, "You're cheap, you're shame." Thereupon, I named Honorable Juman. Honorable Juman continued to argue with the chair in a grossly disorderly manner and challenged the authority of the chair in a most undignified manner by uttering the following words. "Do whatever you want. Couvert. Combien te pour capable couvert? Bientôt te pour dehors." To the address of the speaker. I ordered Honorable Juman to leave the chamber several times, and the honorable member refused to leave, and the sitting became unruly. I therefore suspended the sitting.
Mr. Speaker, sir, in view of your decision to name Honorable Juman, I beg, under Standing Order 17.3, to take the time of the Assembly for urgent business.
Seconded.
Seconded. The question is that the Honorable Deputy Prime Minister be allowed under Standing Order 17.3 to take the time of the House for urgent business. Those in favor say aye, those against say no. The ayes have it.
Mr. Speaker, sir, having obtained your permission, I now beg to move under Standing Order 29.1 to present a motion without notice.
Seconded.
Seconded. The question is that the Honorable Deputy Prime Minister be allowed under Standing Order 29.1 to move a motion without notice. Those in favor say aye, those against say no. Aye. The ayes have it.
Mr. Speaker, sir, in view of your decision to name Honourable Juman, I beg to move that the Honourable Juman be suspended from the service of the Assembly for today's sitting and the next 6 sittings, unless on reserved apologies are tendered to the House.
Seconded.
Seconded. The question is that the Honorable Juman be suspended from the service of the Assembly for today's sitting and the next 6 sittings, unless unreserved apologies are tendered to the House. Those in favor say aye, those against say no. Aye. The ayes have it.
The Water Resources Bill. D'après ce explanatory memorandum qui finit circuler dans le Parlement, le principal objectif de ce projet de loi-là, c'est pour établir un cadre juridique complet pour l'utilisation, gestion, contrôle, protection, conservation et développement durable des ressources de l'eau dans Maurice. Sauvegarde l'intérêt public dans les médias et à long terme pour un accès équitable à de l'eau. Garantir sécurité et résilience de l'eau. Établir une Water Resources Commission. Encourage utilisation efficace de l'eau. Prend disposition pour et en relation avec les affaires connectées et par rapport à ce sujet-là.
Please be seated. Honorable Burrell, you did not stand up. Should I give you the floor? You see? What you advise me, give you the floor or don't give you the floor? So he doesn't speak, we go home. So I decide to give you the floor.
Mr. Speaker, the bill has wide implications. The Minister has been explicit and has sent some positive signals to reassure stakeholders. The setting up of a protocol for private-public sector gives a zone of comfort in relation to apportionment of water during emergencies. The fear of compulsory acquisition of land, which has boreholes through which rivers or canals pass, has been temporarily allayed. The onus is on equitable sharing. Water, like sea, forms part of public property. It is defined in our civil code, and it cannot be subject to private property. No water right, as is, can be for an indefinite period. No holder has absolute right. Those who have rights should know that he or she is entitled to a share of water proportional to the extent of his or her irrigable land, or for industrial purposes. Water scarcity is indeed economic decline, and water has to be well managed. Against this backdrop, I will comment on the bill. And the first casualty of the bill is the Water Resources Unit. It will be defunct. The Water Resources Commission becomes a departmental division of the ministry. The functions are clearly spelled out, but it remains a lapdog. It is the Minister of Energy and Public Utilities who is the Lord of the Manor. Government is government, and government so decides. The agenda of the regime is clear. It will pull all strings. I must say there are some safeguards, but the minister may argue that the technical committee will scrutinize application, but the minister so decides, and he submits the approved cases as an information paper to cabinet. If a person's right is forfeited, the aggrieved person can always seek redress under Section 55, but it is a tedious and costly process. Sometimes clear-cut evidence is not available because of documents which are difficult to retrieve or because of lost documents. Now, water, as the court said, is public domain, and this was said by the Court of Appeal in the case of Ciel versus CWA. And let me highlight, public interest overrides and is overwhelming. The rights of the individual is fundamental, and he or she who constructs the canal has a right to draw water. Be he a planter or a former sugar magnate, rights and obligations are intricately linked. Drawing of water is not unconditional when there is force majeure. If in doubt over management of water, as we say, go to court, let the magistrate rather than the Supreme Court so decide. Government is the custodian, but the allocation of water rights should not be a cash cow for the regime. It is unacceptable that this regime was prepared without protracted, I'm not talking of, soft meetings, but I'm talking of protracted discussion with stakeholders. There was hardly any effective talk from what I've been told. The minister maintains that discussions were ongoing since 2022. Why do I say protracted? Because the historical facts and constitutional rights cannot be ruled out or sometimes established. The regime has already upset domestic and commercial consumers. Let me now come to the history of water rights, and this dates back from the original concessionary period of the King of France, when settlers were provided with portion of king's land, what they call concession double, or grande concession de demi-concession, for agricultural production, and water was attached thereto. Therefore, rights to water are protected as property rights under the Constitution. Some of the said rights, dating back from the French and British periods, have clearly delineated the powers of the state and the courts, and the only authorities empowered to allocate or remove those rights have always been the courts. What should be the object? To ensure fair and just allocation of resources. And there cannot be discrimination nor special or differential treatment allocated. Those rights have been used in a continuous manner, and although some original documents dating back as far as 1778 have become untraceable. The CWA has, with the support of Water Rights Administrator, Mr. Radian Kopemutu, and an expert from New Zealand, Thomas Fancourt, carried out a census of those rights in 1980 and 81. And this census has re-established those rights in the absence of documentary evidence of the courts, which unfortunately have been damaged over time. A register of water rights has been established accordingly. Some water rights holders have re-established their rights through water rights reports, some of which have been registered with the landed property deeds. And Section 51 gives some comfort to existing water rights holders. A second census has been carried out by the authorities, and that census was carried out in 2013 to update the lists of water rights holders. The data are available. I agree the holders of water rights have not always been fair game. Some have been reluctant to enter into effective negotiation or to act responsibly in moments of needs. But a responsible government has to go for effective dialogue. Mr. Speaker, some major provisions of the bill are controversial. They instill fear and create uncertainties. The judgment I've stated, given by Privy Council on the 20th of February 2022, in favor of CWA against Respondent Ciel Limité and other appellants, make good jurisprudence. Le domaine public rule the Privy Council. Water rights are governed by River and Canals Act. The Act provides that river and streams are public property. But even with the legislation which is being introduced, and rightly so, there cannot be certainty over River and Canals Act. The landowners have a right of jouissance. Nothing is for an indefinite period, as I've stated earlier. But every holder, every user has an obligation to return unpolluted water to the canals and rivers. Polluters must pay. The ruling of the Privy Council is a guiding lantern, but the regime is taking advantage of the ruling to act arbitrarily. The risk of constant challenge or litigation in court is high with the provisions of the legislation. It's not a question of them or us, it's about obligation, rights, and overriding public interest. Mr. Speaker, providing extensive powers to political appointee, in this case a minister, for a matter which is related to public property and property rights protected by the Constitution of Mauritius may constitute a dangerous precedent. As I've stated earlier in relation to Rivers and Canals Act, the Central Water Authority Act governing the rights to water remain the main pieces of legislation governing these historical property rights. The times to revisit, to democratize. But there should be no violent disruption, and I will refer to Section 46 of the bill. Any attempt to remove the power from independent courts to allocate or remove such rights would therefore constitute a shift in the constitutional balance between legislative, executive, and judicial powers, which are paramount for a functional democracy. Moreover, water, as I've stated earlier, from part of public domain, is equally essential to sustain life as well as food security and agricultural related activities of our country. A law providing a permit issued by the authority would therefore provide a discretionary power. Unfortunately, it is ripped from the Supreme Court. It is complex, and wide consultation at all levels would have assuaged and mitigate difficult circumstances. I grant you no one should tamper with the constitutional rights, but the Constitution should be amended then to third or three-quarters of the majority, and unless this is obtained, the rights will stay as they are. There are changing times, and policies have to be revisited to ensure fairness and equity. There are priorities in times of needs or urgency, and CW and CEB have to act with fairness on fees to be paid for pumping of water from boreholes, apportioning of water for domestic and irrigation, and rights of holders. Operators cannot be summoned and told to submit their projects for no apparent reason. It should not be an opportunity for corrupt practices. There's a call for decent dialogue and to make sure public interests are served first. Let me tell you the story of a food producer, and I quote, "I also need to inform you the production of sugar, vegetables, nursery, and loan we are doing is very limited due to lack of water. CW is talking about conductivity and water quality to reduce the level of water to be pumped from boreholes. When the bill they want to pass, when the bill which is going to be passed is going through, they will take whatever water they want from everywhere by abusing the rights." This is what was said by a farmer. The farmers will be in more difficult situation, and I hope there will be interactive session to assuage, to mitigate, and to create a climate of certainty. Mr. Speaker, let me refer to specific clauses. Clauses 7, 24, and 32 make the holders of water rights uneasy. In Section 7, the planters, ARIM, and other stakeholders have expressed concern over the power to vary and waive usage vested in a member of the executive. It may be politically motivated, because the fear that the political arm of the executive has been in the habit of exercising unfettered, unlimited power. The power to initiate compulsory land acquisition is worrying, given the fact that many real estate promoters, business, and individuals have rivers and other natural sources flowing through their private property. But the legislation has to be crystal clear in relation to compensation or to entitlement which they are due if ever there is acquisition of the land. Mr. Speaker, do recall, the regime can act, but it has to act forcefully. And I feel sorry that there has been no protracted dialogue with all the stakeholders. There is also no guarantee for procedural rights of those affected by compulsory land acquisition, including right of notice, right to be heard, and right to appeal. Mr. Speaker, in Section 24, determination by minister, where clarity in relation to right of appeal, there is high perception of abuse of power, corruption, and favoritism. One may argue that the minister has to take into consideration advice tendered by the technical committee. The word may circumscribe his power, he ultimately shall, and it is not the commission nor the committee which take action even if a decision is controversial. Let us make sure that the commissions do deliver. Now, Section 32, the minister may in the public interest exempt any person from the requirement to hold a permit under this act. The power of the minister is absolute. He may exempt supporters of the regime and turn down other applications. Section 48, existing water rights as a holder of concession in accordance with his title of concession. There may be an issue with the Supreme Court records regarding water rights. Some have been lost as they date back to the 1900s. Mr. Speaker, let me conclude by asking a few questions. As the minister has said, water rights is human rights, and it is becoming an expensive commodity. But lately, the new meter, water meter, which is being installed, registers, unfortunately, an unusual level of consumption. I don't know whether this is due to recalibration, but there's been complaint, and the monthly bill of many commoners has gone up many-fold. Complaints have been filed at the CSU and the CWA office. It is, I hope not, that it is not a disguised way to reap consumers. A water reform bill defining the policy of government towards water, one of the very few natural resources of the country, and which belong to all of us, precede the mise en place of such an ambitious objective as 24/7. 10 years ago, on the law, Mr. Speaker, now that we are almost on the threshold of the dissolution of Parliament, the verdict is that the government has failed miserably. Almost all areas of Mauritius are now on a water cut regime. The regime is insensitive to the plight of consumers. One has to listen to the radio, day in, day out, the complaints from the public about the poor water quality supply. The water losses in the CWA network is now an abysmal above 65%, one of the highest in the world, and highest since we became independent as a nation. For each 10 cubic meter of water produced, 6 cubic meter is unaccounted for. Mr. Speaker, the CWA uses some water tankers to service consumers. Today, the dams are full, and yet the population is still subjected to water cut regime and drastic in some areas. It should take into consideration the amount of water available and its spread across the island. Here we also have Rodrigue and the outer islands in mind. The immediate and projected requirement of each sector is important. Our district water zone have to be leveled up. We have to set realizable target, which is yet to be done. In the budget 2015-2016, the MSM government projected to spend 20 billion rupees to bring 24/7 water supply to the country. The major projects were 429 million for a new treatment station at Nicolière, 425 million for Port-Lardier project in the east, and the Rivière des Anguilles Dam. The construction of 21 storage reservoirs. These are reservoirs located across the island for storing treated water before distribution to the population. Unfortunately, they have failed abysmally, and they have failed on all counts. Now they come forward with this bill, which sounds like an admission of guilt and outright failure. Mr. Speaker, predictability and reliability of water supply on a 24-hour basis is a luxury in Mauritius. What promises were not made since 2015 over the 24/7 water supply? It would have been a reality, but unfortunately, we are far from the real world. Water, Mr. Speaker, was the beginning of a rift. Water supply, beginning of a rift between the Prime Minister and the former DPM over privatization and affairage of. No lessons has been learned from the recent scandal of allocation of contract for pipeline program. The provoked departure of the internal auditor of CW opened the door to corruption of allocation of contract of 6 billion rupees. CWA has advertised to recruit an internal auditor who will have to report to the manager. Mr. Speaker, as I say, thanks God, the days of this government are numbered. Thank you very much.
Thank you, Mr. Speaker, sir. Mr. Speaker, sir, I stand before this House to support the Water Resources Bill number 8 of 2024, a landmark legislation which is poised to bring transformative change to the way we manage and utilize our precious water resources. Indeed, Mr. Speaker, sir, the Water Resources Bill, which is to be passed in this August Assembly, marks a significant milestone in our journey towards sustainable and efficient water management. As Minister of Agro-Industry and Food Security, I'm acutely aware of the critical role that water plays in sustaining our agricultural activities. Water is not just a resource, it is the lifeblood of our fields, the foundation of our endeavor towards food security, and a crucial element in the livelihood of our planters. Hence, the need for it to be properly managed. From an agricultural perspective, Mr. Speaker, sir, I consider this bill to be a monumental shift towards a more equitable and prosperous future for the agricultural sector as a whole. This new bill, Mr. Speaker, sir, with its comprehensive legal framework, promises to address the long-standing challenges we have faced under the Groundwater Act, Rivers and Canals Act, and the Central Water Authority Act. For too long, our water resources have been managed in silos, with different agencies operating under separate acts without proper coordination. In fact, the existing legislations all deal with portions of the water sector, but fail to adopt a holistic, integrated approach. This fragmented system has led to inefficiencies and thus made it difficult for planters to have equitable access to water resources. Mr. Speaker, sir, the Water Resources Bill represents a significant step forward by providing a comprehensive framework that will ensure water security and sustainability for all, including planters. This bill, in comparison to the existing legislations, brings forth several key improvements. Allow me to highlight some of these and how they will contribute to the growth and development of our economy, including our agricultural sector. Most importantly, Mr. Speaker, sir, the bill recognizes water as a finite resource that needs to be protected for both current and future generations. Its emphasis on conservation, efficient use, monitoring, protection of catchment areas and aquifers will go a long way in ensuring long-term water security for Mauritius. This is crucial for our agriculture, which relies so heavily on consistent access to water supplies. Indeed, Mr. Speaker, sir, this bill establishes a comprehensive legal framework for the use, management, control, protection, conservation, and sustainable development of our water resource. Its objective is to safeguard our immediate and long-term interest by ensuring equitable access to water by one and all. The bill also ensures that planters have a reliable and fair allocation of water resources through a clear and transparent framework, thus enabling them to better plan and optimize their agricultural practices. One of the most commendable aspects of this bill, Mr. Speaker, sir, is its focus on the sustainable development of our water resources. The agricultural sector has often been and is now more frequently at the mercy of erratic weather patterns and inconsistent water supply due to climate change. With the emphasis that it lays on the promotion of efficient use of water, this bill encourages planters to adopt innovative and sustainable irrigation practices, given the increasing challenges posed by climate change and the need to ensure water security and resilience. By promoting the efficient use of water, we can reduce wastage, conserve our precious resources, and encourage a more environmentally friendly agricultural sector. I must say, Mr. Speaker, sir, that with a view to improving the efficient utilization of water to enhance vegetable and fruit crops production at farmers' level, my ministry has been encouraging farmers to adopt climate-resilient methods of production through the development and implementation of novel water and energy-saving irrigation technologies, which prevent wastage of irrigation water by offering a water economy of 40 to 50%. Several initiatives and facilities have been provided to planters to enable that shift. With the implementation of these water and energy efficient technological packages, farmers are able to increase crop yield both in terms of quantity and quality. Another significant and visionary feature of this bill, Mr. Speaker, sir, is the establishment of the Water Resources Commission. This commission will serve as a central body to oversee the management, control, protection, and conservation of our water resources. By bringing all water-related activities under a single umbrella and framework, we can ensure better coordination, avoid duplication of efforts, and streamline the processes that are vital for proper water management. This holistic approach, which was lacking in the previous legislations, where responsibilities were fragmented across different entities, will ensure sustainable management of our surface as well as groundwater, dams, and other water infrastructure in an integrated manner. This independent body will provide expert guidance, monitor water usage, and promote the implementation of best practices in water management. The Commission's presence will ensure that the interests of the agricultural sector are properly represented and protected, which will lead to a more efficient allocation of water resources for agricultural purposes. By vesting ownership and administration of water resources under the Water Resources Commission, far better coordination between all stakeholders in the sector will undoubtedly follow, thus leading to more efficient allocation of water. I also note, Mr. Speaker, sir, that this bill makes provision for the concept of water use permits, which will replace the existing system of water rights. This system will bring much needed regulation and accountability to the use of water resources. The shift will streamline the administrative processes and provide water users, including planters, with a more transparent and accessible mechanism for securing water resources. Processing applications and regulating water usage in a transparent, organized manner will eliminate many of the ambiguities that currently exist. Through the introduction of permits for water use, the monitoring and management of water will be done in a more effective and efficient manner, whilst ensuring that the agricultural sector receives its fair share. This bill will therefore, Mr. Speaker, sir, bring about a robust mechanism for regulating water use, thereby putting an end to inequities and conflicts. I have no doubts that planters will have greater certainty and security of having a consistent water supply for their agricultural activities. The bill also introduces the concept of buffer zones and restricted areas, which are pivotal for protecting our water resources from contamination and overuse. Regulating activities in these zones will, without any doubt, prevent the degradation of our water bodies and ensure that the nation has access to clean and safe water. This level of protection, which are not sufficiently covered in the existing legislations, will help in controlling pollution and resource depletion. In addition, Mr. Speaker, sir, the bill lays emphasis on the protection of aquifers with a view to ensuring that they are not overexploited. This will help, of course, to safeguard the long-term availability of underground water for both agriculture and other uses. The bill recognizes the importance of alternative water sources. It acknowledges that surface and groundwater alone may not be always be sufficient to meet the increasing demands of the various socio-economic sectors. Therefore, the bill encourages the exploration and utilization of sustainable sources of water, such as desalination and other innovative technologies. While promoting water recycling, reuse, desalination, and alternative water sources, the bill will act as a game changer, as it will open up new avenues for the agricultural sector. These innovative approaches will surely reduce the stress on our existing water resources. The enforcement powers, as provided under the bill, will help crack down illegal abstraction and wastage of water, which deprive other users, including planters, of this precious resource. By clearly spelling out the responsibilities, penalties, and compliance protocols, the bill will call upon all water users, including the agricultural sector, to adopt more sustainable practices and make efficient use of our water resources. Mr. Speaker, sir, Section 36(2) of this bill makes reference to special considerations given to small planters. Indeed, it specifically exempts small planters from the requirements to use water from rivers, streams, or water courses only for the purpose specified in their water use permit. This implies that small planters will not be restricted to using water for specific purposes as provided in the permit. They will have the flexibility to use water for any agricultural purpose they deem necessary, as long as they notify the relevant authority. This provision will ease off the regulatory burden of small planters and will give them access to river water for irrigation purposes, while still keeping their water usage subject to terms and conditions to be set by the Director of the Water Resources Commission. The Water Resources Bill acknowledges the contribution of planters to our social and economic development. In conclusion, Mr. Speaker, sir, I must emphasize on the fact that Water Resources Bill embodies a comprehensive, sustainable, and forward-thinking approach to water management. This bill will bring about an unprecedented reform that was long overdue to strengthen water governance in our country. It paves the way for an efficient and equitable water management, and thus ensuring that all the socio-economic sectors of the country have the necessary water resources to thrive in an ever-changing environment. I therefore urge all members of the other side of the House to raise our politics and support this bill. Let me, to end, Mr. Speaker, sir, to commend my colleague, the mover of this bill, for coming forward with this piece of avant-gardist legislation to prepare for the adequate and equitable supply of water for our future generation. So thank you, Mr. Speaker, sir. I'm done.
Before you take the floor, let me give you the floor first. Let me put the traditional question. You did not pay respect to the chair this morning. You sat down when I came in. So I would ask you one question now. Are you prepared to respect the chair? Always. Very good. Very. No, this is not the point. The point is that when I come in the chamber in the morning, you did not stand up to pay respect to the mace and to the chair, to the House, to the National Assembly. You did not pay respect. My question is simple. Are you prepared now to pay respect to the chair?
We follow the standing orders, Mr. Speaker, sir. Whatever we are told to do by the standing orders, we do. If the standing orders tell us to stand up, we will stand up.
No.
If the standing orders tell us to sit when we talk, we sit.
No. This is the tradition in all parliaments all over the world. This is practice in all parliaments. There is no standing order. This is a practice in all parliaments all over the world. So the mace is a symbol of authority. So you're not paying respect to the chair as such. You're paying respect to the mace and the authority of the mace and the House, where you took oath of allegiance to the House to respect the rules and regulations, the discipline, the practice going on in the House. So my point is, are you prepared to show respect now?
I said, Mr. Speaker, sir, I've always respected the mace.
So on that count, you can speak now.
Monsieur le Président, souvenez-vous d'ILO 24/7, où est passée la belle promesse de fournir de l'eau 24 heures sur 24, 7 jours sur 7. Plusieurs régions de l'île ne sont toujours pas convenablement alimentées. L'eau est distribuée dans certaines régions au compte-gouttes pendant seulement quelques heures par jour.
But make sure you're speaking on the bill.
Water resources.
You know what is the bill?
Yes.
Yeah. This is not the CWA problem. This is the concentration of water resources.
Mr. Chairman, I bow to your ruling, but I will draw the attention of the House to Section 80, consequential amendments, where the Central Water Authority Act is being amended by repealing and replacing the object of the authority. So the object of the authority was to ensure proper distribution of water, and now this is being taken away. So I have to make that bilan of the CWA, and that is why we are amending the object clause of the CWA
So
in
you
this.
you may talk on the amendment to be brought to the CWA, but not about this political issue of 24/7 water or whatever thing. Continue.
Monsieur le Président, n'en déplaise l'honorable ministre, nous sommes à Maurice, une île bénie nous avons de la pluie en abondance, bien plus que nous n'en avons besoin. Nos collines, nos montagnes sont vertes et cela témoigne de l'abondance d'eau. On a même des inondations. Mais comment alors expliquer qu'en début d'année, on a des pluies torrentielles, des inondations, mais arrivé en fin d'année, on a des coupures drastiques d'eau? La réponse est évidente, la mauvaise gestion de nos ressources en eau, pour ne pas dire une gestion catastrophique. Et la situation s'est considérablement empirée ces 10 dernières années sous le gouvernement MSM et ses crépuscules. Pourtant, chaque année, nous votons un budget de plusieurs centaines de millions de roupies, voire de milliards de roupies, pour améliorer la conservation et la distribution de l'eau, qui est le sujet de ce débat. Le gouvernement avait même prélevé 4 roupies sur chaque litre d'essence et de diesel pour remplacer les vieux tuyaux. Résultat, aucune amélioration. Fuite d'eau récurrente. Non-revenue water à la hauteur de 60%, un des taux les plus élevés au monde, c'est-à-dire 60% d'eau qui quitte nos réseaux de distribution ne sont pas facturés. C'est ça la mauvaise gestion de nos ressources en eau. Aucun nouveau réservoir construit. Ce bill parle de la construction de réservoirs et de dames. Aucun réservoir construit. Dans ma circonscription, Monsieur le Président, que ce soit à Vallée-Piteau, à Tranquebar ou à Paille, il nous faut de nouveaux réservoirs pour alimenter les réseaux de distribution qui sont saturés. Et je suis sûr qu'à travers l'île, il faut plus de réservoirs. Parce qu'il y a le nombre de maisons, d'appartements, de morcellements qui ont augmenté dans plusieurs de ces régions, mais le volume d'eau distribué, la pression de l'eau n'ont pas suivi. Chaque année, Monsieur le Président, durant le budget, et ce depuis 10 ans, le ministre des Finances, sans le moindre embarras ou gêne, nous sort le projet de construction du barrage à Rivière-des-Anguilles. Rivière-des-Anguilles, dame, qu'aujourd'hui les dames seront vested en l'état. Chaque année, les membres du gouvernement tapent la table en attendant Rivière-des-Anguilles, dame.
I know you would be coming on that point, but listen to me once more, once again. Talk on the bill. It's a water resources bill. You have an explanatory memorandum which says all the bill will treat. So don't go away from the bill, stay with the bill.
Subsection, subpart C.
I'll be patient with you up to a point.
Absolutely. Subpart C of the bill, dams. Section 49, private and other dams. Section 40, responsibilities of dam owners. Section 41, assessment of safety risks. 42, dams declared as safety risks. 43, protection of dams. 5 sections, 3 pages on dam. I'm not allowed to talk about
Honourable member, don't try to be demagogical. Dams means existing dams and control over dams.
Future dams also. This is the bill, Mr. Speaker, sir. Construction of new dam. Who can construct new dam? Private or public? Where does that dam vest into? So we're talking about Rivière-des-Anguilles Dam.
I give you a last chance. Go direct to the bill.
It is the bill. I am the. Le responsable, aujourd'hui, la gestion de nos ressources hydrauliques est sous la responsabilité de la Central Water Authority. Semaine après semaine, à travers les PNQ, les PQs et à l'ajournement, la population constate avec colère la mauvaise gestion de nos ressources en eau par la CWA, de mal en pis, et la venue du nouveau directeur général qui, comme nous l'a rappelé l'honorable Premier ministre durant les Committee of Supply, est toujours son conseiller, la situation à la CWA est tout bonnement chaotique. Comment espérer...
No, but I will stop you there. You're going too far, and you don't want to speak on the bill? I'm asking you for a last time. Do you want to speak on the bill? No, I'm not asking you the question. You keep quiet. I am asking you, do you want to speak on the bill?
Yes.
Okay, I'll listen to you.
Monsieur le Speaker, le point que j'essaye de faire, c'est qu'au lieu de venir avec cette loi, on aurait pu laisser la CWA continuer à gérer les ressources en eau, mais changer la façon dont les gens qui opèrent à la CWA sont nommés. Putting the right people.
No, okay, I'll stop you there. Now I'm lacking patience with you. You are making an abuse of your time in Parliament. Would you like to try again on the bill? No demagogy.
Okay, no demagogy. La Water Resources Commission prévue à la section 9 du projet de loi n'est même pas une commission en tant que telle. C'est un département d'un ministère. Donc, ce n'est pas une commission indépendante. La commission sera gérée par un directeur, un one-man army, un fonctionnaire. Ce projet de loi donne tous les pouvoirs au ministre et c'est très dangereux. Le ministre a énuméré tous les pouvoirs à la section 7. C'est le ministre qui, dorénavant, décidera ou non d'accorder un permis pour utilisation d'eau des rivières, des canaux, des boreaux, des nappes phréatiques. C'est le ministre qui décidera le volume d'eau que vous pouvez utiliser. C'est le ministre qui décidera des fees, des redevances que vous payerez pour ces water rights. C'est le ministre qui peut unilatéralement, sous la section 29, modifier les termes et conditions de votre permis d'utilisation d'eau, et ce, sans payer de compensation, c'est à la section 29, mais c'est aussi le ministre qui décidera d'exonérer toute personne de la nécessité d'avoir un permis sous cette loi, section 32. C'est toujours ce même ministre qui, sous la section 27.2, peut accorder une exonération du paiement des redevances des fees. Oui, le ministre peut le faire dans l'intérêt public. Et qui décide? C'est quoi l'intérêt public? Bien sûr, c'est le ministre. Donc le ministre, Monsieur le Président, sous la section 27.2 de ce projet de loi, peut décider de ne pas réclamer des fees pour l'utilisation des eaux des rivières, des ruisseaux, des boreholes. Non, mais vous vous rendez compte ce qu'on est en train de faire en donnant tous ces pouvoirs au ministre, le pouvoir de donner un permis ou pas, le pouvoir de faire payer ou pas. Monsieur le Président, les rivières, l'eau qui coule dans nos rivières, dans nos ruisseaux, sur la terre, sous la terre, nos nappes phréatiques, l'eau souterraine, toutes ces eaux appartiennent à l'État. Nous appartiennent collectivement. C'est un bien public. Ce n'est pas le bien propre du gouvernement ou d'un parti politique. Donc, est-ce vraiment raisonnable de donner tous ces pouvoirs à un politicien qui peut être sujet à de nombreuses pressions? C'est ça le point que je veux essayer de faire, Monsieur le Président. Aujourd'hui, sur la Rivers and Canals Act, une loi qui date de 1863, c'est la Cour suprême. C'est la Cour suprême qui accorde à une personne le droit d'extraire de l'eau d'une rivière ou d'un ruisseau ou de dévier l'eau d'une rivière ou d'un ruisseau. Et la Cour suprême n'accorde pas facilement cette autorisation. Je me souviens, quelques années de cela, il y avait un client étranger qui avait un projet touristique qui comprenait la plantation de vanille. Il avait reçu l'autorisation de Economic Development Board, il avait reçu l'autorisation de la CWA pour prendre de l'eau de la rivière, pour faire l'irrigation, il avait eu l'autorisation du ministère des Services publics parce qu'il y avait un seul autre utilisateur, donc il y avait suffisamment d'argent. Donc le monsieur a fait une demande à la Cour suprême pour pouvoir extraire de l'eau pour irriguer ses champs. Et là, vous savez ce qui s'est passé? La juge de la Cour suprême a rejeté sa demande. La juge n'était pas satisfaite qu'il y avait suffisamment d'eau dans la rivière pour avoir un deuxième utilisateur et que les droits des autres riverains ne seront pas affectés. Et je cite ce que la juge a dit. It is for this court, Supreme Court, and not for third party, c'est-à-dire la CWA, to be satisfied that the legal requirements have been met before a water right is granted. C'est à la Cour de décider, pas à la CWA. Et ce jugement sera repris quelque part dans la décision du Privy Council dans l'affaire Ciel contre la CWA, qui a été citée et par le ministre et le leader de l'opposition. Cette plus haute instance a confirmé que seule la Cour suprême et auparavant le Land Court peut autoriser une personne à extraire de l'eau d'une rivière ou d'un ruisseau. Les riverains entre eux ne peuvent pas le faire. Je suis d'accord avec l'honorable ministre qu'il faut étendre ces pouvoirs, ne pas les limiter seulement dans le cas d'irrigation, d'avoir une date, de ne pas donner un permis sans limitation, mais au moins laisser ce pouvoir dans la main de la Cour suprême. C'est une protection, parce qu'on est en train de parler du bien public, et on ne peut pas avoir des considérations politiciennes lorsqu'on est en train de distribuer les biens publics. Un autre manquement très flagrant, plus flagrant dans ce projet de loi, Monsieur le Président, c'est l'absence de procédure d'appel, l'absence de droit d'appel d'une personne lésée. Aujourd'hui, sous le Groundwater Act de 1969, à l'article 8, si la CWA rejette votre demande pour extraire de l'eau souterraine, le Groundwater License, la section 8 prévoit un droit de recours à la Cour suprême dans un délai de 21 jours qui suivent la décision de la CWA. Mais dans les dispositions de la section 24B du projet de loi devant cette Chambre, le ministre peut rejeter votre demande de permis et il n'y a aucune procédure d'appel de prévue sur cette loi. Un recul par rapport au Groundwater Act de 1969. Pire, la section 54 de la loi qui prévoit un recours à la Cour suprême si une personne estime que ses droits constitutionnels sont lésés. Il peut avoir recours à la Cour suprême selon la nouvelle loi seulement si ses droits constitutionnels sont lésés. Mais le droit constitutionnel, le recours constitutionnel est très contraignant et il ne s'applique que pour certains cas spécifiques. Si, par exemple, Monsieur le Président, le ministre permet la déviation d'un cours d'eau ou l'exploitation d'une nappe phréatique qui peut avoir des conséquences néfastes sur l'environnement ou sur les riverains. Personne ne semble avoir le droit, sous cette loi, de contester la décision du ministre parce qu'il n'y a pas le droit constitutionnel des riverains ou de la population qui est affectée par une décision ministérielle qui peut avoir un effet néfaste. Et c'est bien dommage, Monsieur le Président, parce que ce matin même, on a eu un PNQ sur la décision du Privy Council qui a statué que l'Écossais avait bel et bien un intérêt suffisant pour contester le permis émis par le ministère de l'Environnement. Donc aussi, dans cette loi, cet après-midi, on aurait dû avoir un droit de recours de n'importe quelle personne qui s'est sentie lésée par une décision du ministre. Mais ce projet de loi prévoit aucun recours dans la plupart des cas. Par exemple, si on suspend votre water rights, si on modifie les conditions du water rights ou la quantité d'eau que vous pouvez extraire, et tout ça seront sous la responsabilité du ministre qui a le pouvoir de le faire de manière unilatérale, ben, vous n'avez pas d'appel, vous n'avez pas de droit d'appel. C'est clairement antidémocratique, voire anticonstitutionnel, mais vous n'avez pas de droit d'appel sur ce projet de loi. Et c'est la première fois, Monsieur le Président, depuis que je suis au Parlement, qu'il y a un projet de loi qui reconnaît explicitement qu'il y a des clauses anticonstitutionnelles et qui prévoit un recours constitutionnel. C'est prévu dans cette loi. Pourquoi? Parce que le gouvernement est conscient que certaines des provisions et la façon d'appliquer certaines de ces provisions peuvent aller à l'encontre de l'article 3 et 8 de la Constitution qui garantit, et je cite, « the right of the individual to protection from deprivation of property without compensation ». La Constitution n'empêche pas au gouvernement de prendre possession des biens d'une personne si cela est nécessaire dans l'intérêt public pour le développement social et économique des Mauriciens. La Constitution n'empêche pas au ministre de prendre les water rights s'il y a une sécheresse et que le gouvernement a besoin de cette loi. La Constitution n'empêche pas le ministre d'effectuer des compulsory acquisitions. Tout cela est permis, mais l'article 8C de la Constitution prévoit des garde-fous. La section 8C de la Constitution prévoit que la loi doit prévoir une compensation adéquate et un recours à la Cour suprême à la personne lésée. Mais que voyons-nous dans ce projet de loi? Section 29, sous-section 3, et je lis, et je cite. « The minister or the state shall not be liable to pay any compensation to a water use permit holder following the variation of any of the terms and conditions of a permit. » La loi est en train de dire qu'on peut varier les conditions de votre permis. Cela peut vous entraîner des dommages, vous pouvez avoir des pertes. Vous avez investi dans un projet en vous basant sur le permis que le ministre vous a donné, que vous allez pouvoir extraire un certain nombre d'eau. Le ministre, de façon unilatérale, décide de changer the rule of the game. Et vous n'avez pas de compensation. La loi le dit clairement, vous n'aurez aucune compensation. Donc, est-ce constitutionnel? Est-ce pas contre l'article 8C de la Constitution? Section 57. Nothing in this part shall be construed as giving rise to a right for compensation in respect of any decision or action that